if you want to use it. But the most efficient way is through Zoom, and you all should have the Zoom link. If you don't, we'll make sure you get it, and you can join the Zoom rooms. And then you just put your exhibits up that way.
Okay, thanks, Judge. Now, if I could just test it one time before we use it, because sometimes the audio plays and sometimes it does it some weird setting.
So during a break you can, but we are, now that we've got everyone here, we've got a lot of ground to cover, and our jurors are here.
Yes, Judge. And the deputy informed me that it's not possible just with him on his own to go get the close. So I was hoping if we could somehow facilitate someone else to get it, or
we can during a break.
Okay.
All right, let's get on the record, please, in State versus Parks and Phillips. It is Thursday, the 19th, a little after 9 o'clock, and we are ready in a moment to bring the jury out here. We have a few things we have to cover. The state had a motion seeking a ruling to be able to use an exhibit, which I think is that big board in its opening. It sounds like you all have resolved that. Is that correct, Mr. Greiner?
It's my understanding that we have.
Okay, no objection to the big board that is a map of the area, Mr. Menendez. It's a demonstrative aid.
Right. No, Your Honor, I was going to motion to use the same demonstrative at some point, so I have no objection.
Great. Mr. Rowe, no issue? Okay. Mr. Menendez filed a bunch of motions. I'm going to work through some of them right now. I'm going to start with the amended special demur. I am denying that on a couple grounds. One, I find that it's not timely. It's not really Mr. Menendez's fault, but special demurs are supposed to be filed way back near the time of the indictment, and Mr. Menendez wasn't on this case at that time. He points to his filing soon after he joined the case, which was an omnibus motion, which is forbidden in this division, where within a whole stack of papers, there was a generic special demur that he says is his placeholder. But I find that neither is timely. Setting aside timeliness and assuming that somehow on the eve of trial a special demur is timely, I deny it on the merits. I find that the possession of a firearm during commission of a felony count 6, does sufficiently put Mr. Phillips and frankly Mr. Parks as well on notice of what they're charged with, and that's that they had on or within their reach a handgun during the commission of at least one. The state doesn't need to specify. They made a list. Obviously, the state's going to try to prove all those because they are all predicate offenses in the indictment, but they only need to prove one, and that way we don't have to have 5 counts of possession of a firearm during commission of a felony, or however many it would be. So it is sufficiently specific. It is, in fact, the garden variety way in which possession of a firearm during commission of a felony is charged when there's more than one predicate felony. Count 3 alleges felony murder for criminal damage to property, and it adequately alleges the elements of felony murder. And that's that someone was shot with a firearm. It doesn't need to allege the elements of criminal damage to property because that's not the allegation. It's that in the process of committing criminal damage to property, the defendants committed felony murder in that they shot the decedent with a firearm. Count 5 correctly alleges criminal damage to property. It doesn't talk about shooting the victim with a firearm. It talks about shooting into a home. So I find that counts 3, 5, and 6 are all adequately pled. There is zero confusion as to what is alleged, and that Mr. Phillips and Mr. Park, should he choose to join the motion, are laboring under no disability or struggle as to what they need to do to defend against those allegations. We have a series of motions in limine, and I want to cover as many of them as we can. Mr. Greiner, the first relates to mug shots, or a mug shot that the state might use. Are you intending to use any mug shots of Mr. Phillips? I don't know if they're mug shots. I see a picture with someone's hand on it, but regardless, are you going to be using any pictures of Mr. Phillips that aren't captured in surveillance footage or whatnot? Because that's not what this is getting at.
Your Honor, I'd like to keep that door open, that possibility. Right now, I do not plan on
Okay.
showing any mug shots, and especially the one that is enumerated here in paragraph 1. So
What would the relevance of a photo, I'm gonna call it a pre-existing photo of Mr. Phillips? So it's not a photo that was generated through any activity at the crime scene. What would the relevance of a pre-existing photo be?
well, there may not be. I mean, I don't know what the defense is going to be yet. Both defendants have admitted to being there on the scene at the time that all this occurred, and also both have admitted to firing their guns at the time. But I don't know what defense may pop up, so
Okay.
I just want to keep that possibility open. But at this point,
So what I'll do right now is deny it as moot. But if you feel like the case is developing where you're going to need to use a pre-existing photo of Mr. Phillips, let's talk about that during a break so that Mr. Menendez can then articulate he's articulated his concerns. You can explain why you think you need it. My guess is it wouldn't be hard to overcome the 401 objection, and it's not going to be a 403. I won't be sustaining a 403 objection to the mugshot unless it says convicted of rape on the photo or something like that, which I suspect it doesn't. So we'll cross that bridge should we get to it. Sounds like we're not there.
If I could correct just one thing, the state is right about Mr. Parks getting an interview, which we addressed yesterday, but as far as I know, Mr. Phillips, when attempted to be interviewed, asked for an attorney. There was no statement by Mr. Phillips proposed as a.
Okay, you don't have to correct anything. Mr. Greiner was saying, I think the evidence is going to be X. It may not be X. I just focused right now on, are we going to be using a pre-existing photo? It sounds like we won't, but we might, and we'll talk about it should that occur.
just to be clear, I used the word statement, but he provided testimony in the immunity here. That's what I was talking
Got
about.
it, and that's out there.
Right, but not part of the state's case in chief though, or in the certificate of discovery anyway.
Okay, we'll cross that bridge when we get to it. Testimony is testimony, sworn statements.
Motion eliminate about that, if it's gonna come in that.
All right, when I get a motion eliminate from you about that, we'll work on it. The second one seeks to exclude any reference to a rash of shootings or an ongoing dispute in the neighborhood, which I assume means the Notting Hill neighborhood. Is that something you intend to elicit from any witness?
Yes, Your Honor.
Okay, and tell me the relevance of that.
The relevance is that there are these two houses. I can actually use this map to explain. So 4215 is here. There's a family that lives here with children. 4228 is down here. This is where defendant Parks lived with his mother. There's a brother, and there's some other children down in this area too. The deceased victim lived next door in 4226. Okay, so there was a fight that developed between kids months before, 6 and 7 years old.
6 and 7 year old kids, or the fight was 6 years old?
6 and 7 year old children.
Okay.
Got into a fight. And after that fight, they each went home. Well, then there arose a dispute between the adults after that point. Actually, there were individuals that came to 4215, I'll say in a heavy-handed way. And following that confrontation, ugly confrontation that occurred, 4215 would occasionally get shot. There would be bullets that would actually be shot at 4215. Sometimes the rounds would miss 4215 and hit 4217, the next door neighbor. This occurred over a period of months.
Leading up to this situation.
Correct, which occurred on September 13th, 2021. So about 9-10 months.
Okay, and do you seek to attribute any of the shootings leading up to the one we're here for to either Mr. Phillips or Mr. Parks?
No.
Okay, Mr. Menendez, tell me why that shouldn't come in. How is that? First of all, it's not 404B if it's not being attributed to your client. It sure seems relevant. How is it unduly prejudicial?
Well, Your Honor, if the way the state just put it, it's not unduly prejudicial. It's exactly as the Honorable Court stated, to imply that my client has ever shot up that house or shot up any house or been involved in any shooting besides the one that killed the deceased, I think would be improper under 404B.
That would be 404B.
Right.
Okay. All right. Well, I think the way you intend to present it, I don't know if he's withdrawing the motion. I'm denying the motion in limine, and you're certainly free to do that. If you've got witnesses where you're a little nervous that they might say, and these guys were the ones shooting up one of those places, you'll need to let us know so you can either give direction to that witness, but that would be problematic if in the middle of the trial someone blurts out, yeah, and I know who was shooting up 4215. It was that guy.
Let me be clear then, okay? Because there's a third individual out there with guns shooting the day of the murder. And that third individual's grandmother lived back here in one of these buildings, back over here, one of these buildings back here. And so the resident of 4215 did have conversations with neighbors around about this shooting, okay?
About the shootings, the prior, or this one that we're here for?
Prior.
Okay.
And 4215, that resident or the residents believed very strongly that these two were involved. And there were police reports made, okay? But I don't anticipate them to say, I saw Defendant Parks or I saw Defendant Phillips out here.
Well, I'm not trying to be so narrow as I saw them. If people are going to be testifying, hey, I have a hunch or I speculate, one, that's not permissible because they're speculating. But were you intending to elicit testimony from any of what I'll call the neighborhood witnesses that, hey, we know, we heard on the street, we had a sneaking suspicion that Parks and Phillips were the ones shooting up that house?
I can't predict the future.
Well, you know what you're going to ask, and you need to tell your witnesses not to say something like that, because it could be 404B. It wasn't noticed as such. If it's hearsay, then it shouldn't come in that way. And that's a harder one to unring than, oh, I heard that Mr. Phillips wears a blue shirt. Okay, that's hearsay, object, disregard that he wore a blue shirt. But I heard he was the one shooting up 4215. I suspect I'll get more than an objection to hearsay if a witness says that. So I'm cautioning you to caution your witnesses not to speculate or anything like that. If it was concrete, I suspect you would have, or a colleague of yours would have filed a 404B notice that, you know what, we're going to get in evidence that 6 months earlier, Mr. Phillips or Mr. Parks got arrested, or there was a 911 call where someone said that kid from the Parks household is shooting up the house again. And I'm not hearing you say you have anything that rises to that level of certainty.
That's correct. I do not have anything like that. I will speak with the witnesses again. If there's an issue, I'll bring it to the court's attention. I do think, though, that they do strongly suspect these two defendants of being involved.
Sure.
I think that they may say something like, you know, these two guys are around, there's trouble, you know, something like that. But yeah, I will.
Yeah, so don't go there. I don't know how that would be permissible. Their theories about culpability or dangerousness, unless it plays into, hey, have people been telling you shouldn't testify? And why would you be worried about someone else telling you that? Well, because, hey, look who we're dealing with. But they've opened that door through their family members and friends who have been harassing potential witnesses, if that's how it plays out. So we'll work through that. So my ruling on motion eliminate 2 is nothing wrong with getting in evidence about the rash of shootings and the disputes, and that it started with 6-year-olds in a fight and it escalated to houses getting shot up. But unless you've got someone who can say, I saw Parks or Phillips shoot it up, you shouldn't go there. And if you've got that witness, that's really 404B, and neither defendant was put on notice for that. Number 3 relates to weed and Mr. Phillips possessing or selling marijuana. Do you intend on exploring that with anyone, Mr. Greiner?
only insofar as Mr. Phillips said that part of the reason why he went over to,
He said this in the immunity hearing?
the immunity hearing, part of the reason why he was over here was to smoke weed. And that they had been smoking somewhere else, and then they came here and they were over here to smoke weed.
Oh, because he's not from this neighborhood. It's Parks who's in this neighborhood. Phillips is a visitor.
Well, Phillips has a relative back over here somewhere.
Okay.
But Phillips gave two different, locations for his residence during this statement.
His statement meaning his testimony at the immunity hearing.
Yes, sir.
Okay.
His testimony. He said he lives somewhere here on County Line Road, and then also there's a grandmother or something that he stays back with over there.
But the extent of weed testimony would be from Mr. Phillips's own mouth. Hey, I was in the neighborhood at the time of the shooting because I went to visit Parks to smoke some weed.
Something like that.
Okay, not, hey, we know he's a marijuana dealer, and so that would mean he has a gun and he's dangerous or anything like that. Okay, Mr. Menendez?
That's satisfying, Your Honor. There are parts of the state's proposed discovery that some witnesses say that they think he smokes or sells weed or possesses weed. But I understand that's been excluded. And, if that immunity transcript comes in by impeachment of Mr. Phillips testifying, then obviously it's intrinsic. I agree with the court on that. But I do have an extensive brief prepared. I just have to polish it up about why the immunity hearing is not permissible under some constitutional grounds as part of the case in chief without Mr. Phillips testifying.
So sooner would be better on that since the immunity hearing was a while ago.
Yes, Judge. I didn't think that was going to come up because it's not part of the state's discovery within 10 days of trial. So I left it be, but I'll address that just in case.
I'm not quite sure what the state would provide in discovery. It was a hearing, so it's actually a court record. I don't know if there's a transcript in the docket. I think there is. So I'm not sure what discovery obligation the state has, given that the official record would be a publicly available document, i.e. the transcript.
Your Honor, I have to include that in my brief as well. I don't have it off the top of my head, but there is case law that says even if the defense is aware of something, if it's not part of the ready announcement and the final discovery, then they have a right to prepare their defense on that presentation and announcement, regardless of if they know about something.
Got it. So my counsel to you would be don't spend much more time writing on that because that's not a winning argument. I'm intrigued about the state can't use immunity information in its case in chief, but a transcript of a proceeding is something that you're expected to have and know and rely on, and no one needs to give you notice that they're going to rely on it. Number 4 is.
I apologize.
That's okay.
May I just clarify one point? Just so we're all clear, the state does intend on having those parts of that immunity hearing read into the record, redacting the parts that mention Mr. Parks, the co-defendant. So the state is intending on
In your case in chief.
In my case in chief.
Okay, so don't do that early on in the case. So Mr. Menendez has a chance, and it will need to be before he goes to bed tonight to get to all of us his arguments as to why that shouldn't happen.
Yes, Your Honor.
Okay.
Yes, Your Honor.
But thank you for clarifying. That's a very real issue then, and I'll need to consider Mr. Menendez's arguments as to why you shouldn't be able to do that, but you do intend to do that.
I do, and I have redacted those parts that mention Mr. Parks.
Sure.
Co-defendant, and so I would just like to have my colleagues review that redaction before we get into the actual reading of it.
Okay, was that on the thumb drive you gave them as well, or that was merely Mr. Parks's statement to law enforcement?
I believe that what was on the thumb drive was only Mr. Parks's statement.
Okay.
So what I have done is I have printed out the transcript, which is a part of the court's record.
Yep.
And I've gone through and scratched through, and so I will hand that physical copy to my colleagues.
Great.
And have a look.
Okay, thank you. Motion eliminate number 4, exclude any reference to police officers recognizing Mr. Phillips, which would suggest they had had contact with him before. Now, it could mean that he was at an at-promise center and they were just hanging out and having a good time, but it could mean that they'd arrested him before. Do you intend, Mr. Greiner, on eliciting any testimony from any law enforcement officer of, oh yeah, that's Mr. Phillips. I know him. I deal with him all the time.
Your Honor, I don't think I'll need to. Right now, I do not anticipate needing to do that.
Okay, sort of like the mugshot. You may need to go there depending on what the defense is. If you pivot and feel like you need to, flag it before you do it. So Mr. Menendez and you and I can talk about that. That's a little more problematic than the mugshot, but I'm familiar with case law that would say that can happen. It just needs to be pretty neutral. Like, well, I recognized Mr. Phillips from a previous interaction, but not, that's when I arrested him for X, Y, and Z. You're gonna win that argument if you need to go there, I suspect, but I want to give Mr. Menendez an opportunity to more fully make the argument. But for now, it seems like it's moot.
Yes, Judge, it's the latter that I'm worried about, that it was any part of criminal investigation or
Right.
suspicion or
Right.
arrest.
Right. Number 5 seeks to exclude the entire extraction of someone's phone, claiming it's not relevant. Are you going to be using anything, Mr. Greiner, that was extracted from Mr. Phillips's phone?
Right now, I don't intend to get much into that, but again, I don't know what the defense is going to present.
Okay, this was a phone found on Mr. Phillips when he was arrested?
No, Your Honor, there's a phone that was left behind at one of the 2 crime scenes.
And what associates it with Mr. Phillips? Or it doesn't, it's just a phone that was left behind?
I'd be interested to hear my colleague's argument on why it relates to this client.
Well, that might be why he says it's not relevant, because it can't show it's his phone. And so why would something on a random phone come in a case against his client? Which may be why you're not planning on using it.
We'll have to see where we go, but right now, I don't plan on using it.
We'll table that one as well. Just like with these other things, mugshot and prior law enforcement encounters, if you need to go in that direction, let's make sure we talk about it first.
Your Honor, to briefly address one of the court's thoughts just now, Detective Thorpe in his report says that, and someone else says that they suspect that that phone was dropped there by Mr. Phillips during the shooting.
Okay, but if we're not getting into its contents, then if someone's doing a crime scene, well, that's a phone that someone dropped. I guess that's where it would need to end.
For whatever reason, they connect it to him, but they don't say it in their report. So I guess that'll.
Okay. Number 6, video evidence that shows Mr. Phillips running from the scene of the deceased, shooting a gun. I don't think that's 404B, so I'm not sure. I think that's the right objection. I guess I'm curious how it's not relevant, and sure, it's not real helpful for Mr. Phillips, but what would the basis be to exclude video evidence showing your client fleeing the scene of a murder, shooting a gun?
Right, Your Honor, because it's shooting much farther away than this court might suspect.
Ballpark, how many seconds after the shooting would this be?
Maybe 12.
Okay.
I mean, that's totally.
I understand, but less than a minute. We're talking about something that's less than a minute later. How is that not inextricably intertwined with the situation we're here for?
Well, there's nothing in discovery that says that's any kind of aggravated assault against Mr. Arnold, the deceased, or the felony murder.
If it shows what you think it shows, and who knows how clearly it shows Mr. Phillips, it puts Mr. Phillips at or near the scene with a gun, firing a gun after someone was shot and killed. It's coming in.
Okay.
Number 7 is body cam footage depicting the arrest of Mr. Phillips. Do you plan on playing that, Mr. Greiner?
At this point, I do not.
Okay, if you change your mind, let's talk about it.
Yes, Your Honor.
Autopsy photos. I tend to agree with Mr. Menendez on this one. He's not saying no photos. He's saying the generic one, here's the deceased on a table so that whichever ME you're using can say, here's how we process a body, and here's the number, the accession number, et cetera. The fatal wound to the neck, I mean, that's really the photo we need. Cause of death doesn't seem to be an issue. the defense could almost stipulate away the ME. They can't legally, but I bet they wish you wouldn't call an ME and they'd say he was killed by the fatal shot to the neck. This seems like a case where you need precious few autopsy photos. Would you agree?
I agree. I may need more than just one or two, but I'm not gonna put in the 70 or so that they took.
Let's do this. When it's time and you're getting ready for the ME, share with the defense attorneys the photos you're going to use, and then let's revisit this. I'm hearing Mr. Greiner being fairly aligned with the notion that this is not a case where we need 30 autopsy photos because we're not having to figure out, well, wait, was this a shot into the back? And so it's not self-defense, or what was the angle because the shooter is so much taller than the deceased? Cause of death is not an issue. I'd be shocked if the defense attorneys ask many questions other than, you can't tell who shot this man, can you? And that's it.
Actually, I think that part of the defense may have to do with the direction of the bullet into the deceased. And so they need be more than, 5 or 6.
Okay.
But
if they're concentrated around the injury as opposed to, and let's, and he fell and he scraped his knee and here's a picture of him with no underpants on, those seem to be more gratuitous than essential to the state clarifying its theory of the case. And certainly the defense can use other photos if they want. This was a motion to say, let's use fewer. But I feel like you are aligned with the general principle. And so let's do what I said, which is before the ME testifies, here are the 2, 5, 7, however many pictures you're going to use. And then the 2 defense attorneys can say, we think that pictures 9 and 12 are cumulative. I can rule real quickly. Jurors don't even need to leave the room for that.
yes, Your Honor.
Great. That is it for the motions in limine. There was late discovery. Tell me what your concern is. Well, there's allegedly late discovery. I made a ruling on that. What was your concern there?
Your Honor, I have huge concerns about that. As the court knows, this was specially set back in April. I got on the case. I assured the court that I would thoroughly prepare and that I would be prepared, which I was on September 5th when the state made their ready announcement. The thing is, the state had this in possession all along. Under Baker v. State, while they might say that the state themselves didn't have it in their hands, but if you review Baker v. State.
Tell me what the discovery is that you think is being provided late.
Your Honor, it's a different angle of the shooting that we just talked about, the running away one.
It's surveillance footage?
From a house. Yes. Okay,
so it's not body cam, it's not law enforcement generated, it is law enforcement acquired.
Right.
But that's just what we're talking about.
Yes, Judge.
Okay.
My understanding, there wasn't much detail. It was just emailed to me.
Okay.
Through Dropbox. Dropbox link was emailed and downloaded from that. It was from a civilian created video, I presume, from a house. And it just shows a different angle of the same shooting away that the court just deemed admissible. And what that does is it shows Mr. Phillips getting into the car with Mr. Parks and with this unknown person, G, and driving off.
Okay.
And
let me find out from Mr. Greiner how the state got it and when they got it. And then I'll be in a better position to say that's not okay, or hey, this is when you got it and you handed it over. Mr. Greiner, are you familiar with the video to which Mr. Monetis is referring?
Yes, Your Honor. So the day that I served, whatever day that was, I went and I met with the witness here at 4217 because she has a video camera. My intention was for her to review the video footage and then do the initials so we would be prepared for that. And she
video footage you already had. You were showing her some video footage you had and the defense already had. Right. Ma'am, could you review this, initial it, so her test, she can lay the foundation?
Right.
Okay.
She started talking about the video and where the car was parked. And I said, what are you talking about? And so then she showed me a video that came from, I believe it's this house here, 4214, that had been emailed out to the homeowners association. So I assumed that Ms. Carrie Henderson, being the resident of this area, she still was at the time, just within days of the murder, she would have gotten the same video. At any rate, It took some doing, but I was able to get it off of that witness's phone and onto my computer, got back to my office and immediately served it on my colleague.
Okay, thank you. Mr. Monetis, this seems like the classic, I just got it, not from law enforcement, not from the FBI, not the, hey, because the GBI has it, it's really within the state span of control. Private citizens, and I'm less focused on, gosh, Mr. Rowe's client's mom should have had it and shared it. Maybe so. That's not really what's at play here. But he basically stumbled across it, Mr. Greiner, and immediately got it to you. So it's not late being delivered, it's late being discovered. Tell me how you are prejudiced by, when did you get it? How many days ago?
I got it on September 9th, 9 days before trial.
Okay, so you've had it for 10 days.
Yeah.
Tell me so it hadn't been used yet, so you will have had it for at least 10 days before it gets used. What's the prejudice? What have you not been able to do that if the state had managed to stumble across this private evidence a month ago and then done exactly what Mr. Greiner did, which is immediately get it to you and Mr. Rowe, what would be different if you had it for 3 weeks instead of 10 days?
Yes, sir. Two things would be different. On September 5th, I was prepared as ordered by the court for the specially set trial where Mr. Phillips has been incarcerated for 3 years, waiting for this trial. I was prepared, and I was prepared with a mere presence and mere association defense. Now, had I had that video before, I might almost, I really highly likely would have prepared a justification defense instead. And of course, I'm familiar with the case law and the rules about that, but I hadn't investigated any prior difficulties or canvassed the neighborhood or called witnesses that might be prior difficulties or talked to people that might have seen this video or anything. I was saying, well, he didn't shoot, he just was there. That's that. But now we had a video that more suggests him as a party. It shows him getting into the car with Mr. Parks, who the state is, who my understanding is going to raise a justification defense, or it's my guess as a practitioner having to read the discovery. And so that's that, Judge Your Honor. I'm not prepared for a justification defense for Mr. Phillips, and I was prepared for what I relied on.
Well, I'm sympathetic in that this came a little bit later. You and your client have had the privileged conversations you've had. He shared with you what he shared with you, and you built a defense based on what you felt were the limitations in the state's evidence. And providentially, not through anyone's misconduct, no bad faith from the state at all, other evidence has come to light. The state promptly shared it. They're entitled to use it. And you, being the professional you are with the experience you have, are going to be able to adapt. And you've actually had 10 days to be retooling, should you choose to retool, what you were going to do, and either had a heart-to-heart with your client saying, gosh, this is news to me, or this is going to be more problematic and we're going to have to put up a different front. So I hear you, but I don't find that there was any bad faith by the state at all. In fact, they complied to the letter of the law in meeting their ongoing obligation to provide discovery. And we've actually had more than enough time for you to retool your defense if that's what you elect to do. So I'm not going to exclude that late discovery. Was there also some FBI, or did you cut and paste your motion?
No, there was, Judge. Could I just real briefly, to perfect the record on that, add that Your Honor is correct. I'm capable of improvising and retooling within 10 days, but I'm not capable of fully investigating, both because of money and time and me having to prepare. Those 3 reasons I can't prepare in 10 days to retool for this specific scenario. And I also can't prepare to retool for having my own expert, which I would have done, examine the work of the state's ballistics expert, because I was planned to defend and say, none of those shell casings came from Mr. Parks. From Mr. Phillips. And there's it's so hard to get an expert these days and so expensive, and no one's going to do it on short notice like that and arrange travel and all of that. So those are the 2 ways that he'd be prejudiced, and a continuance would prejudice him because he's locked up with no bond for 3 years. And as far as
So you're not asking for a continuance, just so we're clear.
well, if the state's not going to exclude it, I would take what I could get. But I'm asking to exclude it, and I also under Baker v. State Judge, which is 238 Georgia Ave 285. It's a 1999 case. It kind of highlights that bad faith is more of a term of art in this scenario. It's not the way you would commonly use the word bad faith as a layperson. It doesn't need misconduct or malice or conspiracy. It's just non-compliance when they had it or had one of their agents having it.
Right, but you're not suggesting that neighbor X from the Notting Hill Drive neighborhood is an agent of the state?
I'm not, Your Honor, but ethically, I do have to contest the proffer of the state that they just put before the court unless they're going to remove themselves from the case and become a material witness to talk about what they just proffered. Ethically, I do think Mr. Phillips has a right, at least outside of the jury's presence, to have some kind of evidentiary hearing that what the state just proffered is actually true.
Well, one, they may well call as a witness the nice woman, man who said, well, wait, no, there's this other video, and you get that. But the way courts consistently handle discovery disputes is we have the officers of the court, the lawyers, explain what they got, when they got it, et cetera. I have no reason to doubt Mr. Griner's recitation. So I find that there has been no bad faith. I appreciate Baker's kind of an old case. There have been many more cases since then, emphasizing the fairly high hurdle that a court has to clear in finding bad faith. I have a next door neighbor who has routinely excluded discovery and has been reversed a number of times because maybe that judge is living with the Baker definition of bad faith and not how our Supreme Court is defining it now. But either way, we're miles away from any bad faith, given my understanding of this situation. And I appreciate how you feel about it. You are out of time discussing that. And I'm ready to pivot to bringing in our two jurors who want to talk. Do you mind, Mr. Griner, taking that down?
And Your Honor, we'll do the other motions at a separate.
We will.
Okay.
So let's start with Mr. Head, please. We'll go in numerical order. Good morning, sir.
Good morning.
Deputy Gordon, you're juror 13.
Yes.
And we spent time together yesterday. You were selected to serve. And Deputy Gordon said there was something that you wanted to talk to us about.
Yes, I want to speak to you personally in the chambers.
Okay. So does it relate to your ability or willingness to serve?
Yes.
That's usually not a conversation. That's just judge and juror. So I'm not going to have you get too much on the record. But if you could at least let me get more of my notes on you. So we had talked about the possible hardship you had. And my recollection is you had said, you know what? As long as I get plugged in, it's not going to be an issue that it may be that you aren't picking up your younger son at 3 or 3:30. I think you said there's a relative who could do it, and it might even be that the mother could be involved or whatnot. But you assured us, which is one reason why we deemed you to be a very eligible juror, that that was a manageable situation.
Right.
Is it something different that you want to talk about?
Yes, different.
Okay. I will talk with you in a minute about that.
Okay.
Okay? All right. If we could bring juror 14 out. Oh, while we're waiting, let me get this on the record. Juror 10, Ms. Reddick, the mediator, called and sent an email this morning. She was diagnosed with bronchitis last week. Getting to the courthouse, the walking involved, and the cold temperatures in the building affected me adversely. You can take a seat. I will be seeing my doctor today. I will not be able to participate as scheduled. I'm happy to provide you with documentation from my medical visits. I spoke with her directly before I came out here, expressing my disappointment and displeasure that she did not share more with us. What she said yesterday was, "It's cold in here." And that was it. Not, I'm gonna have trouble serving or anything like that. But she's not coming down here. So juror 10 has been excused. Anything you want to get on the record in connection with that, Mr. Griner?
No, Your Honor.
Mr. Menettis?
No, Your Honor.
Okay, Mr. Rowe?
Okay.
All right, sir, you are juror 14, and Deputy Gordon said you wanted to talk.
Yes. That you know, I'm not really mentally able to stay focused on this right here because I'm going through some things.
Like what?
As far as, well, you know, I said me and my wife, we married, but we kind of like going through a divorce. So I'm not able to wrap my head around to stay focused on a lot of stuff right now.
So why didn't you share that with us yesterday as we were talking to you about your ability to serve and what's going on in your life?
Well, that's what I was trying to explain yesterday when I was saying I was thinking that I might be able to do it, and you know, it's just not capable right now.
Tell me what you mean by not capable. Like, we're having a conversation. You're understanding what I'm saying.
But you know, while me and my wife going through what we going through, it's like that. I've been having to like sleep in my car, you know, haven't really had good rest and everything. So that's kind of taking like a burden on me. And my daughter, she is kind of going through something herself, you know. She her grandfather passed, so I've been trying to like kind of help her through that. And she's, you know, going through counseling and stuff like that. So it's kind of hard for me to, you know, kind of stay focused.
Okay. Your daughter is the Delta person or the CDL, the trucker?
No, my daughter, she's a
receptionist? Receptionist. Okay.
Glad she's a nurse too, so she's
Okay.
kind of taking care of her grandfather.
Got it.
So I kind of hit her hard.
Does she live around here?
She lives in Cobb County.
Cobb County.
Hospital, yes.
Okay. Is that a place you can stay?
No, she lives with her mother.
Okay.
So,
Oh, yeah, you can't stay there.
yeah.
Okay. Got it. You have several other adult kids, someone at I guess some of them were your wife's kids.
Three oldest ones, my wife's.
Okay, and then the youngest is your kid who lives with her mother. Okay, all right. Mr. Griner, do you have any questions for juror 14?
I do not have any questions.
Mr. Menettis?
No, Your Honor, I do hate to hear that, and if you were still commanded by the judge to serve, would you still do your best?
I don't want to say yes to that, you know. No, I can't.
So, well, I don't know what "no, you can't" means. The question was, if we end up deciding that this is what you're doing, you're not gonna, you can't walk out of the room, but you'll give us your best. You've explained that you think it will be difficult to focus, but okay, I'll add two varies in front of it. It could be very, very difficult. But if the decision is you're staying, it sounds like you will still participate. You're just explaining to us that you've got distractions that will make it harder for you to focus than maybe someone else in the group. Okay. Mr. Rowe, do you have any questions for juror 14?
You haven't been diagnosed with depression or anything like that?
No.
All right. I'm sure you're not excited right now. Life is complicated for all of us. All right, thank you for sharing that. I'm gonna have you go back to the jury room. So I'm going to go speak with Mr. Head in my office. Then I'll get him back in the jury room and I will report back to all of you what Mr. Head and I talked about. I will tell you that I'm not inclined to excuse juror 14. And we'll need to hear what Mr. Head says. But we're already down one, thanks to our mediator deciding she wasn't able to come in today. So unless everyone agrees that we can go with 11, I'm going to cling pretty hard to our remaining jurors. I am open to the notion, and you should consider it, of doing a rotation. They don't know who's who, and having juror 14 be our alternate. We already have one alternate who's become a regular juror. We have both our alternates become regular jurors, and 14 is our alternate. Talk amongst yourselves about that. I need to go meet with Mr. Head, if you could bring him back.
This order, is it on in all, or is it? It's not, it's one, it's just the original used. You just guys, just like Marty's photo. Oh, so they have to come and do something to that. Okay. So I need you guys to come back and do something.
Yeah. Right. Yeah. That should be. Use the chair.
All right, let's get back on the record in State versus Parks and Phillips. I met with juror 13. I'm gonna bring him out here so you all can engage with him on an issue that he raised, which is he has two sons who I think work with him, but he said last night as he was thinking about it more and his sons and some of the struggles they've had, he worries that he might, this is sort of a la the juror who wore the 49ers jacket. I see my sons in that situation and I just need to let you guys know that I may wrestle with that a little bit. And I told him it's perfectly natural in the same way that a juror might wrestle with the deceased looks like my dad or something like that. But I wanted to give the lawyers an opportunity to engage with juror 13. It doesn't sound like it's something that rises to the level of us needing to change anything at all that we're doing. But let's bring juror 13 out so you can chat with them should you want to. Good morning, juror 13. I shared with the lawyers what you shared with me about how last night, as you were reflecting more on your life and you're the young sons who I think work with you in your business, you began to struggle a little bit with well, wait a minute, how neutral am I as I think about the defendants and your sons? But I want to make sure the lawyers could engage with you like I did to see if there's anything more they want to learn. Mr. Greiner, I'll start with you. Do you have any questions for Mr. Head about what I shared with you?
Sir, you have two sons, one is 16, one is 17.
Yes.
And do they Are they in school?
Yes, one is at, McKeachman, the other one's at Landmark Christian.
They doing pretty well.
Yes,
Do they play sports and things like that? Are they active?
they don't play, sports, but they are, active as far as going to the activities at school, you know, football. They're at their age now where they want to hang out, go to football games, things of that nature.
You want to be where the girls are at the football game as opposed to the stinky guys in pads.
Okay. And I mean, clearly, we're talking about different people, older. Do these two resemble your family in any way?
But honestly, we get, a lot of guys that come to our shop, looking for second chance.
Oh, the question was different. Do your sons in any way resemble either of the defendants? You look at one of them and say, gosh, that's my 16-year-old.
I mean, I can say as far as, race, yes. I just see, I see two young men, and I saw the thing about my boys. Sure, you know, I understand that, you know, we all make mistakes. I made mistakes. I didn't get this far without race. I know we're not in charge of the sentencing part, but I understand that when you get charged with murder, you typically know what that means. And you know, I don't know the circumstances, but I just see two young men that from the community that I'm from. You know, I just don't know if I can be 100% non-biased.
And what we talked about, Mr. Greiner, was that there's a difference between being biased and maybe having empathy or sympathy going in, and that in the same way people may start to develop that with the family of the deceased as they learn a little bit about that. And that's a natural human emotion, but ultimately I'll be giving an instruction to the jurors that those natural feelings need to be set aside when it comes to evaluating the evidence. Did the state meet its burden or not?
You can do that, so.
I'll try my best.
Thank you.
Okay.
Yeah, I don't have any other questions.
Mr. Monetis, any questions for juror 13?
Yes, just a couple. Good morning, sir. Good morning. Thanks for sharing that with us. When you talked about second chances, and then you talked about Mr. Phillips, my client, being racially similar to your children, you didn't mean that to say that you already presumed that he's done anything wrong?
No.
Okay. And so if the judge instructs you on the presumption of innocence and the proof of the state, you can follow that?
Yes.
Okay. And so right now, having not seen any of the evidence, you don't have any reason to think he's done anything wrong ever?
Correct.
Those are my questions.
Mr. Rowe, anything else for juror 13?
And would that be the same for my client, Mr.
Yes.
Park as well?
Yes.
Okay, sir, I very much appreciate your candor. You're wrestling with very natural things, and a lot of folks do that when they get called to serve in this way. I'm gonna have you go back with the group. I appreciate your time. So someday we'll start the trial. I need to know if you all discussed having juror 14, Mr. Middlebrooks, become our alternate. Well, let me take a step back. I don't believe juror 13 needs to be excused on the basis of that. Mr. Greiner, do you agree?
I do.
Okay, Mr. Monetis?
I agree as well, Your Honor.
And Mr. Rowe?
I agree.
Okay, he stays. I'm not inclined to excuse juror 14 either. I heard what he said, but he's here and I think he should stay here. But I'm open to having him become the alternate. Mr. Greiner, do you have a perspective on either of those questions? Should he be excused? Should he be the alternate?
I don't think he should be excused. I agree with the court on that. And I also agree that he should probably become the alternate. He said that he may have difficulty focusing. Perhaps there's somebody else who can stay better focused.
Mr. Menettis?
I second that.
Okay, Mr. Rowe?
I agree with that.
Unanimity. All right, then, we don't need to say anything to anyone. We understand the situation. And then I suspect we'll hear from Mr. Middlebrooks again tomorrow, and we'll work through that, as the days progress. Anything else, Mr. Griner? Well, let me say this. In a moment, I'm going to bring the jurors in. I will swear them in, and then I will give them some basic operating instructions and repeat the burden of proof and the presumption of innocence, all that kind of stuff. Takes about 15, 20 minutes. And then you'll be up for opening, whichever one of you is given opening. Anything we need to sort out before I do that?
I just want to make sure that I will be able to put PowerPoint up on the screen.
Oh, something wasn't working over there. Was it the bigger screen?
Yes.
Okay,
So,
I'm looking at your emails, so, looks like you're shareable.
like that.
While you're figuring that out, Mr. Menettis, anything else on behalf of Mr. Phillips?
Just around, yeah, the court had generously allowed me to tamper with, not tamper. Tinker with the court's technology to make sure that the audio is in order, because I just want to play one audio during my opening.
Okay,
And then I also wanted to, we didn't get to the component of my motion to exclude about the FBI and the ballistics part, which is interrelated with my motion to inspect the physical evidence in the case, which I had requested a few times well outside the 10-day window, but haven't gotten a response. I just wanted to make sure, could we hold off on that testimony today, since it's going to be several days anyway, so that I kind of have a chance to physically review that. It's pretty sophisticated scientific stuff, and
so maybe there was something special done. I'm pretty familiar with ballistics work, and the marks that they look at on shell casings and on projectiles. Is that what you're referring to as the sophisticated science, or is there something different going on?
well, Your Honor, that and chain of custody packaging and getting to actually see what they photographed in discovery, which was provided only 2 days before trial, which I'm going to argue at the court's convenience, similar to the other motion, being a state actor this time.
What do you mean what they photographed? How about this? Stop. Are you going to be talking in your opening, Mr. Griner, about ballistics?
I may mention it, but not get into too many details. I think that what my colleague is referring to is that, some months ago or maybe a year ago, we had an expert witness who reviewed the ballistics evidence in the case. There are 33 pieces of evidence, or 32 something, and provided it, created a report, and we served that on the defense. And so, time has gone by, and that particular expert had some issues in his personal life. So now, as we are advancing closer to trial, I contacted that witness and I asked him for some particularities about, the details about the evidence. And I said, well, just send me everything you got, your notes and all that stuff. So he sent me his notes. I mean, these are things that he hand wrote.
Okay, I'm going to stop you as well because we're starting. You're not going to be talking about that in your opening.
Not the notes and all the other
Okay, and before lunch, are we getting into any witnesses who have anything to do with ballistics?
No.
Okay,
witnesses.
then we're good. Mr. Rowe, anything before we bring the jurors in?
Okay.
All right,
Judge Matt, will the court allow me to talk about the ballistics evidence?
sure. You may talk about the ballistics evidence. It sounds like you're not going to be presenting the notes of Mr. Jarvis or anything like that.
No, Your Honor. And-
Okay.
and for what it's worth, as soon as I got those notes, within minutes, sent to those.
I understand. It's a different thing though, and we'll work through it. I'm understanding Mr. Menettis' concern, and we'll work through that. We're not doing that right now. Let's bring the jurors in.
Last thing, Your Honor, the Parks interview, I reviewed it this morning, it's 46 minutes.
You can bring the jurors in.
That's some proposed additional redactions, so if we can hold off on that too,
We'll see.
or at least recess.
Your Honor, we'd like to vote for rule sequestration.
Okay. Any potential witnesses here?
No, Judge.
Okay.
There is for me, Your Honor, you just go tell her. Ms. Frida Gates has sent out a report to the
I don't remember seeing a witness list from you.
Yeah, that goes into some unavailability of the state's witness and her having a recording of that unavailable witness.
It goes into a late provided discovery from the defense.
Well, similar to the civilian thing we talked about with the video, I talked to a witness who told me about a recording. I talked to the witness that had the recording. They needed to repair their phone to get it. I told them, could you please do that? They did. They gave it to me. I've given it immediately to the state.
But what about a witness list? Like, I haven't seen a witness list.
He wasn't a needed witness list because I was gonna call Ms. Shonda Blakeney, who I've had an investigator exhaustively looking for. And I'm gonna present that to the court, all his efforts, which have been fruitless. And then because of that, I now need Ms. Gates. I didn't need her before.
Okay, and when was I gonna learn that you had witnesses?
Well, Your Honor, when during these motions that we're taking them.
It's just goose and gander. If you've got information that you want to use, you need to disclose that. I don't have I got a witness list from Mr. Rowe, got a witness list from the state. The only person who had to excuse a witness from the courtroom was you. I don't have a witness list from you. So if you want to try to get traction with the, hey, I'm not getting things from the other side, you need to be providing what you've got.
No, it's not that, Your Honor. It's that my investigator can't locate one of the state's witnesses that is the primary.
I heard what you said, but the young lady who you sent outside is someone who you said would be a witness for you, which was remarkable to me because I don't have a witness list from you. End of discussion.
Yes, you will have one.
Okay.
She presented the necessary hearsay based on availability, which I didn't need before the witness was known available.
Your Honor, before they come in, just so that we're clear on this issue, I received this morning from Mr. Menendez, an envelope with, I think what he's referring to, something from a Miss Frida Gates. I don't know what this is.
Okay. Oh, okay. Is the monitor up here on? Great.
All rise for the jury. President of California.
Everyone else can be seated. Good morning, ladies and gentlemen. Bet you wondered if we were ever going to bring you out here. Why'd you make us come down today? Getting started with a trial is always a little complicated. There are legal issues that come up at the last minute. We have two defendants instead of one, so there are two of everything instead of one of everything. We've got a prosecution. We had a couple jurors I needed to chat with, so I'm sorry you were here on time. And we weren't able to start right away. We generally try to do work that doesn't require your involvement during your lunch break, after you leave, or we get started early in the morning. But that start up before you can start receiving evidence, there are often a few hiccups, and we had some of those. We've worked through them. You've now experienced your new home away from home. That's the jury room. That's your space. That refrigerator has bottled water in there. That's for you. That little Goldilocks basket full of snacks, those are your snacks. If something runs low or runs out, let Deputy Gordon know. I don't know if Ms. Hansberry's here today. You haven't met her. She's going to be helpful. If you need anything replenished, I think there's a coffee maker. That's for you also. That's your area, your whiteboard, all that kind of stuff. When you report each day, you report to the jury room, and we don't bring you out here until all 13 of you are here and everyone is ready to go. I'm going to give you another oath in just a moment. Yesterday, you took the potential juror oath. Today, you're going to take the I'm a real juror oath, and then we'll get started. A few other operating instructions. We will typically go from 9 to 5. I love to start as close to 9 as possible. We cannot start unless all of you are here. So if one of you is running late, we'll circulate that name and phone number so we can all call that person saying, where are you? If we haven't done it yet, we need to put up on the board in there the number for my office so you can call if you're stuck. Because if you're running late, but you're okay, we just need that phone call. Hey, I'm on I-20. Traffic happens. But if we're not hearing from you and it's 8:50, it's 8:55, we start working your numbers and your email, we get worried. So do your best to be on time like you did today. We take regular breaks. In particular, there'll be a lunch break. It won't be like some of you yesterday may have had a 3-hour lunch break. That won't happen. It'll be about an hour. It will be noon-ish. And then we also will always have at least one morning break and one afternoon break, just to give you a break. During that break, you can be in the jury room or you can fan out up and down that hall. There's actually natural lighting at that end of the hallway and over near a little elevator bank. If you're out of the jury room, if you don't mind using a lower voice, there are other judges and their offices, and they'll come fuss at me and it's like, rowdy jurors, we're playing the drums down at the end of the hall. But it's fine to use that space if you need to make a phone call and don't want to do that in front of all your other colleagues in the jury room. We will also take a break whenever one of you needs it. Your role here is to be the fact finder, and you find the facts, what was proven in this case, by listening to what the witnesses say and observing the exhibits that are admitted. They'll be put up on the screens or held in front of you, whatever the evidence is. If we reach a point where you are not absorbing anymore because it's gone on too long, raise your hand, do what you need to do. So it could be that the break is simply, can I stand up and do this? It could be you need to get into the jury room. Usually having a morning, a lunch, and an afternoon break is enough, but everyone's different. And there may be a really boring witness and you've had enough. And you don't need to say the witness is boring. You can just say, we need to take a break, and we'll do that. Because there is no rewind button. You don't get to say, hey, could you have that witness come back? Because I really, you know what, I was doing something else while that witness was testifying. Having said that, if you all could stand and raise your right hand. Do you swear or affirm that you shall fairly try this case between the state of Georgia and Mr. Parks and Mr. Phillips, who are charged with murder, felony murder, aggravated assault, criminal damage to property, and a firearms offense, and give a true verdict according to the evidence? Please say yes if you so swear or affirm.
Yes.
Does anyone not so swear or affirm? All right, thank you. One thing about seating, there are no assigned seats. If you need to be at, it's my left, I think it's your right, because every once in a while you need to stretch your legs out, feel free to be there. Otherwise, I'm not going to order you to, but I'm going to strongly encourage you to sit in a different seat when you come back in here. You literally get a different perspective. The witnesses are all going to be right here. The five of you are going to see these witnesses pretty closely. You way in the back, you may want to be far away from a witness, and that's okay, but it's a different experience. You see things differently. These screens are easier to see closer. So don't hog a seat unless you're like, I'm a corner person. I need to be in the corner. It is okay to have a different seat each time. Deputy Gordon and his colleagues are the people to engage with if you've got a question about where's the vending machine or this or that. When we take a break and we go to lunch, you're going to be out in the hallway going down elevators. You might, just by happenstance, bump into the lawyers. They're going to treat you like you're radioactive. And that is not because you are or that they're weird. They're mostly normal folks, but they are not supposed to interact with you outside the courtroom. That's an instruction. You could imagine how it would look if four of you are waiting for the elevator and one of the lawyers is chatting it up with you. And it may be as innocent as, oh, I recommend this restaurant. But if I'm the lawyer for the other side, like, what are you talking to four jurors? Like, my case is going well. What, you got any advice? So if you have a question about, wait, where's the cafeteria? Answer is, we don't have one. And one of the lawyers is walking towards you and they turn away or they get off the elevator because you got on. That's natural. They need to only interact with you when all the other lawyers are around. It's on the record, and I'm here to handle any objection that might arise. I'm now going to share with you some basic legal instructions. These are not the formal legal instructions I'm going to give you at the end of the trial with the elements of the crime. It's sort of the roles of the lawyers, the burden on the state, and importantly, your role as the fact finders. First thing I want to talk about is note taking. You all have notepads and you are free to take notes. You are not required to take notes, but some people find that it's helpful to jot things down. As I mentioned, there's no rewind button. And so if someone says something that to you seemed kind of important, you may want to write it down. You don't need to. They are memory aids. Your notes are private until you begin your deliberations. When you finally have all the evidence, and I've told you what the law is, you are free to rely on your notes to refresh your recollection, to advocate your perspective on the case. But if you're someone who didn't take notes, you shouldn't say, well, gosh, because that guy wrote it down, it must be true. You rely on your recollection as it may be aided by note taking. So feel free to do it. Please don't let note taking interfere with one of your important roles, which is to assess the credibility or believability of witnesses. One way you do it is you hear someone say, the sky is red. Like, that's crazy. The sky's not red. Another way you do it is you watch how the witness responds. And if the state calls the witness, and when the questions are coming from the state, they're engaging you and making eye contact, and the moment some questions come from one of the defense attorneys and they turn away or they start sweating, that may tell you something, the way the witnesses are reacting to the questions being asked. And you miss that, if you're trying to write down word for word everything that's said, because you can't. There's one person in the courtroom who can write down word for word what's being said. That's Ms. Rivers. She has trained for years and climbed many mountains to be able to do that, and you haven't. So take notes, don't let it interfere. Your notes are private. And last thing on notes, when the trial is over, they get shredded. You don't need to, they're not made part of the record. So if you write down, judge is an idiot, I'll never see that. It will get shredded. It's okay to express your personal opinions in your notes. Ladies and gentlemen, the defendants in this case are charged in this indictment, which you will have with you during your deliberations, with various crimes. Crimes are violations of the laws of Georgia. I'm going to read to you now this indictment. Feel free to take notes, but as I said, you'll have this. It's very legalistic. It talks about things in a funny way because there's certain ways things need to be charged. You will have this during your deliberations. And I should add this, because you're going to have this. There is a third defendant, Carrie Henderson. Her case is not before you. I'm not going to read what her charges are. They're in the indictment. You can read them, but those charges are not before you. You have the case of Mr. Phillips and Mr. Parks, and not the case of Carrie's a female, Ms. Henderson. And you may learn who she is and her connection to this case during the case. You may not, but that's not germane to what you're deciding. Count one charges Mr. Parks and Mr. Phillips with murder. And the allegation is that here in Fulton County on September 13th, 2021, the defendants did unlawfully and with malice aforethought cause the death of Tobias Arnold, a human being, by shooting him with a firearm. Count two charges Mr. Parks and Mr. Phillips with felony murder. And the allegation is that here in Fulton County, on that same day, September 13th, 2021, the two defendants did unlawfully during the commission of a felony, and that felony is aggravated assault, cause the death of Tobias Arnold, a human being, by shooting him with a firearm. Count three is a second charge of felony murder. And the allegation is that here in Fulton, on that same day, the two defendants did unlawfully during the commission of a felony, and this is a different one. This felony is criminal damage to property. The allegation is that they caused the death of Tobias Arnold, a human being, by shooting him with a firearm. Count four is the aggravated assault charge. The allegation is that Mr. Parks and Mr. Phillips here in Fulton County on that same day, September 13th, 2021, did unlawfully commit an assault upon the person of Tobias Arnold by shooting him with a firearm, that firearm being a deadly weapon. Count five charges both defendants with criminal damage to property in the first degree. The allegation is that here in Fulton County, on that same day, the defendants did unlawfully, knowingly, and without authority interfere with the townhome residential dwelling at 4215 Notting Hill Drive here in Atlanta, the property of Tabitha Hammond, in a manner so as to endanger human life by shooting into it with a firearm. And finally, count six charges both defendants, Parks and Phillips, with possession of a firearm during the commission of a felony. The allegation is that here in Fulton County, on that same day, the defendants did unlawfully have on and within arm's reach a handgun during the commission of at least one of the felonies I've already mentioned: murder, felony murder, aggravated assault, and criminal damage to property. There are two other counts in the indictment, 7 and 8. They relate to Ms. Henderson. Those aren't before you for your consideration. What I've just read to you is evidence of nothing. It is not evidence of the guilt of either defendant. It's not an implication of guilt. It is merely the mechanism by which the state brings charges against someone. And to the charges, the defendants have both entered not guilty pleas. It's filled out on the indictment that you'll have. Both defendants sit before you with the presumption of innocence in their favor. And that presumption stays with them unless and until the state has proven beyond a reasonable doubt one or more of the offenses charged. A defendant should not be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt, stays with the state throughout the trial. There will not be a point where I hit a buzzer and say, all right, the state's done what it needs to do. Let's see what the defense attorneys have to say. There is no burden on a criminal defendant, it may be that Mr. Menendez and Mr. Rowe never stand up again in this courtroom to do anything at all. They have an absolute right to. They can call witnesses, they can put on evidence, but there's no burden on either defendant. And so it could be that the four folks over there don't do anything else during the course of the trial. Now, they both have very, very good lawyers, and I expect that they're going to engage with you, but they don't need to because the burden remains with the state throughout the proceedings. A reasonable doubt means just what it says. It's a doubt based upon common sense and reason. It is not a vague, arbitrary, or speculative doubt. Instead, it's a doubt for which a reason can be given. And that's a reason that arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. The state is not required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. As I mentioned, the defendants have no burden at all. If, after giving careful consideration to all the evidence you receive, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if no reasonable doubt exists, you would be authorized to convict. Now, the basic structure of the trial is that in a few moments, all the lawyers will be given the opportunity to present what we call an opening statement. This is a preview of sorts. It's a chance for the lawyers to say, here's what I think you're going to hear, X and Y and Z. And the state's going to tell you X and Y and Z are going to show you that Mr. Parks and Mr. Phillips are guilty. The defense attorneys have the same opportunity. They don't have to give an opening, but if they do, there'll be a chance for them to say, you're not going to hear X, and Y is confusing, and Z is contradictory, whatever their argument is that the state cannot or will not meet its burden of proof. Opening statements are not evidence. In fact, nothing the lawyers ever say to you in this case is evidence. Evidence comes from two sources: the mouth of a witness who's been sworn in, and then exhibits that are admitted, a photograph or a T-shirt or whatever evidence the parties might admit. Once the opening statements are done, I will turn to Mr. Greiner, say, call your first witness. That witness will come in, he or she will be sworn in, and Mr. Greiner or Ms. Porter will start asking questions. And that first answer to the first question is when the evidence starts, because it's what the witnesses say. It's not the questions that are asked. At some point, I'll ask Mr. Greiner to call his next witness, and he'll say, Judge, at this time, the state rests. That's the close of the state's case in chief. By that point, they've met their burden or they haven't. I will then turn to either Mr. Menendez or Mr. Rowe, and they'll let me know the order in which they want to go. And I'll say, hey, are you going to call any witnesses? And they may, but no burden on the defense. It might be I say, Mr. Menendez, are you going to call any witnesses? And he says, Judge, the defense for Mr. Phillips rests because there's no burden on Mr. Phillips. And Mr. Rowe might say the same thing. But know this, both these lawyers have the same ability as the state to subpoena witnesses, get them to come in and testify. So if they want to put on evidence, there is nothing preventing them from doing so. They just may choose not to do that. At some point, everyone will have rested. I'll ask the state if they've got any rebuttal. Something may have come up if the defense puts something on that they want to rebut by calling a witness. But eventually, everyone will say, we're done, we rest. And then we turn to what are called closing arguments or summations. These lawyers are going to get back in front of you, and they're going to try to persuade you to decide the case in their direction. So Mr. Greiner or his colleague will say, here's why you should find the defendants guilty. And they're going to talk about all the evidence, line it up with the law, and say, your job's not all that complicated because of X and Y and Z. And you should feel free to be persuaded, but know that just because a lawyer tells you, here's what the evidence was, doesn't mean that that's what the evidence was. You decide what the evidence was. The defense attorneys will be given the very same opportunity to give a closing argument or summation. When all those are done, I will give you the final charge. That's when I'll tell you what the elements of murder are, what the elements of felony murder are, all the things you need as the law to say, here's the framework. Let's start seeing if the state has met its burden. Have they proven this beyond a reasonable doubt? Have they proven that? That's when you begin your deliberations. It is important that you save your deliberations until then. When you go to lunch today, you can talk about anything you want except for one thing, and that's about how the case is going. You don't say, wow, man, that first witness, I'm done. That guy sold me, guilty. Or based on that witness, this state has no case at all. You can be thinking these things, although you should resist the temptation to be making up your mind until you've heard everything. In particular, because you don't even know what the elements of the crimes are. Kind of hard to know if the state has proven its case until you know, well, what do you have to show for aggravated assault? What are those pieces that you need to meet? During the trial, the attorneys have a right to object. You've seen this on TV. Objection, judge, that's out of order. Lawyers get to do that. My job in handling those objections is to apply the rules of evidence and either sustain the objection. Yep, that's a good objection. Person who is asking the question, you need to do something different. Or to overrule the objection. Nope, I'm denying the objection. Let's keep going in the direction that the lawyer who was asking the question was going. You should not interpret from anything I say in ruling on an objection as some opinion I have about which side is doing better or the defendants are guilty or not guilty. I am simply listening to what the concern is and addressing that concern as best I can. That's it. The lawyers may, from time to time, have motions. And the distinction between an objection and a motion is basically an objection. I can handle it while you're sitting right here. And we move on. A motion usually means you get an extra break because it's something where the lawyers want to talk pretty freely about something that until I rule on it, they don't want you to hear what they're talking about because I may say, nope, you can't go there at all. But they want to talk about why they want to go there and you shouldn't hear that. So I'll often say if there's a motion, hey, could we just hold on to that until we take a break? Sometimes we cannot and you get an extra break. But I do my best to have those motions dealt with, like we dealt with a bunch of them this morning before you came out here. You have an important role as well. You are the fact finders. You decide what happened in this case, and you apply the law that I give you to the facts that you find. You, in doing so, will be determining the credibility or believability of the witnesses who appear before you. And in determining credibility, you may consider all the facts that you've heard already in the case, as well as the manner in which the witness testifies, and this witness's interest or lack of interest in the outcome of the case. Generally, it'll be the lawyers who ask questions, but you may find from time to time that there's a question that you've got that hasn't been answered by the interaction of the lawyers and the witness. And you have a way of asking that question. And that's those note cards that are spread out on a little shelf in front of some of the jurors in the front row. And you can distribute them to everyone in a minute. At the end of every witness who testifies, I'll be turning to you all to say, do you have any questions? You don't raise your hand and say, hey, where did you go to school? You'll write it down on one of those cards. You can write as many questions as you want, just on one side of the card. Please write legibly. Don't put your name or number on there. They're anonymous questions. They're juror questions, but they're anonymous. Deputy Gordon will collect those cards. I'll meet with the lawyers because in the same way that a lawyer could ask an impermissible question that maybe calls for hearsay, your question might as well. And if it is an objectionable question outside your presence, the lawyers will say, well, Judge, that you can't ask that question. And if I agree, I will not ask the question. But maybe during the exchange with the witness, you learned a lot, but you didn't learn, well, was it dark out or not? Someone said, hey, that happened at 6 p.m. Okay, well, depending on where we are in the calendar, that could be dark. And all you want to know is, was it dark out? You write down, was it dark out? Nothing objectionable about that question. I'll share it with the lawyers so they know. And then I, not you, will say to the witness, hey, a few more questions. First, was it dark out that night? Oh, there were lots of streetlights, whatever the answer is. And you get the answer to your question. The lawyers will be free to follow up after you ask your questions because you often have questions that the lawyers hadn't thought of and they want to jump in on that. You should draw no conclusions if your questions are not asked. All that meant was it was an impermissible question. It doesn't mean that someone's hiding something or this or that. Either was the wrong witness for that question or it violated some rule of evidence. If at any point during the trial you cannot see or hear what's going on, let me know. These monitors should make it so that you can see a photograph if that's an exhibit. I work pretty hard with the witnesses to make sure they get up close to the microphone. We have some soft-spoken witnesses. I'll get them closer to the microphone. But I won't know that you can't hear unless you do something like this, and we'll adjust immediately so you can. And if it's break time and I've missed that fact, let me know and we'll take a break. Please view the evidence with an open mind and resist this temptation to say, I figured this one out. There's no jeopardy, you buzz in early. you're going to have to listen to every witness that the lawyers want to call, then hear closing arguments, then get the law before you can meaningfully begin your deliberations with your colleagues. It is essential that you decide this case based only on evidence that is received here in court. That's why you're permitted to ask questions. What you cannot do, it will cause a mistrial, and if you're the one who did it, it will cause you some trouble afterwards, is do this. Hey, I'm curious if it was dark out that night. I'm gonna go to the Farmer's Almanac and see when sunset was on that night. No outside research. Don't get on your phone to look up a picture of the alleged crime scene. If it's important for you all to see the crime scene, lawyers will have pictures of it. If they didn't, does anyone have a picture of the crime scene? Write it down on the card. If you look something up outside the courtroom, one, we don't know that it's correct. Two, the other side, if it's evidence that helps one side, doesn't get a chance to say, well, wait a minute, let me put that into context. That's why that doesn't apply. So it is forbidden, no outside research. Ask it by way of those note cards. Finally, when you go home tonight, you may be tempted to share with people in your household or people you're online with or people you like to talk to at night how your day went. You need to be a real boring friend in that way until the trial is over, because well-meaning people are going to say, oh, let me tell you what that means. When that happens, oh man, that's a bad sign for the state, or that's trouble for the defendant. Those folks don't know, because that's whatever their experience was, wasn't this case. It wasn't this courtroom. It wasn't this prosecutor. It wasn't these defendants. And so you have to be very, very circumspect. I'm a juror. I'm loving it. The judge is a great guy. Leave it at that. And don't do anything more than that. When the trial is over, there's nothing permanently confidential about what you're doing. When the trial is over, you can share with people, you can ask questions, what was your experience like? But between now and then, that's another vector where you might receive outside information. Oh, I know that neighborhood. That kind of thing happens all the time, or that never happens there, or whatever. Maybe they're right, maybe they're wrong. That's not happening here in court, where people can object and try to counteract it with other information. So be very, very circumspect with your interactions with others. I'm not aware of any media coverage of this case. In the super off chance that you're driving home and on WSB they say, and in courtroom AD today, change the channel. But there's no one from the media in here. I don't think you're going to run into that issue. There's a trial going on right now where it would be hard to stay away from the news, but this is not that case. You are going to be jurors for a week and not for a year. Consider yourself blessed. That concludes my instructions, ladies and gentlemen. I appreciate you listening to me. I'm going to ask you now to listen to someone from the state as the state gives its opening statement. Okay. Man, I see something on my screen. It's not big, but it's there.
Okay.
You may want to F5 it.
We all know that if you shoot a handgun in a neighborhood, you are responsible for that bullet and the damage that it causes. It's exactly what these two over here did back in September of 2021. Parks, Phillips, and a third guy, they each had a handgun and they each fired at a house. They shot up a house with a family inside, adults, children. They didn't shoot just 1 or 2 times or 4 times, something like that. 31 shots, 31 rounds, these two and their friend put into a house. On a Monday night, 6:30 in the evening, families coming home from work, kids out in the yard, teenager playing basketball. 31 rounds they shot into a house in a neighborhood here in Fulton County. I'm going to show you what is State's Exhibit 1. We're going to refer to State's Exhibit 1 throughout the trial. This house right here is 4215. This is the house that got shot at. Inside this house is a family. Tabitha Hammond, Devontae Harris, their children live in this house. Down here in 4228 is where defendant Parks and his mother lived, together with another brother that they call Fats, and some children. There's some children associated down here with this house, 4228. You see, it's hard to get much information about this house because Carrie Henderson, Parks's mom, has provided several inconsistent statements in this case. Back in 2020, a few months before the murder in this case, there were two children, a 6-year-old and a 7-year-old, approximate ages, who had a fight, as kids will have fights. One of the children lived here at 4215. Another child was associated with this address down here at 4228, may have lived there, who knows. This fight happened, and they separated, and they each went their own way. Very unfortunately, though, the adults began a dispute among themselves. That night, there were two men that came to 4215 and confronted the family that lives here about the kids fighting. That started a series of events. Every once in a while, through the ensuing months, this house will get shot at. A bullet or two. Sometimes they would miss this house and they would hit 4270. These are things that were reported to the police. The police would come out, they see the bullet hole, they do what they can. There we go. At this point, at some point in September, this family had had enough. They're going to move out. September 13th, 2021 was moving day. They rented a U-Haul. You're going to see pictures. They parked the U-Haul here on the side of the street, or between the street and the house, and they were loading things into it. You're going to see kids. There are children out here in the yard. They invited friends over to help move. One of these friends, I'm going to call him Sam. You're not going to hear Sam testify. One of these, he's gone. One of these friends parked his car right here. There is some video evidence in this case. Don't get your hopes up. It's not wonderful video. It's good. You can certainly see what's happening. But it's not Hollywood quality video. But you'll see on the video that Sam appears to be alarmed. You see, there's a car, a red Mustang, that is parked over here. And these two defendants here and their friend are sitting here in this car. There's a fourth guy, Fats, who I mentioned already. Fats comes walking up this way, and as he gets to here, he kind of deviates over here, and then he comes like this. He's curved. These three guys here, these two defendants and their friend, get out of the car, and then the four of them come walking down past this 42, across the front of 4215. Sam is standing there. He senses something apparently. He has two guns pointing straight down. He stands there. Doesn't point the guns. We'll see on the video. Doesn't say anything. There is nothing that goes by between these individuals as the four go down here. Sam just stands there. The only one else who does anything is Phillips. Phillips does what's called clutching. You have a handgun in your pocket, and they grab it, and as you walk, showing that you got something in your pocket. That's what Phillips does as he walks past. So the four come down here, down the road to this house here, 4228, which is where Parks and his mother lives, and Fats lives there too. There are children here in the yard. So Sam, he's out of there. He gets his girlfriend, they get in the white car, they leave. They're not gonna stick around for this. They leave. And they come up here and they leave. But while they're leaving, Carrie Henderson, you'll see her plainly in her red shirt. She comes out and she photographs something. She looks like she's trying to take a picture of the white car or whatever as it's leaving. And then she turns around and she comes back here to this area. And somebody says something. Because within seconds, it all breaks loose. 14 rounds are shot down here. 14 rounds. And they're shot toward 4215. The bullets are all going this way. And these aren't, we're not talking about controlled shooting in a range. We're talking about completely irresponsible shooting, just shooting, letting loose, just crazy. They shoot 4215, they shoot 4217, they put a bullet over here in 4322. They shoot, there's a car, this is a Google photo, Google aerial map. This is not the car, but there was a car parked in this area. It gets hit. And unfortunately, the next door neighbor who's standing right here in this area, Tobias Arnold, he gets shot also. One round in the neck, he's down, he's dead. That's why these two together are charged. They were working as a team with their friend shooting. As a team, they're all responsible. But that's not all. Because you see, when Mr. Arnold collapsed and he's dead, he's bleeding, these three, they run. And as they're running up here past 4217 and 4215, you hear, "Cover your face for the camera." There are cameras. Again, not Hollywood quality, but there's a camera here in 4217, one in 4215, and there's one over here in 4214. Cover your face for the camera as they run past. And then you know what else? They light up 4215. They light it up. 17 rounds up here. 31 total rounds. 2 crime scenes. They shoot 14 down here, 17 up here. 17 rounds into the house. And then they get in their little red Mustang. And guess what? Phillips gets out of the Mustang. One more shot, bam! Into 4215, and then they go screeching off. Guess who else leaves? Carrie Henderson, the mom down here. And there's another car that's here. They both leave. They leave Tobias Arnold. They're bleeding in his own driveway. His girlfriend, Onodata Neal, is completely panicked, completely freaking out. They left her too, just to deal with it. So neighbor calls 911. The police are there fairly quickly, and there's chaos. Because in the middle of all of this, there is a completely unrelated white minivan, completely unrelated to this case, that had gone down here and it comes driving up through, and these neighbors, when we saw a white car, there's a white minivan, there's a red Mustang, and so they're just spitting out all this stuff for the police. And right in the middle of it, Harry Henderson parks his mom, comes driving right back through into this area. They won't let her down too far, but they stop her, and she gets out and starts talking inconsistent statements. She says, she never says Parks was there, my son was not there and all this. Well, guess what? He was there. He was there. He's on video being there. He later made a statement admitting that he was there and that he shot his gun. He was there. In his statement, he says somebody up here was shooting back at them. Guess what? No ballistic evidence at all. No evidence whatsoever that shows bullets going this way. No damage to the two cars that were parked here, or to the decedent's car, or to this car that's here on the side. No damage down here. No cartridge casings deposited up here from another gun. There are cartridge casings out here from three guns only. 1, 2, and then their friend, 3. No other cartridge casings. Lieutenant Phillips gave testimony also admitting being there, shooting his gun. His statement was also inconsistent.
Not right now.
Let's have an objection.
Okay, I understand your objection. This is opening statements. It's a preview of what may happen during the trial. We'll see if it does.
One other thing, Carrie Henderson, not only did she give an inconsistent statement to the police, she tried to influence Ms. Neal into what statement she would make regarding her son, regarding the defendant Parks. This third individual, everyone calls by the street name G. He's unnamed, not been caught yet. These three got rid of their guns, they got rid of the car. This is not a self-defense case. There is no evidence of gunfire toward them at all. The residents at 4215 were not bothering anyone. They were not a threat. They were not arguing, challenging, any of that. These defendants, if they had a concern, they could have gone inside and called the police instead of pulling out their guns and shooting. Sam drove away. He wasn't there. There were children in the house. There were maybe 5 children in this house at the time. And we talked about all the other areas that were shot. So this is not a mistake. The evidence is not going to show that this is a mistake. Don't let the faces fool you. These were intentional acts. You're going to have the indictment back with you in the jury room, ultimately when you decide this case. This is the most important document in the case. Count 1, as the judge told you, is malice murder. And it charges that these 2 defendants did unlawfully and with malice of forethought cause the death of Tobias Arnold, a human being, by shooting him with a firearm. The judge is going to tell you what the law is. He's going to tell you about party to a crime, how 3 people acting in concert are responsible for the entire actions. He's also going to tell you about transferred intent. If I try to kill one person and I hit somebody else, my intention to kill this person is transferred onto the actual victim. That's why these 2 are charged with malice murder. They're also charged with felony murder based upon committing an aggravated assault which results in someone's death. Shooting a handgun in a neighborhood, very likely, very foreseeably, very predictably, could result in someone's death, as it did so in this case. That's why these two are charged with felony murder based upon what's called a predicate offense of aggravated assault with a deadly weapon. They're also charged with count 3 felony murder based on criminal damage to property in the first degree. When you shoot up a house, you are endangering lives that are in that house. That's criminal damage to property in the first degree. If you actually kill someone, that's felony murder based on criminal damage to property in the first degree. That's why these two are charged with count 3. Count 4 is aggravated assault with a deadly weapon. That is what's called a predicate offense for count 2. They committed an assault. An assault is an attack. It's aggravated because they were using a deadly weapon. They were committing an assault upon the person of habeas arm. Remember again, it's that transferred intent. Trying to shoot that person or that house over there. I hit somebody intervening, not on accident, or get something like that. The intent is transferred. Didn't mean to hit that person. I was meaning to hit the other one. The intent is transferred. Criminal damage to property in the first degree. That's the predicate offense for count 3 felony murder. Again, the judge will give you more instruction later, but interfering with this residence by shooting up with a handgun, with a firearm, that is criminal damage to property in the first degree. And then the last count, count 6, is possession of a firearm during the commission of a felony. This is, in Georgia, it is a criminal offense. It's a separate offense to commit a crime while possessing a firearm, as opposed to a slingshot or rock. You can kill somebody with something else. That's different. You wouldn't have this charge. Here, they committed these offenses with a firearm, and so that is its own charge. It's a separate offense, and that's why they're charged with count 6, and that's what the evidence will prove. So, after opening statements, as the judge said, we're going to get into witnesses, the exhibits. There are going to be a number of exhibits in this case. There are going to be photographs and physical pieces of evidence and things like that. Pay no attention to the numbering. We may go from 1, 2, 3, 4, 5 and skip to 7 and 8. We may skip some numbers here and there. It means nothing. There might be additional evidence after the closing the state's case, closing arguments. And then the judge is going to tell you what the law is. The judge is going to tell you what the law is. And I anticipate he's going to tell you again about parties to a crime and transferred intent, which are two critical parts of law in this particular case. You're going to hear direct evidence, which is based on what people saw, what they heard, basically what they sensed, and circumstantial evidence, which is the circumstances that all these pieces of direct evidence put together. You're going to hear expert testimony in the form of ballistics experts and also the medical examiner who's going to testify about the cause of death for Tobias. Ultimately, we're going to come back during my closing argument and ask that you find these two defendants guilty of each and every count on the indictment. Thank you.
Thank you, Mr. Greiner. If you wouldn't mind taking down the board. Mr. Rowe and Mr. Menettis, I forgot to consult with you all about who's going first if you're given openings. Whether you'd like to or not doesn't mean you are. Do you have any objection to Mr. Menettis going first? He can go first. All right. Mr. Menettis, you are up on behalf of Mr. Phillips.
Yes, Your Honor. Should we approach first about that objection, and then just...
Well, we can. You've preserved it, and we'll get it on the record at the appropriate time.
Okay, thank you. Good afternoon. As I said yesterday, it's my honor to privilege to be part of this process. to represent an innocent young man, Mr. Phillips. And I think the evidence will show that a lot of what we just heard from the state is not true. And a lot of things were left out. So that's gonna be up to you. Don't take my word for it, but I say it's not evidence. The judge said this is just a roadmap where I'm gonna point out things that you make yours for yourself. September 30th, 2024. It's a good day. Until it wasn't. For Mr. Phillips, Mr. Parks, and Mr. Arnold were deceased. It was a good day until it wasn't. Mr. Phillips, my client, did not go to that area for any kind of violence. He didn't go there to attack anyone. He didn't attack anyone. He went there because that's the mom's house of his friend, Mr. Parks, who I don't represent, but they have an interrelated story. Mr. Rowe represents him. He's going to present a compelling story for his client. Mr. Phillips' story is different. He's going there because that's his friend. That's where some of the people he knows hangs out. And as the state said, sometimes certain area.
Yep, something just happened. Hold on. You can keep talking.
Now, sometimes things happen where you live. And you can't choose where we live. You gotta be friends with somebody. You certainly can't choose where you live when you're 17, 18 years old and still relying on your parents. Mr. Parks lived with his mother at the neighboring house where Mr. Tobias Arnold lived, the deceased. What's really going on, why Mr. Phillips really went there, is for friendship and fatherhood. He's just given birth, not him, he's just had a baby with his girlfriend, Miss Martonia Higgs. And Miss Martonia Higgs' uncle is the deceased, Mr. Tobias Arnold, the niece of the deceased. And Mr. Phillips knows him, likes him, has an endearing relationship with him. Will never attack him, did not go there to attack him, did not go there to help anyone attack anyone, or these people that the state told you about, who are the actual attackers. And the scene is not investigated enough for us to believe beyond a reasonable doubt the state's burden a lot of things that were just said. Again, don't take my word for it. Mr. Parks goes there to hang out with his friend, to talk about his fatherhood, to share the news. He's talking about it, he's in the house. Mr. Parks and this guy G, who Mr. Phillips, for better or worse, is also friends with. They're all hanging out. Mr. Arnold is there because that house is where his girlfriend stays with her roommate. So he also is not there for any kind of violence or shootout, anything like that. He's a completely innocent bystander. He could be any of us. And it's terrible what happened. Mr. Phillips did not have a part in it the way the state says. Now, Mr. Arnold is there. There's some intimacy, some affection with his girlfriend. Mr. Phillips is there, sharing the news about his new baby, hanging out with his friends, seeing his friend's mom where his friend stays. And it's a good day. It's a good day for everyone. Until it's not. And what happens is, we don't know who exactly is being shot at or why, but other people, one or more, open fire on this area that we'll see on video. You might hear some conclusions that are unreliable from a ballistics expert, or you might hear someone make an inconsistent statement that the state tries to go against them. But again, believe your own eyes, believe what you see on the video, because that's not what happened in the state says. Now, you'll see on the video, Mr. Phillips, my client, is in all white. He's in his friend's mom's house. He walks out to the porch. G is in all black. Mr. Parks is in red. You see them in the driveway. And then, I'm sure Mr. Rowe is going to get into it, there's an attack towards this area from this other uninvestigated area where we end up suspiciously not having video. Wow, well, there's so much videos about this one area, but there's not video of the other area. I'll get to that in closing. You sure with common sense see for yourself. Now, Mr. Phillips walks out with an attack. And Mr. Phillips reacts differently than G and Hot. G is the friend that's not here in the all black on the video. Hot is what Mr. Parks is affectionately known as with his friends and family. Now, G and Hot react differently to the attack. They get out guns and they start shooting back. And I'm not here to advocate or put a spin or anything like that. That's between the state and Mr. Rowe and his client. But they have guns on them. Mr. Phillips has a gun on him. A lot of us have guns on us in a lot of places for a lot of reasons. We talked about yesterday. And you see that Mr. Phillips and possibly Mr. Parks were pretty right about wanting to have a gun on them. Okay? And they're teenagers. They don't get to decide what they do. You gotta be friends with somebody. And friends with the people around us. That's how we work. Now, they start shooting back, okay, to the attack. Mr. Phillips, as a young person in this day and age, gets out a phone. You'll see on the video that he does not have a gun in his hand. You cannot see a gun in his hand, and it's not in a posture that looks like shooting. You see him filming what's going on. You know, he might stay silent, he might not. None of us have a right to hold that against him. He's presumed innocent. So anything we don't know at the end of this is settled in his favor, because we presume him innocent. So the state proves beyond reasonable doubt with evidence. That's reliable, that he's not innocent. So he's filming the attack. That happens all the time. It's weird. It's weird. You all might not act that way, but people do. That's why we see so many cell phone videos of so many natural disasters and shootings and different things like that. We just saw it during an attempted assassination on a presidential candidate. There's all this cell phone video, but you know, shots going on. Whatever in this day and age, that's an impulse that some people have. That's what Mr. Phillips did. These people that are shooting at him, attacking him, he gets his phone out and he starts trying to film it. You'll see that. Okay? And I want to just play it for you.
Judge, we need to see this before, this is.
I'm confused. Mr. Menendez brought this up outside the presence of the jury. This is something you've never seen before? So take it off the screen.
No.
It's on the screen. Take it off the screen.
I'm just asking, what's the source of this?
Your Honor, it's fine. A good faith, pretty obvious belief that it should be.
Have you not seen this video before? If you've never seen this video, it's not being played.
I've seen I'm not sure. I've seen a video from a similar perspective. I don't know if that's.
Is that what's in the envelope he was handed this morning?
No.
Did you provide this video to the state before now?
It's not my video, Your Honor. It's part of the state's discovery.
Okay, then I'm okay with it. I was not aware that that's where.
That's all you need to say. Is this something that came from them? Okay.
Yes, Your Honor. And the state might not present it to you exactly the way I am. I zoomed in and it's screen recorded so that I can bring attention to what happened and the reasonable doubt and what I've been sharing with you so you can decide for yourselves. But it is the video and has not been altered. There's some audio that I'm not. You see Mr. Phillips right here walking out of the house, phone in his hand. Shooting breaks out. Mr. Arnold drops dead right here. This is G going around shooting in different places. This is hot shooting. You don't see Mr. Phillips shooting at any point. You see him go up to someone he knows, the uncle of his girlfriend, sees him dead beyond help, beyond calling 911, sees a dead body, and then you see him getting his gun out of his pants. And later the state will throw you, I'm sure, some alleged activity after the fact, but that's not part of felony murder. That's not what he's charged for. We're not gonna have a right to hold that against him. There isn't this mass shooting into the house, there's no bullets to prove it. But the area that the attack comes from doesn't have houses in it, it's like this grassy hill. It's not even examined. Okay, they only examined this area. So that's what happened, he comes out, he tries to film, he never ends up being able to start the recording in the chaos and the noise. Talk about headsets and shooting ranges. He's never able to start the recording, he gets scared. He drops the phone, you'll see. No burden on Mr. Phillips, but he drops the phone in the scene. And you'll hear from the detective, Detective Thorpe, that they believe that's his phone. One of his phones, at least, that he was using at the time. iPhone, other phones, you don't just whip it out and start recording, you have to swipe one time, click video, click record. You didn't pull that off in the moment before Mr. Arnold, the uncle of his girlfriend, drops dead. And you'll hear from the medical examiner, but you don't need to be a medical examiner to imagine what you're gonna have to see, sadly, but thank you for your duty in advance. You don't have to be a medical examiner to imagine what's going through Mr. Phillips' mind when he sees that. Medical examiner will testify that tragically, through no fault of his own, in the midst of this attack, and in hot and G firing back, a bullet goes through his neck, through his carotid artery, and through his brainstem, shattering the brainstem. And that's what Mr. Phillips, you saw, who walks up and sees in the midst of not being able to forward and dropping his phone. He sees that person dead. You'll see the photo of it. It's terrible. You might never forget it. It's nightmarish. It's terrible. It's gut-wrenching. That's what Mr. Phillips sees, and he flees away with his friends. That's what happened. And everything after the fact, they're not on trial. He's not on trial for when you see him raising his hand up with the gun in his hand, maybe firing, maybe not. Not on trial for that. You see him doing anything after any of these allegations, he's not on trial for that. And there's no normal response to an abnormal, life-threatening situation. So that's what the evidence is going to show. And any attempt to use any kind of flawed methodology or science by a state hired working expert, unreviewed, or reviewed by someone that has a motive, or doubting the chain of custody, or methodology, or the human error. We're gonna try to use that to put a square peg in a round hole, to get you not to believe your supposedly lying eyes when you see him trying to record with the phone that he drops at the scene. He's not able to start recording with, that he flees the attack along with the other people that are attacked. We don't really know who's shooting, what they're attacking at. They're never investigated, they're never caught. The people that I think have some role in it, Demonte Harris, they lie about it, of course. There's no video of where the attack came from. Do those people have some connection to the attackers? Do those people have a fear, like we've talked about, and like we're here in this case, it's common sense? Do they have a fear of being the ones to provide evidence to these people that did this insane, reckless attack at someone around my client or at my client? All reasonable, all doubt for which a reason can be given. And again, I regret you're gonna have to see what you see, but you're also gonna see this. You're also gonna have doubts. And no flawed response to that doubt is gonna repair the state's verdict. So please hold them to that verdict. So you can't put a square peg in the wrong hole. You can't get us to not believe what we saw. You can't hold any silence or, blind spots in the investigation against Mr. Phillips. And then on top of all that, you'll hear from Mr. Rowe and his client, I imagine, that they believe that Mr. Parks was justified in shooting that. And that he did not mean to hit that person. This was a self-defense scenario. But I'm not here to talk about that, that's not my client. Okay? And it's really what happened, the phone recording, no shooting until after the death. And then if you have some doubts about that, or you use your experience and your interpretation of the evidence to reach a different perspective than me, there's still the fact that there was an attack towards this area. And however Mr. Arnold was tragically killed is either from the attackers or in the justified response of G and I. I don't have a lot to say about that, but I will say that my client is within that. He's presumed innocent of shooting, which he didn't do, and he's also presumed innocent of being near or part of any justificated defense. Like it or not, we have that, right? And whether it's used responsibly or training or anything like that, that's not available. They're going to instruct you. Okay. So he's in a bit of a Russian doll presumption. The judge will say we're cloaked in presumption. Mr. Phillips, my client, is cloaked twice. He's merely present, merely associated at the scene, not involved in the shooting, not helping in the shooting, not being a lookout, not saying shoot over there, do this. And then, whatever you might believe about that, the shooting is justified in the first place. So we really shouldn't even be getting to that question. Although I would want you to look at that, of course, because I don't represent Mr. Parks. Okay, if it's justified, it's moot, what I'm saying. You have to think about whether it's a phone or a gun, is the ballistics reliable or anything like that. But then, if you don't feel like the state's met an incredibly high burden to prove Mr. Parks not innocent, then please hear me out, please examine the evidence. And while I contend that that's what I believe really happened, that's what I believe the evidence shows, that's not the question. The burden is on the state only, as the government, that we get to hold accountable in a very special way, in a especially special way where you're sitting, to prove beyond a reasonable doubt what happened the way they say it. It's going to be a lot. It's going to be gruesome, but thank you in advance. And I don't want to tell you what to say or what to think or how to look at things. But I do ask you to please hear me out and pay attention and take notes and really reserve your judgment about the state's burden until the end. And I'll be back up here afterwards. But thank you in advance, and I'll talk to you at the close. Yeah.
Thank you, Mr. Monetis. Mr. Rowe?
Things are not always what they seem to be. It depends on where you're sitting, depends on where you're standing, depends on your perception of an event. And that's what happened in this particular case. Ladies and gentlemen, we want to thank you for all of your honoring your civic duty being here yesterday and today. We know there's a lot of responsibilities that you dropped to be here. And we are appreciative on behalf of my client, Mr. Parks. We say thank you for your service and being here with us. What's already been mentioned is my client enters this courtroom. He's clothed and dipped with the presumption of innocence. He carries that throughout the entire trial. He has no burden, as indicated by the court. All the burden is on the state to prove beyond a reasonable doubt each and every element of the crime, of the indictment, that the state occurred. And we submit to you today that the evidence.
I'm sorry, one second. Can you take your?
Yes, Your Honor. That's my mistake. I didn't want to interrupt everyone.
That's okay. Well, when you ended, should have taken it with you. I'm sorry, Mr. Rowe.
That's fine.
That's okay. All right, back to you, Mr. Rowe.
Back to the regular scheduled program. But he's presumed innocent. And that presumption he carries throughout the trial. Unless the state is able to prove each and every element of the crime, of the indictment, of the charging document. Ladies and gentlemen, what occurred was, on behalf of Mr. Parks, was self-defense. Mr. Parks was hanging out with Mr. Phillips and with the victim. They were together. They were neighbors. They were hanging outside. There were children outside. There were ladies outside. They were all outside talking. And bullets came from a hill. Two individuals. You believe two?
We believe, one of our witnesses who testified there were two. Some say there was one, but either way, there were bullets that came from that hill that officer did not examine as indicated by my co-counsel. And bullets rained down on Mr. Arnold, on Mr. Parks, on Mr. Phillips. Now, these children outside were related to Mr. Parks. So when these bullets came raining down, they have a right to defend themselves. He was thinking about his little cousins that was outside. He was thinking about, it was chaos with these bullets. They came, Mr. Parks came and returned fire in protection of his cousins, of himself, and they began to run. That's why you see on the video. And look, the state presented to you that somehow all the bullets came to another house. But remember, the victim was right by Mr. Parks' house. The victim was standing right by Mr. Parks and Mr. Phillips. That's where the victim was standing, and that's where he was shot. This is a matter of self-defense. By the time we believe the evidence will show that by the time Mr. Arnold is already fatally shot, that at that time, after he is fatally shot, the return fire goes out. That's what we believe the evidence will show. We believe that since the real shooter, the primary aggressor, was not arrested, was not captured, the state is trying to put it on these two individuals who were defending themselves. The ones they themselves were shot at. Because the initial aggressors got away. And that's what this case is about. Somebody was unfortunately murdered. And at the end of the day, the individual that committed this act is not going to come. But that does not justify the state to arrest the poor people that return. We believe that what's crucial in this case, what is crucial in this case is where the victim was. Where was he standing and who he was standing with? Now, the state does not have to prove motive. We understand that. But motive is to be taken into consideration. The state has not presented any evidence that an issue between my client or the victim. And remember now, we know there were more guns out there just by the state's opening statement. Sam had 2 guns, as indicated by the state. There's another individual that also had guns as well. So there were several gun totals out in that neighborhood, in that same area. So there were a lot of guns around. But it's the state's job not to just prove that somebody was murdered. They have to prove that Mr. Parks was the one that shot the victim, period. And that's what they're not going to be able to do. They're going to be able to prove that was a homicide. We concede there definitely was a homicide. But if you don't have the right person, that's not justice. And your job as jurors is to render a verdict that speaks justice. that speaks justice. Because proving a crime and not having the wrong person, not having the right person is an injustice. And we asking you to look at the evidence carefully. Require the state to meet its burden to prove beyond a reasonable doubt that my client, Mr. Parks, that he was the one that shot the victim. And they're not gonna be able to prove it. And you know why? Because he didn't do it. And we believe that the evidence or lack of thereof, after you look at each element of the crime, after you look at the impact, you're gonna come back with a verdict that speaks justice. And that's not guilty on each and every allegation and count in the indictment. Thank you.
Thank you, Mr. Rowe. Mr. Griner, ready with your first witness?
Yes, Melissa Arnold. Actually, Judge, there are a couple of photos that I may need to get lined up in order to put it up there to the computer that went outside with those photos, so I may need a moment to get that set up. I don't know if now's a good time. I know that Mr. Menendez had something he wanted.
Well, what I'd love to do is get a witness or two in before we break for lunch, rather than break for lunch now. So I don't know if Ms. Porter can help, the sort of the trial partner piece of getting those photos, and Ms. Arnold.
Ms. Porter can just bring her laptop back in, and we can start with this one.
Great. Ms. Arnold, come on up, please.
Sit and face me or raise your right hand. You swear affirm that testimony you will be true, the whole truth, nothing but the truth of God.
So I'm gonna write on to ABC. Or actually, yeah, to A, to B, to C.
Melissa Arnold, MELLISSA, Arnold, ARNOLD.
Good morning, Ms. Arnold.
Good morning.
Thank you for being here. Can you tell the jury who you are and your relationship to the deceased in this case?
Well, I'm Melissa Arnold. I am Tobias Arnold, mother. He was 31 when he died. I am his mother, his only parent, really. I'm all he had.
Sorry for your loss.
Thank you.
When's the last time that you got to speak with him before his death?
The day before my birthday. My birthday is on September the 5th. He was killed on September the 13th. So he messaged me. I talked to him the day before my birthday. And I got a chance to speak with him again before his niece's birthday. It's on the 17th of September. But that was the last time I got a chance to speak with him. It was on September the 4th, 2021.
Ms. Arnold, it's hard to think of someone in their 30s as being a child, but I'm going to ask you how was your child? How was
He was a family person. He loved his family. He loved to cook. He loved culinary arts. When he was in school, I took him out of one school and put him in another school because he had some learning disabilities and he wasn't a quitter. I took him, he went all the way through and I was so proud of him. He was a good kid. He never was trouble in school. He never got in trouble in school. He was just a good kid. He was a good kid. He was very family oriented. You know, he loved his family. We loved him.
As he got older, did you stay in contact with him?
Your Honor, I don't mean,
Yes.
maybe briefly approach.
Nope, but you can, if you've got an objection, you can make an objection.
Yes, there's just relevance and character needs.
Okay. I'm not, this is obviously important, but I'm not sure it's relevant to what you need to prove in this case.
How about the end?
Okay, let's wrap this up.
Okay. So, Ms. Arnold, I'm gonna show you what has been marked as six exhibits, 2A, 2B, 2C, and ask if you can look at those, please.
This is my son.
This is your son. Are these photographs that you actually provided to me and District Attorney's office?
Yes,
Do they truly and accurately depict your son at about the age that he was at,
yes,
passed away?
yes.
Your Honor, this time I'm gonna move from the six exhibits to A, B, C, and D.
Mr. Rowe, any objection to states 2A through D?
No objection.
Mr. Menettis?
No objection, Your Honor.
They're admitted.
May I publish, Your Honor?
You may.
So one of the photos, are these true and accurate depictions of the different photos, Your Ms. Arnold?
Yes, that's my son.
Thank you. Ms. Arnold, I don't have any more questions for you at this time. My colleagues from the defense may have some questions.
Mr. Rowe, do you have any questions for Ms. Arnold?
One question.
Good afternoon, Mr. Arnold.
Ms. Arnold.
Good afternoon.
Now, you wasn't present during the shooting.
No,
That's all right.
Mr. Menettis, do you have any questions for Ms. Arnold?
No, thank you, ma'am. I don't have any questions.
Okay, any questions from the jurors? No, seeing none. May Ms. Arnold be excused?
I have no objection to that.
All right, thank you, ma'am, for being here. I appreciate your time. Next witness?
Your may we approach briefly, in consideration of the state's next witness?
Okay. Mr. Menettis and Mr. Rowe, if you will join me, please. Jurors, hold on. Don't go anywhere.
Somebody probably did.
Pardon me? Press that black circle, that black button.
Okay.
All right. We're gonna take our lunch break now. I was hoping we could do a little bit later. It doesn't make your lunch longer or shorter. It just happens now. You are free to eat lunch as a group. You don't have to eat as a group. You're welcome to stay in the jury room. I don't know if you brought lunch today, but in the future, if you want to bring your own meal in, you can. If it needs to be refrigerated, you can use that refrigerator. You cannot get metal cutlery through security. They will take it from you. I don't think you can get glass in either. So you have to bring Tupperware, just declared bankruptcy, or some kind of plastic carry if you want to bring your own food in. And I think we have a list of options of where you can eat if you're going to go out. Our first lunch, let's try an hour. You may tell me at the end of the day, that was too long. We don't need that much time. It's not long enough to get to where we need to go, digest, and be back. But let's aim for an hour. That clock is really slow. I think this clock is fast. I'm going to say it's noon right now. And so we're going to try to start back up at 1 o'clock. So I need all 13 of you back in the jury room a little before 1. And then we'll get out here and the state will be ready with its next witnesses and we'll keep pressing on. This is your first break since you've started receiving evidence. Remember, no outside research. If you've got a question, and I get it, there were no questions for Ms. Arnold, but if you have a question, write them down and we'll ask them of the witness. You don't ask Google or Bing or anyone like that. Any logistical questions? Take your notepads with you, leave the notepads in the jury room. Thank you for your attention. See you in an hour. All right. You all can be seated. Mr. Manettis, during Mr. Griner's opening, he talked about your client's testimony during the immunity hearing. He didn't use those words, but it was when he got into that topic that you said, can we approach? And you had an objection. You should state your objection out. It was timely and it is preserved, but I want you to give voice to it. I read it as, wait a minute, you're talking about the immunity hearing and we haven't even litigated that. My curative instruction, and that's probably too generous a term, was to remind the jurors that an opening is not evidence, it's a forecast of what might happen. They may never hear about anything your client allegedly said in a hearing again, or a statement he made, but I'd like you to make the record you want to make about the concern you had when Mr. Griner veered into that space. I'm not criticizing him. He brought it up. He may not be able to deliver.
Well, right, Your Honor, I'd move for a mistrial based on that. I know the court's very seasoned and talented with the curative instructions, but I don't think that bell can be unrung. He just said something that he did not have a good faith belief that was going to be as part of evidence because he's not the court. He's not the person like Your Honor that's going to make that decision. And we just talked about it moments before that we're going to later do it. We even said, I'm going to brief it tonight and Your Honor will read the brief, hear from the state, hear from me, hear from Mr. Rowe. And the state just got up there and just defied the court's authority just so flagrantly and recently from when we just said, we're going to brief it. So how do you go from the court saying that it wants a brief to having a good faith belief about how this honorable court is going to rule? He can't have that. And even the court can't have that just yet. That's why we're doing the brief. And now he tells them that, oh, there was this inconsistent statement. And they're going to wonder at the end. I mean, they're human beings. They're going to wonder, okay, well, where was that? Did it just get dismissed by some technicality, some defense attorney thing? I didn't hear that. So where is it? And then if they don't get to hear it and they think it exists, they're going to might assume the worst, which would not be a fair trial, Your Honor.
Okay, well, first, I don't feel defied. I hadn't made any ruling, and I think each of the three lawyers who presented openings said some things that the evidence may not bear out. That's how trials work. But I think that Mr. Griner had a good faith basis to believe he's going to be able to explore that space. It is true that you have claimed you're going to file a motion. You haven't yet. You made an oral motion, but didn't give me any authority. In fact, what you said was, I'm coming up with a creative constitutional argument about that. And I'm sure it'll be creative and it'll be well written. I don't have it yet. And so you're coming in a little late with that claim. I have rejected in toto your claim that there's some discovery violation because you don't have notice that the state might rely on a record in the docket as part of its case in chief. So I deny the motion for a mistrial. I find that the comment I made to the jury after you asked to approach made plain to the jury that openings are not evidence, they're a forecast. We'll see what the trial actually ends up showing. My direction to Mr. Griner was, don't call a witness to talk about anything that was said in the immunity hearing until you belatedly get in this motion trying to keep out immunity testimony. So I would continue to work on your motion. The sooner you get it to me, the sooner I'll be in a position to think you're right or to deny you the relief you're seeking.
Yes, Judge, and had I known they were going to try to use it, I would have filed it sooner. The research is already done, and it's really not creative. It's based on the case law, but I'll have it tonight.
Okay. Mr. Griner, it would be really helpful if I had an exhibit list so I can keep track of what you are admitting. So I don't know if that's in the works, but if we've got a case with 30-something shell casings, there are going to be a lot of exhibits, and it helps me keep track. So far, you've admitted 4 things, 2A through D, but as that list grows, it's helpful to be able to keep track. So if that's something during the lunch break you all can put together, super, we'll see. Mr. Rowe, do you have anything you need us to take up at this time?
No.
All right, Mr. Monetis, anything else?
Yeah, just a very put on the record, Judge. Yesterday, I mentioned that there was some last-minute supplemental discovery that mentioned body cams that hadn't been provided. So I got that report for the state, so they can get that to me as soon as they can. I might give it to Mr. Griner right now.
Okay. Mr. Griner, anything from the state before we break?
No, Your Honor.
All right, you all should be back here a little before 1 o'clock so we can try to hit the ground running at 1 with the state's next witness. Thank you.
What time did you say?
Be here a little before 1.
Oh.
We have all 13 ready to go. Were they more or less on time? Okay. I know I got stuck, but all right, Ms. Rivers, are you ready?
Yes.
Let's get back on the record in State versus Parks and Phillips. We've got our defendants and their lawyers and our prosecutors. Mr. Griner, anything we need to talk about before we bring the jury in?
I don't think so, Your Honor.
Okay, I have an email from you that has the exhibit list on it, so I'll print that out. Mr. Monetis, anything from Team Phillips?
Only that my previous announcement, Your Honor, about the body cams that I believe exist that we don't have yet, that's still ongoing because the state still can't find those. I talked about it. That's it.
You received a police report semi-recently, and in it, there's a reference to body cam. You want the body cam. The state doesn't have its hands on the body cam.
Exactly.
Okay. Mr. Rowe, anything else?
I would kind of join in on that, Judge. I did get the report, but I hadn't also got the body cam.
I hope you would have spoken up if you had the body cam. The sense I get is that the state is looking for it. If that's a police report from 2021, not sure when the state's going to get it. You're certainly entitled to it if the state can get its hands on it in the same way that the state probably wants it as well.
Judge, actually, if I can clarify.
Please.
I think that what my colleague is referring to is, remember how I mentioned in my opening statement that there were other shooting incidents in which there were gunshots fired around the neighborhood?
Sure.
And so one of the things that I was able to obtain is police reports for some of those other shooting incidents. And so, of course, when I got those, I turned them over to my colleagues. And so I think it's one of those incidents. If I'm not wrong, it's a January 18th of 2021 incident that my colleague has asked me about specifically.
Got it.
This case occurred September 13th, so it's they're separated by 8 months, and I don't have the body cam, and I haven't been looking for the body cam in the January incident.
Because it's not going to be an interview of Mr. Phillips or Mr. Parks or anything like that, unless the police reports mention their names. It is documentation of what you were describing, some of the tumult in that neighborhood.
Yes, Your Honor.
Okay.
Unless I'm wrong, unless Mr. Menendez is going to point to me to, or I misread a date, but I believe that that's what we're talking about.
Your Honor, yeah, the date's correct, Your Honor. This goes back to that same issue, I don't want to relitigate it, but I think the co-defendant would bring up prior difficulties if maybe those body cams were available, because they might say something about the defendants that the court pointed out. So.
Okay, well, it sounds like you've got investigative capacity. You've been looking for witnesses, and that capacity can be looking for body cam too.
Yes, if you know me, yeah, to come to a future court date on Monday.
Okay. All right. Let's bring the jurors in, please.
All right, adjourned.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back from lunch. Thank you for being back on time. Anyone go to American Deli? No? Okay. I see. You'll survive. It's all right. It's good stuff. The wings are supposedly very good at American Deli. We are ready to continue with the state's presentation of its case. Mr. Griner, if you would call your next witness, please.
The state calls Sharon Lettner.
Ms. Porter, all right. Hello again, Ms. Latners. Same as last time.
Do you swear affirm that testimony you will give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Oh, yeah, I see. Can you state the spelling name for the record?
Sharon Latners, SharonLatners.
Can I proceed?
Please.
Good afternoon, Ms. Lettner.
Good afternoon.
Can you tell the jury where you're currently employed?
City of Atlanta Communication 911 Center,
And what is your current title?
custodian of records.
And can you describe your responsibilities as a custodian of records?
I handle all the incoming 911 calls, audio, dispatch audios. I handle all the subpoena cases for the days, Metro Days office. I handle all the CAD reports.
How long have you worked in this capacity?
Last 25 years.
And can you explain to the jury how you can pull up a particular case?
Our incident number, our address.
And can you also describe what a CAD report is?
CAD report is computer aided dispatch. What's on that CAD report is the date of the incident, call type, location, the information the caller provided to the operator, and the information from the dispatcher, it's from the officers, and the times.
And what is a dispatcher?
Dispatcher is the dispatcher who handle the radios for police officer information. We have 6 different zones in Atlanta, so you have a dispatch for each one of those zones.
And for this particular case, were there any related 911 calls?
Yes.
How many?
2.
And were you able to pull both of those 911 calls?
Yes.
Your Honor, permission to approach it?
Yes, so all the attorneys have continuing permission to approach any of the witnesses unless I tell you not to. So assume you can approach a witness to present an exhibit or anything like that throughout the trial. I'll let you know if that permission has been revoked.
Ms. Latner, I'm going to hand to you State's Exhibit 3A and 3B for identification purposes. And we'll give a moment to take a look at State's Exhibit 3A and 3B. And do you recognize what State's Exhibit 3 is?
Yes.
What is it?
It's a copy of the CAD report for that incident.
And how do you recognize it to be the CAD report of the incident?
Well, incident detail, this is the Atlanta report.
And were you also able to take a look at State's Exhibit 3B?
Yes, 2 911 calls.
And how do you recognize those to be 2 911 calls?
I listened to the calls
When did you listen to the calls?
maybe 10 minutes ago.
And Your Honor, the record, Ms. Leonard, was this record made and kept in the course of regularly conducted business activity?
Yes.
And were the 3A and 3B, the 911s and CAP report also routinely made and kept in the course of business in the business usual practice?
Yes,
And for your information, was 3A and 3B the records made or at or near the time that the calls came in?
yes,
And were the records that you reviewed made by a person with knowledge or from information transmitted by a person with knowledge and who reported such information in the regular course of business?
yes.
Do you recognize any changes, alterations, or deletions to 3A and 3B?
No,
Your Honor, the state would request to move into evidence states 3A and 3B.
Mr. Rowe, any objection to states 3A and B?
No, Judge.
Mr. Monetis?
No, Your Honor.
They're admitted.
Thank you, Your Honor. Permission to publish 3A and 3B?
Granted, and same as with approaching witnesses, if something's been admitted, you are free to publish it without asking, unless there's an objection to publishing made when it is admitted. So feel free to publish.
Thank you, Your Honor.
Lane 911, operator 7359, may I have the address of your emergency?
Yes, how you doing, hon? I just heard like at least like 15 gunshots go off.
Okay,
I'm right here. I'm 4288 Notting Hill.
Lane 911, operator 7359, may I have the address of your emergency?
Yes, how you doing, hon? I just heard like at least like 15 gunshots go off.
Okay,
I'm right here. I'm 4288 Notting Hill Drive.
4288 Notting Hill Drive.
Yeah, it wasn't at my house.
No,
I just hear it in the neighborhood, but that's
yes, sir. I understand the shooting wasn't at your house. We just need a point of reference. And you said you heard 15 gunshots.
Yeah, it sounded like 15. Trying to look out the window, but I don't see nothing on this side. So,
right,
but
right.
Yeah.
Okay. And did you see anyone? Did you see anyone shooting or hear any vehicles driving off?
I didn't. Neither one. Just heard the shots.
No problem. And did you want to speak to an officer when they get out there?
No. I just want to make sure that they come out. I'm HOA president, so part of my duties are calling.
Right. We're gonna send somebody out. Just wanted to know if you want to speak to them, so we'll send them out to the location. Okay.
All right. Thank you.
No problem. Have a good night.
All right. You too. Bye.
Atlanta 911 operation.
4226 Notting Hill Drive. Oh my God, I've been talking to police for the longest. Nobody never did anything. This been going on for months.
Man, what's going on?
Some boys in my subdivision, man. How the heck go to police? They go to police right now. They go to police. Ma'am.
Yes, ma'am.
Listen, I've been calling the police since June. Every time I call, they tell me the investigator gonna call me back. They never call me back. The boys was out there today, and they shot over there where I stay at, and they killed this man. This is not right.
Yes, ma'am. The police are out there. Do you want to speak to them?
Police. This ain't right.
The police are out there. Did you want to speak with them?
Yes.
Okay. Are they near you?
I don't know. He flew past me.
Okay, what's your name, ma'am?
My name is Terry.
Terry?
Yeah.
Okay.
This ain't right. This ain't fucking
And what's your
right.
telephone number, ma'am?
Before this happened, they left their truck and everything.
Okay, and what's your telephone number?
470-429-0951.
I got 470-429-0915.
0951. I gotta go
0951.
around. They driving too slow.
Okay, yes, ma'am. I will get an officer to speak to you. Okay.
This ain't right, ma'am. I kept calling y'all before it got to this.
All right, I will get someone to speak to you. Okay.
And for her, that was State's Exhibit 3B.
You put it on the record that there is.
Now publishing State's Exhibit 3B.
Co-defendant.
Ms. Blattner, as it pertains to State's Exhibit 3A, how many sheets do you have in front of you?
3A. I have 5 sheets in front of me.
And how many CAD reports?
2.
2 CAD reports. And can you describe to the jury why there would be 2 different CAD reports?
You have 2 different 911 people calling in.
And looking at page 2 of 3B, can you look to where it says caller information and read where it says caller name?
I see 3A, I don't see a 3B.
On 3A, the second page, page 2. Do you see where it says caller information? It should be like the 3rd section from the top.
I don't see what you're looking at. That's 1 incident, there's 2 incidents. It just says female caller.
Okay, and what time did that call come in?
It doesn't show the 911 time the call came through. It shows the time that the 911 sent the call over to dispatch.
And what time is that?
At 6:32 p.m. hours.
And for the second CAD report under caller information, can you read where it says caller name?
It says male caller.
And can you also let us know what time that call came in?
Call came through 911 at 6:29 p.m. hours.
And for the first CAD report where it's a female caller, can you turn to the second page where it says incident comments? And can you read the first line?
It advised male shot to the head.
Can you read the 5th line?
I'll advise that subject's not breathing, alert, unconscious.
And finally, can you read the 9th line?
It shows a 30-year-old male. I guess that white, like a W. 30-year-old male, gunshot wound to the neck, not alert or conscious, not breathing at this time.
Can you explain to the jury how calls are dispatched?
Calls are dispatched by priority. We get a 50, that's gonna be a high priority call. You get a call when someone just wanna complain about a dog barking, that's gonna be a low priority call. So 50 is like a 10-minute response time. A dog barking it could be an hour, it all depends on how busy the zones are.
And is it usual to have multiple calls come from one location?
Yes.
And I'd like to go back to the CAD report where it says female caller. On that first page, can you let the jury know what time an officer arrived on scene?
First officer arrived on the scene at 6:38 p.m. hours.
I have no further questions.
Mr. Rowe, do you have any questions for Ms. Latners?
Yes. Ms. Lassiter, referring to, the call at 6:32 PM, you indicated it was a female that made that call, correct?
Yes, sir.
Okay, there's no way of you determining, the identity of that female, correct?
I'm sorry, I didn't hear you.
There's no way of you, determining the identity of that female caller, correct?
No, sir.
Okay.
Say her name in the call.
Were you able to determine the actual address or location the female caller was at, based on the report?
Looking at this address location, it says 4226 Norton Hill Drive Southwest.
Going to the call that was at 6:29 PM, you indicated that was identified as a male caller, correct?
Correct.
And were you able to determine the location of the male caller?
4288 Norton Hill Drive Southwest.
And you indicated that the officer arrived at which location at 6:38, do you know?
First officer arrived at 6:38 at 4226 Norton Hill Drive.
So, the officer arrived at the location that the female caller was at, correct?
Correct.
You said it was usual for, you to receive, 2 911 calls coming from one incident.
If you get shooting in an area, somebody been shot, you're gonna get multiple 911 calls.
Okay.
And they're gonna relate the calls to the incidents.
Okay. And so once you receive, those calls, you in turn dispatch patrol officers?
Now, the dispatch, yes.
Okay. And you testified that, which call identified that a victim was shot in the head?
The female caller.
Okay. And then you said another call identified the victim was shot in the neck.
Just reading from the description.
Okay, which call that came from?
On the call with the female at 6:32, she advised male shot to the head.
Okay.
And you come down. Person not breathing. At same call from the female at 6:37. The unit advised his dispatcher at 6:37, 30-year-old male, gunshot wound to the neck.
So it was the unit that advised the dispatch?
Yes, sir.
So it wasn't the caller, correct?
Correct.
Okay. So the unit referring to the police patrol vehicle that arrived?
Yes, once the unit arrived on the scene, he
Right.
investigate, he sees what's going on, he advises dispatcher what's happening at that location.
It was also the unit that advised that the male was 30 years old and not breathing?
Correct.
So neither caller advised anything about the gunshot or the not breathing or anything like that. These were units.
The first call from the female at 6:32, she advised the operator, 911 operator, male shot to the head.
Okay.
That's the operator.
Okay.
When you get to the dispatcher, that's the conversation between the dispatcher and the officer. The
Okay.
911 call taken on, don't hear the other side of this.
Right.
Two different people.
Okay. So just focusing on the unit
Yes.
as to what they said back to the dispatch.
Yes.
They said that what did they say in particular about the condition of the victim?
That's what he advised his dispatcher at 6:38. At 6:30, 37, 30-year-old male, gunshot to the neck, not alert, not conscious, not breathing. He advised his dispatcher that at 6:30, 7:55 hours. Yeah.
Okay. Did that complete your involvement with this case?
Yes.
Okay, thank you. I have no further questions.
All right, Mr. Monetis, any questions for Ms. Latners?
Yes, Your Honor. We heard one of the callers, thank you for being here. We heard one of the callers say that they killed somebody.
I'm sorry.
Is it true that we just heard someone on the call say they killed somebody?
I didn't hear anybody say they killed someone. Well, she did holler, they killed.
That's what
Female
I'm
did,
referring to,
yes.
yes, thank you. And you don't have any personal knowledge about who that they refers to, correct?
No.
Okay. And we talked about the identity of the caller. Did you hear the person say, my name is Carrie?
She said Terry.
Oh, Terry, okay. I'm sorry, I thought I heard Carrie. Now my last topic. You've listened to quite a lot of 911 calls, correct?
Over 1 million or so, yes.
You said over 1 million?
A year, yes.
Oh, okay, wow, thank you for that. And it's true that sometimes people who call 911, they refuse to tell you who they are.
Correct.
Okay. Those are all my questions, Your Honor.
Ms. Porter, any redirect?
Very briefly. Ms. Latners, on the read, you talked a little bit about priority calls and you said something about a signal 50. Can you explain to the jury what is a signal?
Atlanta Police, we have over 60 signals. We use plain talk now since the incident of Brian Nichols. So Fulton County, everybody, the roundings, the police department know what we're talking about. So 50 is a person been shot. 25 shots fired.
Mr. Rowe, anything else?
Okay.
Mr. Monetis?
No, Your Honor.
Okay, questions from the jurors? Oh, all right, Ms. Latners, thank you for your time. Next witness.
Officer Jack Carter.
Please sit in, raise your right hand. You swear affirm that the testimony you will give is true, the whole truth, and nothing but the truth so help you God.
I do.
You don't have to.
One more thing before you sit. I'm sorry, officer. Mr. Griner, if you don't mind there's some paperwork up there that I think is exhibits from the previous witness. We will gather the evidence that fits on the corner of Ms. Rivers' table. And if you'd also move the easel, when someone's questioning from the podium now, the easel's sort of direct line of sight for the witness. Unless you're going to be using, if you're going to be using it with this witness, leave it right where it is. But when you're done, we need to get it out of the way just so it's not blocking. You can even move it over there.
Yes, Your Honor.
Sorry, you can take a seat now.
You state this letter for the record.
Name is Jack Carter,
JACKCARTER.
Good afternoon, sir. Thank you for being here. Can you please tell the jury where you currently work
City of Atlanta Police Department,
and how long have you been with the City of Atlanta Police Department?
5.5 years.
Can you tell the jury a little bit about your law enforcement training and experience?
It's a lot. I can't say what exactly you need.
Let's go through some basics. When did you go through the police academy?
I graduated June 19, 2019.
Are you a post-certified officer?
I am.
Can you explain to the jury what post certification means?
Post certification gives me the ability to be a peace officer in Georgia.
Okay. What kind of steps do you have to go through in order to become a post certified officer?
6 months training in the academy.
Okay. And at the academy, what are the just generally the types of things that you might learn or study?
Night driving, firearms, basic law. Yeah, bunch of things.
Okay, so every year, do you have to do anything to maintain your post certification?
I do.
Can you explain that to the jury?
I go to in-service for a refresher of mainly every tool that I have on my belt or anything that I use in the field.
And when you say in service, are you talking about specific training classes that you have to take?
Yes, we get if we're getting a new firearm, new taser, anything that we get new or anything that we haven't used, we get trained on it again, just in case we haven't used it or may deteriorate the knowledge of it.
In the course of the year, can you give the jury a sense of how much training you might have to undergo in order to be in your current status?
In 1 year?
Yes, just in a single year.
Roughly about 60 to 70 hours.
Can you tell the jury, were you on duty back in September 13th of 2021?
I was.
And can you tell the jury back at that time what your job responsibilities were, just generally?
I was a beat unit. I was on evening watch in zone 4. I was assigned to beat number 9. And it was anything in the zone 4 area, which typically B sector, which is from Cascade to Kemp Creek, all the way from Lee Street into Fairburn Road, generally.
Okay. The beat that you would work, that whole area, is that in Fulton County?
It is.
You mentioned tools that you might use in your job. Is there any special training that you have to undergo, for example, to use the handgun that you use that you wear on your belt?
Handgun is standard for every police officer that's employed by City of Atlanta, but we have additional firearms that we also use.
Can you tell the jury a little bit about that?
All right, so I am rifle certified as well. I carry a rifle. It took me 80 hours of additional training to obtain the rifle, and I have to take an 8-hour refresher every year to maintain that rifle certification.
Tell the jury what happens if you get out to the scene of a murder or some other potentially active scene, what you might do, given that you are rifle certified.
Well, yeah, at that time, I was one of the only ones that was rifle certified. So if something comes up where the suspect can still be on scene, or it's a homicide or something involving a firearm, they may call me to the scene to have crowd control, just make sure everybody else is particularly safe or our officers are safe. And the rifle gives me the ability to do it at a safe distance with more accuracy if I need.
Do you recall getting dispatched out to a particular location? This case back in September 13th of 2021?
I do.
Can you tell the jury what happened, how you got the dispatch, and what occurred once you got out there?
We received a call that it was a person shot, possibly to the head, and it was on the address of Notting Hill. Notting Hill is like its own neighborhood because it's one way in, one way out, and it's like 2 or 3 streets total over there. Very familiar with the area. I got the call to go over there, and once I arrived, I saw a gentleman that was laid down on the ground in his driveway, unresponsive. And we were trying to secure the area, putting up caution tape around the best places we could to try to keep everybody away, but it was a lot of people outside at the time.
And when you have a lot of people outside in an area like this, what are the basic job duties that you and other officers try to do?
Oh, first thing is try to keep the scene as safe as possible. Well, say that's the second thing. First thing is try to keep everybody safe after a shooting. We don't know who the suspects are. We don't know if they're still there. We don't know if it's still a dangerous situation. We don't know if it stemmed from an argument or something like that. So try to keep the people, at bay. Try to preserve the evidence of what we have. So we tried our best job to put the crime scene tape down as wide as possible, so we can try to just secure the area and then call for fire or ambulance to come out and try to help if they can still.
And you said that you got a call out there. Is this a call from a 911 caller or is this from your dispatch?
It was from dispatch.
I'm gonna hand you what's been marked as State's Exhibit 1 and ask if you can identify that, or if you recognize that.
Yeah, this is the Notting Hill neighborhood. So Notting Hill Drive, right off of County Line at Hamilton.
Okay, and is that a true and accurate depiction that you're aware of the area?
It is.
All right, I'm gonna show you what is also been referred to as State's Exhibit 1, which is more or less a blow up. And would you agree that what I'm holding in my hand is larger exhibit is just a blown up version or a large version of what you have before you?
It is.
True and accurate copy?
Yes.
Your Honor, at this time, we're going to move to admit State's Exhibit 1 and 1A. We'll call this large Exhibit 1A.
Mr. Rowe, any objection to states 1 and 1A?
No, Judge.
Mr. Menettis?
No, Your Honor.
Admitted.
So, can you just kind of describe to the jury, please, what is shown? I'm going to label this as 1A. Can you just describe to the jury, please, what is shown in this exhibit?
Like I said before, it's the Notting Hill Drive neighborhood. It's right off the county line. It's a little bit further south from Hamilton. It's one way in, one way out, and we rarely get calls there. It's just a neighborhood in itself.
Is this entirety that is shown on this exhibit, State's Exhibit 1A, is that all in Fulton County?
It is.
Okay. When you got to the scene, it may help if you step down. When you got to the scene, can you just kind of direct the jury to where you went and what you saw when you got there?
I came south down county line, and I went straight down Notting Hill. Got to about this area here, stopped my vehicle, got out on foot, and I saw a gentleman in this driveway here that was laying down on the ground, bleeding from the head.
Okay. Were there any other people around that gentleman on the ground?
There was a gentleman sitting here on a green box. I believe it was a green box. Older gentleman, I think he lived at this location. There was a Caucasian lady with tattoos that was speaking to me right here, telling me what was going on. There were some more people around this area. And we had another set of officers that was here at the beginning of this year.
Okay, so kind of for the record, let's put some numbers if we could. When you got there, let's assume that this is 4226 right here. Was the body in front of 4226?
Yes, in the driveway of 4226.
And you mentioned an older gentleman sitting on a green, I guess, electrical box?
I believe so.
And was that gentleman over there sort of at the corner, right at the edge of the driveway?
Objection, Your Honor.
I can move right.
Okay. It's not leading. So you can continue if you want. You don't have to rephrase, but I'm overruling it unless you were going to end it with, isn't that true? But go ahead.
Thank you, Your Honor. Can you just more or less describe the area where the older gentleman was sitting on the green box?
Well, it was right by the corner, so I believe it was right here. He was an older gentleman, shirtless, black pants.
And is that at the corner of Nottingham Drive and Oxford Court?
Yes.
Okay. And so I believe you also mentioned some other officers that were on the scene. Can you just kind of describe what units they may have been in or where they may have been distributed?
Okay, so our vehicles were kind of blocking off Notting Hill from going back further toward the house. So our vehicles were here. I believe Officer Malcolm, Officer Smith, and Officer, I can't remember the other officer's name, but they were here talking to the people that were outside in between this area. And Officer Sample Britton was also along these lines talking to the people here.
So you all spoke with people who were outside?
Yes.
Is that correct? What was your primary duty when you got there on scene? You know, different officers talking to different people. What was your primary duty?
Mine was to stay around the area where the person was shot, and I spoke to the person who was with him at the time.
Is that the white lady?
Yeah, white lady, tattoos, bigger lady.
Can you describe her overall demeanor, best you
She was more so shocked at what was going on.
Objection, Your Honor, speculation.
Overruled.
She was more so shocked. She was telling me what was going on. She was kind of yelling at me, trying to get the story out, but it was just emotionally traumatizing for her, I would say. So,
Sir, did you see any physical evidence anywhere in the driveway or the street down there in that part?
I did. So along this area here in the driveway, I don't know if it's shared or not, but it was shell casings. And I kept telling everybody that was walking through it that there were shell casings in the driveway. So the gentleman that was on the green box, he tried to go into this door here. I told him, hey, you're kicking these shell casings. The firemen that arrived on scene, I told them as well. And then an additional officer, I believe I told them too.
And what's the general reason why you would want to kind of preserve things where they were laid at that time?
Well, how the story came out, it said that someone from this area was shooting back at someone in this area. That was the general thing. So if that was true, then the shell casings would be over here. But seeing how we have them, however they're falling, we want the people to come investigate the best way possible. So I don't want to disturb them at all.
Okay. Is it your role to pick up shell casings and collect them from a scene like this?
It is not.
Can you tell the jury whose role that would be?
We would have ID techs come out. So ID would come to the scene, they would take photographs of everything that's out there, every bit of evidence, and then they will be the ones to collect it and give it to whoever they need.
Yeah. You mentioned there were officers out here speaking with people who were standing around. Are there detectives who also do that sort of work?
Detectives come after we did our primary investigation. So we would talk to whoever we need to first, see what we have, raise them on radio, tell them that we have a possible homicide or a homicide if we can confirm it at the time. And then they will come out and they would get the information from us. They will also talk to whoever is outside if they're still there or if they're able to speak to someone, and then they would do their investigation leading from there.
During the time that you were down there at the scene, did you leave any area other than this one down here at Nottingham Drive and Notting Hill Drive and Oxford Court? Did you leave this area at all?
The furthest I went was possibly 4215, so I'm here, but I never left this particular area.
And I'm gonna ask you a couple of questions that you can probably have a seat for right now. So you mentioned cartridge casing. Can you explain to the jury just generally what we're talking about when you talk about a cartridge casing that you observed on the ground?
Oh, the casings are, they are exited out of the firearm after the firearm has been discharged. So anytime a gun is shot, the casings is going to fall out of it if it's an automatic.
And so not everybody has the same level of experience on the jury with firearms.
Okay.
Some shot a firearm, some not shot a firearm. Can you explain just generally when we've got a live cartridge and a live round put into a gun and just what happens when the firing pin hits the round?
Your Honor, objection calls for an expert opinion.
How many times have you fired a gun?
Me?
You.
About 5,000.
Okay, you can answer the question.
Well, Your Honor, as to firing pin and the internal mechanisms of the gun.
If it gets technical, you should renew your objection. I think right now it's the basic mechanics. There's an explosion and the bullet goes up. I'm not testifying. We'll see where he goes. But if it gets in any way technical, please do renew your objection. I don't get the sense that that's where we're heading with this witness. But they ought not to substitute someone they haven't noticed for someone they have. All right, Mr. Griner, ask again.
Can you generally explain what happens when we have a live round and it is fired through a semi-automatic weapon? What happens to the projectile, cartridge casing, just general?
Okay, for a firearm, if you pull the trigger of a firearm, it's going to shoot out the projectile. If it's not a revolver, it's going to get rid of the shell casings and get ready for the next live round. So the shell casings are going to exit out of the firearm every time it's shot. That's what it said.
And that's what you saw down here? You say cartridge casings or casings, that's what you saw?
The shell casings, yes, sir.
Shell casings. All right, so are you familiar with this area up here along County Line Road? And whether or not there is a fence along the road?
Yes, I'm very familiar with it.
Gonna hand you what is marked as State's Exhibits 4 through 15. I ask if you can look at these and tell what they show.
You said 4 through 15? The fence?
Other ones too.
I'm familiar with all of them.
All right, can you just, in a sentence or so, just tell what these are generally?
Okay, number 4 is the beginning of the gate to the neighborhood.
You don't need to narrate each. That may happen with questions, but generically those 11 photos, however it is, they show you what?
This is the gate furthest east that's around the community along County Line Road.
Okay, so show the fence area along the road?
Yes.
Are these true and accurate depictions of what the fence looks like?
Yes.
All right, Your Honor, this time I'm going to move to State's Exhibits 4 through 15.
Mr. Manettis, any objection to 4 through 15?
No objection, Your Honor.
Mr. Rowe?
No objection.
Admitted.
You, so we're going to put 4 up on the screen.
It should be, officer, make this easier for you so you don't get something happening to your neck. If you'll click stay muted on that screen in front of you, tap stay muted. Okay, that's a touch screen that he can mark on if you need him to signify anything. Lawyers?
All right, let's start with State's Exhibit 4. You just generally describe what that shows.
That's the beginning of the fence area along County Line Road.
Okay, let's compare that to State's Exhibit 1A. Can you just generally point where that is? Okay, so you pointed to the top part of 1A. Is there, I see on one side we've got chain link fence, which looks like barbed wire and a lot of kudzu at the top. And then to the left, we've got brick, looks like a brick and a post here and all of that. Is that kind of connected and they're running back along the property line, best you know?
The fence for the Notting Hill side or for the business? That's a bus business.
Well, I mean, they kind of connect. I mean, does either fence run back down on?
That I'm unsure.
Okay. Let's look at State's Exhibit 5 then. And can you tell what's shown in State's Exhibit 5?
State's Exhibit 5, that's a continuation of the fence going back south on county line.
So to the right part of Stacy's.
Yeah, but this is your new video, so if he trying to say it's a gate right now, you can get on the back of the neighborhood, just new
Yes.
pictures.
Okay, let's look at 6, please. All right, and 6, can you describe that, please?
That's an extension of the fence for Notting Hill, or from the county lines side, southbound.
So if we compare Stacy's Exhibit 6 with Stacy's Exhibit 1A, just generally speaking, where are we looking at? So these are like 4308, 4310, that kind of, those buildings.
Yes.
Those towers. And Stacy's Exhibit 7, please. Basically a continuation.
Yes.
All right, and 8. There's a lag without backs. Can you tell the jury what is shown in Stacy's Exhibit 8?
8 is the entryway to Notting Hill Drive.
And on Stacy's Exhibit 1A, what would that be? All right. And Stacy's Exhibit 9, please. Show us in Stacy's Exhibit 9, or tell us in Stacy's Exhibit 9.
It is, again, the entryway to Notting Hill, which is a little bit further south than number 8. No, it's west of number 8, so it's leading into it. Yes.
And Stacy's Exhibit 10, please.
Number 10, same thing. It's deeper into it, further west.
Can you look at Stacy's Exhibit 1A and tell approximately where we're looking at? Yes.
Number 10 will be here.
Okay. So just, I guess, for the record, we're talking about Notting Hill Drive, where it kind of circles back around and connects with this entryway into the neighborhood. This general area.
Yes. This is the only way in and only way out. So number 8, 9, 10, according to your chart.
Okay, thank you. Let's look at 11, please. What does 11 show?
11 is the furthest south side of the entryway. So it's the same entryway as number 8. It's just the south side of the street.
Okay. And let's look at number 12, please.
And number 12 is further south down the same street, which is county line.
Okay. And comparing 12 with 1A, where are we approximately on 1A? And let's look at section 13, please. More or less a continuation.
Yes.
And 6 is at 14. And where are we on 6 is at 14?
That is the end of the fence furthest south down county line.
All right, and if we compare 14 with 1A. Okay, and let's look at 6 is at 15. You see 15 kind of where that is?
Yes.
Is that basically turning the corner?
Yes, it is turning the corner.
Okay. All right, thank you. Was there any body camera footage that was recorded that day when you were out there at the scene?
Yes.
And have you gotten a chance to review that body camera footage here this afternoon?
I did.
And what you saw, what was presented to you, is that a true and accurate copy of the body camera footage that did it depict things accurately as they occurred back on the date that all of this did occur?
It did.
All right.
Your Honor, I'm gonna have that marked as State's Exhibit 62.
62?
62. And I'm gonna move to admit that into evidence. The body cam.
Officer Carter, body cam, exhibit 62, okay? And you're tendering it now?
I'm tendering it.
Mr. Rowe, any objection to state 62?
No good.
Mr. Monetis?
No, Your Honor.
Admitted.
Approximately how long were you out there on scene?
Roughly 3 hours, a little bit over 3 hours.
We're not gonna play 3 hours, but we're gonna play a few minutes. Okay, so let's start off by noting that you're here. What's the time stamp on the left lower part of the video? Starting at what time approximately?
8 minutes and 27 seconds.
Okay, and is that?
So we're clear for the record. That's a timestamp from the media player. That doesn't mean it's 8:27 p.m. We can work through clock time if you want, but I'm not seeing on the screen a clock time. There's the counter time so that we can make a good record of where in the video did we start and stop the video replay, but that's not clock time. I believe. You should correct me if I'm wrong.
That is correct.
Okay.
We're 8 minutes and 27 seconds into the video recording.
Got it.
And so up until that time, can you just generally tell the jury, is your body cam always working, or do you turn it on, or how that might actually be triggered?
I hit on this particular day, I believe hit my lights and sirens. It automatically cuts on for me in that case.
So when you hit the lights and sirens in your car, it automatically turns on your body cam that is on you're wearing on your vest.
Yes.
Okay. And so were you driving to the scene during that initial 8 minutes and 27 seconds?
The 6 minutes and 27 seconds, we have a 2-minute buffer on it. So it's going to start at the 2-minute mark. It's going to still record, but it's going to start recording at the 2-minute mark, which it took me 6 minutes and 27 seconds to get there.
Okay, very good. Okay, well, we're going to play it forward for just a few minutes, and then we'll I may stop and ask you a few questions about what's occurring. A little technical issue.
Right, we need more people out here. There are tons of people. Okay, I copy. Is there any additional unit that can clear? Any additional unit that can clear? Run up to 50. 26. Copy. 4-1, give me 1 minute. I'll be headed that way. Where you at? 4-1, I copy. 34, already 8, 34, hold so I thought it was. 4-4, copy, 12, train route to the 50.
What are you doing right here?
Getting my city issue rifle.
Don't. Keep that there. We'll get. We're blocking everything off.
We see the older gentleman you mentioned earlier, sitting on the box.
Yes.
And the lady was passing.
Yes.
561382.
The son? Who's son?
Let me talk to that man. That deceased, back on the driveway, sort of back in the background.
It is.
There was a white car sitting on the corner. They were up there taking pictures of the white car. The only thing I know, there was gunfire. There was gunfire.
Hey, come back this way. We don't want you to go that way.
That's the way he just came out.
I got you.
You mentioned earlier that your role at this point is to sort of maintain the scene, safety first. Were you attempting to give any kind of formalized statement?
I was trying to speak to the woman, the Caucasian woman with the tattoos, but she was unable to talk clearly to me. This gentleman here, I guess the guy in black shirt was trying to go inside, but I wouldn't allow him to walk through the driveway.
Like that right there. We didn't have nothing to do with this. We came out my house to go to the store.
3401 radio, I'm code 12 and route.
Okay.
Okay, wait, it's too many.
Please let me talk. This is my baby dad, grandpa, please. Yeah, y'all gonna talk.
What are the remarks on the code?
You mentioned shell casings earlier. Were there shell casings there on highway area?
No, when I first got on scene, I noticed a bunch in the driveway, and I wasn't able to kind of figure out what all of them were, but I was trying to just keep my eyes on them.
No, we're gonna come out the store to go to the store.
All right, so we're gonna have you come this way, because we're gonna get everybody out the. I got you, but we're gonna have everybody get out the crime scene. It's crime scene right now. We don't mean any disrespect by, but we gonna have you guys.
At this point, trying to direct them to basically get out of the crime scene.
Yes.
He's on a machine.
I got you. We get shell cases out here. We had a lot of shell cases out here. You're kicking them. We want you
How about
outside.
the shell casings here?
Yes. See, listen. Hey, listen.
Just back up on the house and go to get his oxygen.
Hey, listen. If you go in the house, stand in the house for me.
Yeah.
Okay, do that. Don't kick anything while you're going down.
Did you let that older man just go back into the house? You wanted to get back into?
Yeah, they said he suffered from COVID, so he was on a machine, so we didn't want to have him outside. So we decided to let him go back in the house and just, as long as he stayed in the house and didn't disrupt the crime scene, he would be fine.
I know. I'm not really paying attention because the little girl gave me a hug. All of a sudden, my boyfriend pushed and he heard gunfire.
And do you know whether or not detectives later spoke with this Caucasian woman?
That I do not know.
Okay. Essentially, did you, from this point forward, did you more or less stay, you said the video's 3 hours, you stayed kind of in this area, you sort of maintain this area?
Yes.
And do you remember when the crime scene got out there to start picking cases up and marking things? Do you have any idea?
Crime scene cannot come out until I guess the ME call. I'm not exactly sure what time frame they were called at that point, but I know they arrived. They can't take pictures of everything until everything is already set in its order.
At this point, would you describe the number of people up in the street who can see? Is the area safe and secure yet, or still kind of chaotic?
This particular area that I am in is safe and secure. I don't have anybody walking by me. If they were intercepted. The other part was a little further east, so where we're walking to now. They said that was part of the crime scene as well, so we had to get an additional officer to kind of keep that area settled.
And that's why we got the crime scenes there across the street.
Yes.
So we're clear. Kind of looking at where we paused, and we have paused at 14:03 into, that's the video counter. And approximately, if you look at State's Exhibit 1A, and you can just point generally to where you are currently right now. As shown in the video. So you're more or less right from Unit 4223, kind of intersection of Oxford Court and Notting Hill Drive. Is that, yes, that general area?
Yes.
And we had a crime scene tape across the street somewhere along there?
Yes.
All right. And then this other area up here, which is where Notting Hill Drive loops back into itself near the entrance, is that where things were a little bit busier?
Yes.
Sir, thank you very much for coming in this afternoon. I don't have any further questions. Counsel for the defendants may.
Mr. Monetis, you're already up. Do you have questions for Officer Carter?
Yes, Your Honor, thank you. Now, you mentioned talking a little bit about shell casings. It's fair to say that they're pretty lightweight, correct?
Correct.
And they can be moved around easily because of that.
They could.
And that's why it's important not to contaminate a crime scene, correct?
Yes, sir.
Okay, and then you talked about telling some firemen to stop walking in a certain area?
Correct.
And you also said you were telling some certain officers to stop walking around a certain area, correct?
Correct.
Okay, so about how many total if you had the firemen and the officers together?
How many times? Total like probably about 10 times maybe, because it was too many people.
Okay, understood.
Were you telling some of the same people the same thing twice, or you think it was 10 different people?
10 different. When the firemen came, I think it was 6 of them.
Hmm.
And then maybe 3 of my own officers, the one guy, the shirtless guy, and
The guy with the black pants?
Yeah.
Yep.
Okay. And this is all before the crime scene photographer had a chance to take any pictures, correct?
Correct.
And that's because, as you shared with us, the crime scene photographer can't take pictures until the medical examiner is there.
Correct.
And the medical examiner wasn't there yet.
Correct.
Okay. And about how long did it take for the medical examiner to get there?
That I'm gonna say.
Okay.
I'll say roughly 2, it was after 2 hours. I can say that.
Okay. And so then you show up and you give instructions to various people to stop contaminating the crime scene, correct?
Correct.
Okay. And you said it took you about 6.5 minutes to get there?
Correct.
So that's 6.5 minutes before you're giving anyone those kind of instructions, correct?
Correct.
And I also talked about the only one way in and out of the complex, correct?
Yes.
Okay, and that's certainly a reason why the crime scene tape was put up, because driving over a scene can contaminate it, correct?
Correct.
The car driving can move these lightweight shell casings, correct?
Correct.
Okay, and again, for 6.5 minutes, there's no one to secure that area.
That I'm uncertain on. I
Okay.
wasn't the first one there.
Okay, but you testified that the crime scene tape hadn't been set up yet for the eastward area.
Crime scene tape was set up in certain areas.
Right, now, what I'm asking is, when I said asked you, maybe I just heard you wrong, wasn't there a time where you said you started to secure another area of the crime scene, the second area they needed to secure? When you said
Yeah.
east?
Yeah.
Okay,
I see what you're saying now.
okay, right, and so when you arrived, that had not been secured?
Correct.
Okay, and that had not been secured until you instructed people to start securing it, correct?
I don't know if it was me that did it. They told them to, but they started after I got there.
Okay, someone.
I guess.
Okay. So I guess what I'm getting at is it did not start being secured until after you got
Correct.
there. Okay, and you say that's the only way in and out of the complex, correct?
Driving wise, yes.
So every single car that would have to come in or go out that's beyond that westward part or driving out to the exit from before the area would drive over that unsecured crime scene, correct?
Yes.
Okay. And you weren't there at the time of the shooting, correct?
Say it again?
You weren't there at the time of the shootings?
No.
Okay, so you don't have any personal knowledge of where any one person might have been standing while shooting?
Correct.
Okay. And you're not involved in investigating that after the fact, right? You're just on patrol?
No, I'm not.
Now, you're trained in writing reports, correct?
Sorry?
You're trained in writing reports, police reports?
Yes.
Where you describe the investigation, what was found,
Yes.
who was talked to, things like that, okay. And the reason for writing those reports is that they might be relied on by another investigator.
Correct.
They might be relied on a DA.
Correct.
They might be relied on 3 years later during a trial when you might have to refresh your memory.
Correct.
They might be relied on at a time when, knock on wood, you're not available for some reason.
Correct.
Okay. And you're not aware of any reports describing searching that hill area for shell casings?
I'm not aware of any of that.
And you weren't involved in searching that area?
No.
Do you know who might be involved in searching that area?
The Hill area? If K9 was involved, maybe? That I don't know.
Okay, are you aware if K9 was involved at any point?
Not to my knowledge.
Okay. Now, you talked about how, for pistols, the cartridge ejects when it's fired, correct?
Yes.
And being on patrol, you certainly had the chance to investigate many, many violent crimes, correct?
Correct.
Almost too many to count?
Yes.
Okay. And so you're aware of times where people have shot a gun from within a car and the shell casing ejects into the car?
Yes.
And in your training experience, that might even be something that a criminal does to make sure shell casings are not left behind?
Yes.
They can shoot with the gun within the car by shooting out the window, correct?
Correct.
Okay. And you're not aware of whether or not that happened in this case by anyone?
I am not.
Okay. Now, I want to talk about flock cameras. Are you familiar with flock cameras at all?
I am.
Okay, and flock cameras are cameras in various parts of the city that have a sort of like a facial recognition, but it's like license plate recognition. So it knows when a license plate goes by, correct?
Yes.
It takes pictures of that.
Yes.
And those are often used in investigations like this, correct?
Correct.
Okay, and did you collect any flock data from the entrance of the complex or anywhere around it?
I saw myself search, but I don't even know if I reflected. I wouldn't be the one to say.
Okay, so it's possible then that you did collect flock camera footage and then.
It is possible.
Well, it's possible that you forgot about it.
Mhm.
Okay, and that's why it would be something you'd include in the report.
Yes.
And you didn't write a report including that.
Correct.
Okay, are you aware of the search for flock camera data being sought after by anyone else in your department of the investigation?
I'm not aware.
Okay. And if that was something somebody did in your training experience, you would expect that to be in the report?
No.
Okay, so you would expect the officer to collect crucial data about a murder case and then not write it in the report?
The flock locations aren't given in any reports.
Well, right, but they're collected to be used as evidence, correct?
Correct.
Okay, and
Someone
then,
would mention a vehicle if it was captured on flock, but it wouldn't give the location or the way that they collected it.
yeah, I'm sorry, I might have not explained the question well enough. What I'm asking is, if you or someone else sought after flock data, that's something you would include in a report, like, hey, at this date and time, I sought the flock data from this intersection, right?
No.
Okay, so how would we know where anything was done or how?
We're not able to, we wouldn't be able to give you the location, date and time of the camera it hits. We don't give that location. We would say, it was in the area of, we can say it's around this location, but we can't say it hit on the corner of, let's say, for example, Hamilton and County line.
Okay, but isn't this used as investigations to establish the locations of vehicles?
It is, that's why I said it will be in the area of.
Right,
We
and
don't
then,
give direct locations.
right, and then what you shared with us is that it's a camera that's taking a picture of the license plate, correct?
Correct.
And so what you're telling us then is that there's no data that's ever stored or saved or.
It's not what he's saying. We're going around in circles. They don't reveal the locations of the cameras. It's like revealing the identity of a CI. They're not going to tell you where the camera is.
Well, right, Your Honor, I understand that. What I'm asking is, are you saying that's just not accessible, period?
It's for us, it's accessible.
Okay, that's all I'm asking.
Okay.
Okay, and while the report might not say the exact area for security reasons, the exact location, it would say the area.
Correct.
And that's because a certain license plate might have been in the area,
Correct.
and that might be significant.
Correct.
And a license plate can be connected to an individual, correct?
Correct.
And that might be significant.
Absolutely. Yes, correct.
And last area of questioning. So when you got out of your car at the scene, you got out a rifle, a pretty serious rifle, correct?
Correct.
And you got that out for your personal protection, correct?
Personal and everyone else, that's what I'm saying.
Right, because somebody could get attacked and you would use that gun to protect them
Yes.
and yourself.
Yes.
Those are all my questions, Your Honor.
Mr. Rowe.
So when the dispatch came, were you the first officer that was dispatched to the scene?
No.
Okay, so when you arrived, there were officers already present?
Yes.
Okay. All right, and how many officers was present when you arrived?
I do not remember.
Okay, as far as the deceased, the body, was there any officers at that particular location?
No.
Okay. Where were the other officers that were already there?
Some were setting up crime tape, and some were trying to diffuse the crowd that was growing and growing.
In your testimony is that none of those officers started to secure the crime scene, correct?
I'm sorry?
I said your testimony is that none of the officers that was there before you started to secure the crime scene, correct?
I said they were setting up crime scene. I just said.
Okay, but you just testified that there was several firefighters and other officers walking through the area where the body was kicking.
Correct. Firemen and ambulance are allowed to come to the crime scene to help the victim if possible.
Right, and you said that before you said anything, no one was securing that crime scene.
I'm sorry, I didn't say that.
Okay, what did you say?
You said, where were they? And I said they were setting up crime scene. The number one thing that you want to do is set it up as big as possible so nobody steps into it, just in case you could find or whatever. They didn't have that particular area where I was at.
Right.
Because if they block off further than that, no one would come to that particular area.
Okay, well, that's the area I'm asking you about, the particular area where you said that firemen was walking through that area and other officers, and you told them to stop kicking the shells. That's the area I'm talking about.
Okay, so restate your question.
Okay, did anybody secure that area before you came?
Yes.
So just so we're clear, you were standing at the top of a driveway, saw your body cam, you're interacting with some folks, you're trying to speak with she's actually trying to talk to you, the woman with the tattoos. Was that within a secure area?
Yes.
Nonetheless, fire and police can walk in there because they can be inside the secure area.
Yes.
And you're saying to people inside the secure area, hey, watch out where you're going, there's shell casings on the ground.
Correct.
Okay.
Okay, is that what you're saying, sir?
Yes, sir.
You indicated that not only were there firemen and other officers kicking the shell, you mentioned the older gentleman as well that was walking through that same area, correct?
Yes.
So when you saw those individuals kicking those shells on that driveway, what did you do other than telling them to stop? What did you do to secure that sub area? Did you do
Can
anything?
you repeat? Because you said they were kicking the shells. I never said they were kicking it.
Okay, what did you say? I'm sorry.
I was avoiding them from kicking. That's what I was telling them about. I never said they kicked it.
Okay, all right. So what did you do once you saw them walking through that area? Did you do anything other than tell them to stop?
No.
Okay. And why is that?
One gentleman went inside the house, another gentleman exited the area.
Okay, so when you left, did you just leave everything just like it was? When you finally left the scene?
You mean after the shell casings were collected? Or?
When you left the scene with the shell casing collected before you left?
Yes.
Okay, all right. So you just stayed on the scene to wait for the shell casings to be collected?
Yes.
Okay. You said there was a Caucasian woman that was on the scene that was speaking to you, correct?
Yes.
So did you conduct an interview of that particular individual?
Preliminary interview, yes.
Okay. Did you interview the older gentleman that was sitting on the box, the electrical box?
I didn't interview him.
You said there were a lot of people on the scene. civilian people, correct?
Correct.
Okay, did you interview any other civilians that was on the scene?
No, not to my recollection, no.
Okay.
Oh, wait. Yeah, it was a woman.
Okay, all right, do you know her name?
I do not.
And where was she?
She was at the intersection. She was a dark-skinned female, red t-shirt. She was speaking to me about getting a tag on a vehicle, actually showing me a picture. She's in here as well.
Okay, and why is it that you didn't interview all the witnesses?
Why don't I interview them?
Yes.
Well, I didn't know the story. I didn't know what's going on. I'm not the primary officer. I'm assisting. So if I can just collect information to give to them, then that was my role at that point.
So which one did you decide to interview? You said
The ones that were right next to the body.
So that is the Caucasian woman. What about the older gentleman? He was right next to the body too, correct?
The gentleman that went inside the house, or the
Yes.
gentleman with the black shirt?
The gentleman that you said that was sitting on the box, that's the box.
Okay, the gentleman without the shirt.
Yes.
He went inside the house and was not allowed to come outside, so someone else will be interviewing him.
Okay. So how many people did you actually interview? I know the Caucasian woman, her and just the other
Yes.
woman. And you expected the lead investigator to interview everybody else?
Well, the detectives are called after we initially get the primary information.
Okay.
We give that over to the investigators and they go from there.
Okay. All right, when did the detective come in?
After being raised on radio, after we get the crime scene set up, the area secure, make sure there's nothing, harmful for them, then they'll arrive. Time frame it can vary.
Okay, what was the time frame on this?
I'm unsure.
Did they arrive before you left?
Correct.
Okay. And do you remember, you're not sure how long that was?
No, sir.
Okay. And what if a witness leaves?
Got a little more on the question? What if they leave?
You arrive on the scene, correct?
Yes.
And when you arrive on the scene, there's a dead body, correct?
Correct.
And there are people around when you see the dead body, there are civilians around, correct?
Correct.
And you choose to interview some and some you don't interview, correct?
Correct.
All right, well, what if one of those people that was there leave before the detective get there?
Well, the detective would do their investigation to see who was there, who knows anyone else that was there, or primarily could assist in the investigation. So they would do their due diligence. I just tell them who I saw, and they'll review my body cam as well.
You testified there were other officers also talking to different people on the scene. Is that correct?
Yes.
All right, so, the other officers that were on the scene, were they talking to the people that were further on down the street?
It was a mixture.
Okay. How many civilians would you say was out there on the scene when you arrived?
Around 15, I want to say. 15 to 20.
So your job obviously is not collecting the evidence, right?
Correct.
Okay, so you don't collect, say, shell cases or anything like that, correct?
No.
And it's not necessarily your job to secure the crime scenes, right?
Depending on depending on the scene, if there's a firearm out there, cool, I'm trying to document on my body cam, pick it up, because there are people walking around, so I will secure something like that.
Did you get, have any more involvement in the case from the point that you arrived on the scene after you left?
No, sir.
When you got a statement from the Caucasian woman, did you put it in writing or did you just provide the information to the detective?
Provide the information for the detective,
In written form?
body cam form.
What about the interview with the other female you said you talked to further on down the street? Provide that as well?
Yes, also on body cam.
That's all I have, Judge. Thank you. Thank you, sir.
Any redirect?
No, Your Honor.
Any questions from the jurors for Officer Carter? No? Okay, officer, thank you for your time. Appreciate it. Next witness.
So, Jason Teague, investigator Jason Teague.
Please sit in your place, raise your right hand. We swear affirm that the testimony you'll give will be the truth, the whole truth, and nothing but the truth of God. What was the address? Can you state and spell your name for the record?
Sure. Investigator Jason Teague, that's Jason, last name Teague. Sir, thank you for being here. Can you tell the jury where you're currently employed? City of Atlanta Police Department. I'm assigned to the Homeland Security Unit as an electronic surveillance specialist. Can you give the jury a sense of your law enforcement training and experience? I've been with the Atlanta Police Department for 26 years. Of those 26 years, I've been a detective or investigator for 20 of those years. I've been assigned to in patrol out in Zone 3 as a patrol officer. When I made investigator in 2004, I was assigned to Zone 5 investigations, where me and a couple of investigators handled the lion's share of aggravated assaults and robberies in the downtown area. 2007, went to the Intelligence Organized Crime Unit, at which is under the Homeland Security Unit. That's where I was actually tasked to become an electronic surveillance specialist. Once I was tasked to become an electronic surveillance specialist, I had to go get trained. The beginning training, I had to take an 80-hour course in basic electronics, dealing with cameras and recordings, DVRs, body bugging, GPS tracking, and things of that nature. Since then, I've been going to other extensive training in those matters, including specifically going to a training course at the Federal Law Enforcement Training Center in FLETC in Glencoe, Georgia, where the feds, locals, and states train in actually video recovery from digital video systems. I've been to other extended training from Ocean Systems up in Maryland and other webinars and things of that nature. So I've been extensively trained in the matter. What are your current duties? What do you currently do? Currently do, basically, me and two other detectives, we deal with all the department's GPS tracking, body bugging, wiretapping, electronic countermeasures, video recovery from digital video systems when people don't know the passwords or don't know how to work the systems. Along with other things, dealing with the Homeland Security stuff kicks in, dealing with subversive groups of that nature, and also assisting Secret Service with dignitary protection details when protectees come into town.
Okay. Were you asked to obtain any data specific to a device in this case?
Yes.
Can you tell the jury how that came about?
With that, I got a request from homicide unit advising me they had a DVR they needed me to pull video from. They brought me the DVR and went into the hard drive of the DVR. They give me a date and time frame of video if they want. I go in, pull everything from that time frame, make sure video plays, and give it back to them to watch it.
Are some of these DVR devices password protected or otherwise encrypted or something of that nature?
Yes, they are. Some of them are password protected. That's why we actually had to go out and get training about software to basically get around that, basically going in directly to the hard drive of the system.
Were you provided with a specific DVD or DVR player in this case?
Yes.
I'm going to show you what's been marked as States Exhibits 71 and 72, and ask if you can just tell what those are.
Yes, this is a Night Owl DVR that I processed.
Night Owl?
Night Owl, that's the brand.
Those are photos of the particular device that you got the data from?
Yes.
Honor, this time we'll move to this 71 and 72.
Mr. Menettis, any objection to 71 and 72?
No objection, Your Honor.
Mr. Rowe?
No objection.
They're admitted.
Okay. And once you got the data off that DVR, what did you do with it?
I gave exported it to external media and gave it to Detective Thorpe.
Have you gotten a chance to review? I mean, just generally, what are we talking about?
Just video clips from the DVR itself.
Okay, some kind of security system? Or
Yes, DVR means digital video recorder. Basically, to put it in layman's terms, it's basically a security system that monitors, that's hooked up to the camera system that records to. It's basically the evolution of old VCR. Everything now is digital. It's just a digital video recorder, and the evolution you're seeing now from these systems right here. These systems, used to be the standard. Now, like a lot of times, people homes now, the standards are Ring cameras and, blink cameras and stuff like that, because they're a little bit more inexpensive and easier to install. Usually these take a professional installer to do because you have to run power to the cameras and things of that nature. So these are getting to the point, but basically they're more so in businesses now than homes. But still, every once in a while, we do run into them in homes.
Since we're talking about it, we're just going to put up 71 and 72 real quick on the screen. So these are the device. This is the device that you got, that you received, and that you were able to get the video off of.
Yes.
Okay. All right. And have you gotten a chance this afternoon to review the data and to ensure that what you collected back in 2021 during this investigation is here to be produced in court?
Yes.
I'm going to hand you what's been marked as States 22 and 23, and ask if you can identify what's 22 and what's 23.
Yes, this is a copy of the video that I recovered.
Were there more than one camera angle that was recorded on that DVR, if you recall?
Yes.
All right, and true and accurate copies of the different camera angles for the times that you were requesting?
Yes.
Your Honor, this time I'm going to move to admit States Exhibits 20. No, I have one more question. How do we know that the thumb drives that I just handed you are the ones that you observed earlier this afternoon?
I initialed them.
All right. Your Honor, this time I'm going to move to admit States Exhibits 22 and 23.
Mr. Rowe, any objection to 22 and 23?
No objection.
Mr. Menettis?
No, Your Honor.
Admitted. And Mr. Rowe, just to preserve, there was some pretrial litigation involving this topic, and you have preserved the concerns that you memorialized in that pretrial litigation. You don't need to renew those. That's in the record, but I am admitting 22 and 23.
Thank you. Sir, thank you for being here this afternoon. I have no further questions.
All right.
Mr. Rowe, do you have any questions for Investigator Teague?
Investigator Teague, does that basically captures your involvement in this case?
All of it.
Okay, all right. That's all I have, Judge.
All right. Mr. Menettis.
Thank you, Your Honor. Now, as a surveillance specialist, you can say that nowadays these surveillance home videos are pretty common, correct?
Yes,
They're pretty cheap for someone to buy themselves.
yes,
They're pretty easy for someone to operate, even someone without your expertise.
yes, pretty much so.
And as far as you involving yourself in collecting them, you've been involved in several cases where a homeowner voluntarily gives you the video, correct?
Yes,
You've also been involved in cases where you get the video by force with a warrant, correct?
yes,
Okay. And now these videos can be deleted by the homeowner, correct?
they can be deleted, but the software has a function that we can actually recover most of the time videos that's been deleted, unless it's been deleted a long time ago where it's been overwritten. There's deleted and there's actually on the hard drive there's overwritten. Overwritten means basically new data has been put on top of the old data, and you can't usually recover the old, but sometimes you are able to also.
Okay. And you weren't involved in trying to do that with any other cameras in the neighborhood?
No.
Okay. And now you explained to us that digital video recording is different from VHS. So that's DVR, that enables it to even be stored by the service provider, right? Like Night Owl or Ring.
Well, Night Owl, this is a standalone system, but some of them actually do have cloud backups that you can purchase, out of your pocket to do so. Also, Ring, everything is in the cloud. Blink has a cloud, but also Blink cameras allow you, if you don't want to pay for the cloud server, to record directly to an external hard drive or a thumb drive. It just depends on how you want your system set up.
Okay.
And even with systems like this, DVRs, the initial installer can set it up to constantly record, or they can set it up to just record motion. It just depends on how it's set up. But on my end, I don't really have anything to do with that. I have to get what's there.
Okay, understood. And so you're not aware of any of these commonly used video services? You're not aware of any of the other houses maybe using Ring or Blink?
No, I didn't go to the scene. I was brought this in my office.
Oh, okay, I understand. And then, so that's something that law enforcement could get from Ring, for example, right?
Yes, you can subpoena. You can subpoena Ring.
You can subpoena Ring, and they'll give it to you.
Yes.
And there's even something in the Ring user agreement that says it can be given to law enforcement, right?
Yes, with a court order or warrant, they're compelled.
Right. Even without our permission, correct?
Yes.
Okay. Because you're agreed to the user agreement.
Yes.
Okay. And to get a warrant or a court order, all you need to do is call up the judge, correct?
Yes, sir.
It's a little more complicated than
that. But yes, there's gonna be an affidavit road and all this other stuff.
So we're clear, it's not just, yo, judge, Ring camera, please.
Yeah, understood, yeah. That's how you initiate the process, right?
Yeah. Well, sometimes you usually have to write it out and either do a video warrant or find out who the presiding judge is, or Your Honor can tell you that in my career, we've had to go to judges' houses in the middle of the night, way back in the day. So it just depends.
So that's something that can be done, I guess.
Yes.
And you're not aware of that being done at all by anyone in this?
I have no idea about that.
That's all my questions, Your Honor. Thank you.
Mr. Griner, any redirect?
No, Your Honor.
Jurors, any questions for Investigator Teague? All right, you'll hand that to Deputy Gordon, please. Thank you. So normally I'd run this by all of you, but I'm not going to. Detective, is there a difference between detective and investigator?
No. It's basically pretty much with the Atlanta PD, what we call ourselves. The official title for basically housekeeping functions is investigator, but all our badges and people refer to us as detectives. It's the same thing.
Is every detective an investigator?
Yes.
And every investigator is a detective?
Yes.
Okay, got it. Got it. All right. Based on that question, any follow-up, Mr. Griner? Mr. Rowe?
No, Judge.
Mr. Menettis? Investigator And detective, thank you for your time.
Just the one thing, the badges say detective. So.
All right.
All right.
I had that same question long ago. You leave everything there. Mr. Griner will take care of that, or Miss Porter will. All right. Next witness. You want your break before the next witness? Would you? Okay. More importantly, Ms. Rivers wants the break right now. All right, ladies and gentlemen, we're going to take our afternoon break. I try to keep that at about 10 minutes, but here's how it works. When we're ready, I send Deputy Gordon into the break room. And if you're ready, you say, yes, the break is over. If you're not ready, you say, not quite yet. You're going to know the rhythm you want and the time you need to refresh. So he'll be in about 10 minutes and hopefully we can pick up then. Please don't talk about the case while you're back in the jury room. No outside research. See you in about 10.
All right, for the
Mr. Griner, anything before we break?
No, Your Honor.
Your next witness is ready. That's not why we needed the break. You just thought it was cleaner to break first?
Yes, I think I've got 3 in the hallway ready.
Great. Have you figured out yet what Mr. Monetis handed you in an envelope today? You've been in trial, so if you haven't, that's fine. I'm just curious if that's an issue I need to have on my issue list.
I do not know what this is yet.
Okay.
I haven't even looked at it, opened the envelope. He gave it to me this morning.
Okay, understood. Mr. Rowe, anything we need to talk about? I owe you, more so your client, please give this man a haircut order. I'm gonna try to get that done. It probably would happen over the week. Did they do that over the weekend or? We'll work through it. But I'll get that order. I'll work with Deputy Gordon. He'll know to whom I can send it to see if we can make it happen.
Okay.
Anything else?
Nope.
Mr. Monetis?
Just similar to the haircut, I really need the clothes for tomorrow, the suit jacket and the suit pants.
I didn't, yes, haircut, no hair. You never asked for a haircut.
No. I meant in a similar vein.
Oh.
I'm requesting to make sure that the suits that I dropped off last week, that he can wear those tomorrow.
Sure. Do we have them? So what happened this morning?
It was 2 bags. I just took 1 bag down.
Okay, you didn't realize there were 2 bags. Okay, definitely can happen. There's just a miscommunication. They're here, and we'll make sure that Parks' clothes go on Parks and Phillips's clothes go on Phillips. And maybe you won't have to tie his tie for him.
Thank you, Judge.
All right. Okay, that's it. See you all in about 8 minutes.
I mean, I just like to care about that.
What's the name? When he said that it's a Terry, and she said it's a Terry in the report, it's the paper that she gave her, it say Carrie Henderson.
And that's in evidence now.
So.
Are they ready?
Yes.
Great. All right, let's go back on the record, please, Ms. Rivers. In State versus Parks and Phillips, Mr. Griner, are you ready for the jurors to come back? Mr. Monetis, are we ready?
We are ready, Your Honor.
Mr. Rowe? Jurors, please.
All right, for the jury. Judge, President of the County Board.
Thank you, Deputy Gordon. Everyone else can be seated. Everything going all right in the jury room? Yes? Good. Okay. Sound like I heard a voice from over there. You better not know. Good. Mr. Griner, your next witness is?
Tabitha Hammond.
So Ms. Hammond, if you come on up here, Deputy Gordon's going to tell you what to do.
We swear affirm that the testimony you will be able to give truth, the whole truth, nothing but the truth, so help you God.
This one, 4215. She staying.
Tabitha, Tabetha.
And your last name?
Hammond, Hammond.
Thank you.
Problem.
Good afternoon, Ms. Hammond. Thank you for being here.
No problem.
Let's start off by just tell the jury a little bit about yourself, where you work, whether you have a family.
Hey, my name is Tabitha Hammond. I was currently staying at 4215.
You don't need to give us your address.
I don't say that no more.
Oh, okay. Then you can, where you used to live is fine. All right.
We've been moved.
All right. Where did you used to live?
You saying at the time?
Yeah.
4215 Notting Hill.
4215 Notting Hill.
Correct.
Thank you.
So, set this up again. I'm going to show you State's Exhibit 1A. We've been looking at it. Some other folks. I'll just stand right here inside. Let you take a look at it. Does this look familiar?
Yes.
And can you point out where you used to live? Okay. And who all lived with you at 4215 Notting Hill?
It was me, my kid's father, and my kids, and my mother-in-law.
Okay. So let's put some names on that. Who is your child's father?
Javante Harris.
Okay, is he here with you this afternoon?
Yes.
And your mother?
Mother-in-law,
Mother-in-law. And what is her name?
Tanya Rich.
Okay, and she was living at 4215 at the time?
Mm-hmm.
Yes.
Yes, sir.
Okay. And, children, let's talk about children. How many children were there?
It was 6 at the time, yeah.
All right, and can you tell the jury at the time their approximate ages and just first names?
My oldest, his name is Sorrell Gardner. He was like 7 at the time, or 6. My little girl, Janila Harris, she was a baby. She wasn't even 1 yet. Javante Harris, he was like 3 or 4. And Javante other kids, Josiah Safras, he was probably like 2 or 3 at the time. And Jatavius was a baby. He was a newborn.
Okay, so, there are 2 Javante. There's Javante Harris Senior and Javante Harris Junior. Am I right about that?
Correct.
Okay. And
We have a
so,
junior.
Javante Harris Senior is baby's father.
The father. Mm-hmm.
Okay. And you and he are in a relationship, married?
Just in a relationship.
And how long had y'all been in a relationship?
Over 10 years.
Over 10 years. And it sounds like you had some children, he had some children too?
Correct.
Okay. And so altogether, 3 adults and I hear 5 or 6 children?
It was like 6 kids.
6 kids, okay. All right. At the time, where were you working?
I was working at Burger King at the time because I was pregnant.
Okay, you were pregnant.
Mm-hmm.
And how long had you been living at 4215 back in September 13th, 2021, when all of this occurred, the murder?
Like a year and a half.
Let's go back a little bit in time, a few months before.
Okay.
Let's talk about, are you aware of an incident between one of the children who was living at your house and another child in the neighborhood?
Yes.
And can you tell the jury generally what occurred?
When we first moved out there, they used to pick on him because he was so little.
And who is he?
Sorrell Gardner,
Okay.
my oldest son.
Can you spell the first name?
Yes, SAH_RELL. Gardner, GARDNER.
Back at that time, he was how old?
He was 6
Okay.
when the fight occurred.
Okay. And then go ahead and continue then. I think you said that he was picked on?
Yeah, they used to try to pick on him. Everywhere he go, they try to pick on him because he's so little for his age. And I guess one day he got tired. They was picking on him and they ended up getting into a fight. And he knocked the little boy's tooth out when it was already loose. He didn't just knock it out. But it went from there.
Okay. Did your son come back home after the fight?
Yes, and he was telling me about it.
And then what happened next?
My boyfriend, him and his homeboy was in the garage. 2 adults pulled up and with guns and was like, "What teenager being on my son?" or something he was saying. And we was like, "Ain't no teenager staying here. It's a child." And we just went from there. And
were you out there in the garage to see this confrontation between the 2 men with guns and your boyfriend and his friend?
No, I heard it, and me and my mother-in-law, we was walking down the stairs, and they ended up coming in the house, and they was like, "Don't move." They was pointing guns. They was saying, "Don't move, or I'm gonna shoot you."
This occurred on the evening that the 2 little boys, the 2 kids got into a fight.
Yes, one of the boy's brother, he showed the 2 men where we stayed, because he was with them.
The boy that had the tooth knocked out.
His older brother, I think he was like 12. His older brother was like 12, and he walked the 2 men to where we stayed.
What happened once you got downstairs with your mother? What did you see? What did you observe?
I just seen the 2 men I never seen before, and we just froze on the stairs.
They had guns?
Yes.
Did they point them?
Mm-hmm, yes.
Had you ever seen them before?
No, I never seen it.
Have you ever seen them since?
No.
How did the situation end up? Was anybody hurt from this confrontation between the adults?
No, when they left, they shot one time and pulled off.
Yeah, and you say they shot one time. Where did they shoot, if you recall?
I think in the air, because it didn't hit nobody.
Pulled off, meaning they drove away?
They drove away.
Do you remember that first incident, what kind of car they were driving, if you remember?
No, because it happened so quick.
Did you or anyone else report that incident to the police?
Yes.
Did you actually speak with the police and they came out and y'all talked about it?
I think so. I don't remember.
Were there any other incidents that occurred, approximately when did that occur? Just approximately.
I can't really say. I don't remember.
Let's relate it to New Year's Eve. Was it before or after New Year's Eve 2020?
It was before.
Weeks before, months before, days before?
It was like weeks before.
Was there any other time after that initial event, weeks before New Year's Eve of 2021? Was there any other time that your house got shot at?
No, just on New Year's.
Okay, so tell us about New Year's Eve.
On New Year's Eve, we was drinking Seagrams, having fun with the kids. And we got tired. We was like, we're gonna go put the kids to bed. And we had cameras on our TV sitting up. And by the time we laid down, bullets started flying through our house at 12 o'clock on the dot.
Who was home when that happened, if you recall?
The same people.
3 adults you mentioned earlier and the 6 kids?
Correct.
Were you able to look out the window or see who was shooting?
No, but a couple hours later, we ended up seeing the same car drive in, and we seen the victims get out the car and go in the house, change clothes, and come back out.
You saw a car?
The same car.
And what kind of car was it?
I don't remember. I know it was white.
Anybody you knew?
No. I didn't know nobody out there.
I'm sorry?
We didn't know nobody out there.
Okay. You didn't know other neighbors and socialize with other neighbors?
No.
Any reason for that?
No, we just didn't come outside.
After New Year, approximately how many times was your house shot on New Year's Eve?
It was just that one.
One time?
Mm-hmm.
Any other times that your house got shot at after New Year's Eve?
A couple of times.
Can you tell the jury about those instances?
I mean, we never had no altercation with these guys, but it seemed like they wanted a problem. But every time we turned around, bullets come flying through our house, and we don't know why.
Do you ever become aware of someone around the neighborhood called Hot?
Yes, he stayed across from us.
Let me show you, say this is exhibit 1A again. I'll walk back over here. If you could point out approximately where Hot lived. I can turn this like this. Okay. So
I used to always see him, like how camera was sitting up, we could always see them walk in and out there.
okay, and you pointed to what direction? I don't want to point for you.
Right over here.
Okay, and you seem to be pointing, you correct me if I'm wrong, something like 4228 or 4223, that building?
Yes, sir.
Okay. And can you see Hot in the courtroom? Stand up and look around.
Tell.
One of the two? Okay. Sitting in the
Correct.
Okay, thank you. Did you ever come to know who Woe was? A guy named Woe?
I never really seen him like that. I used to always see him on the camera.
And can you identify whether Woe was in the courtroom? Not really sure.
Not sure. Because it happened so long ago and they don't got it.
Fair enough. So we were talking back, and you indicated that your house had been shot up New Year's Eve, and then got shot up a couple of other times.
Correct.
At some point, you saw a white car on the camera.
Mm-hmm.
You may have to say.
Yes, sir.
Okay. And so, can you tell us about how many times your house got shot up during 2021 before this September event?
I say like 5 or 6.
And did you try to report it every time it happened?
Yes, and most of the time we'll probably go get a hotel or something because my kids are traumatized, and they still do it when we're not at home.
Did you at some point decide to move?
Yes.
Did you end up renting a U-Haul truck to help with that? Did you have other people come over to assist you in moving stuff?
Yes.
Find it difficult to pack things up and move furniture to kids running around?
Yes, it was a lot, so it took longer.
Did you ever know a friend that came over named Sam, called Sam?
I never seen him like that because I think he was just getting out of jail at the time, and we had just met him.
Okay. Was he at your house for very long on September 13th, 2021?
No.
She don't recognize us. She don't recognize us.
He was supposed to help us move, but he kept seeing them walk back and forth with weapons in their hand, and he didn't want to be involved, and he didn't want to get himself in trouble.
Did was there any conversation inside the house when you all were getting things ready to move? Was there any conversation about the guys outside walking back and forth or whatever they did?
Yes.
Can you tell us what you recall of those conversations?
We just kept seeing them walk back and forth with the gun. So we was talking among each other. We was just saying we need to hurry up because, you know, my kids in here and we don't want nobody hurt.
Hurry up meaning what?
So we can go move, so we can finish moving.
Were you all trying to get everything moved out that particular day?
We was trying to get everything moved that same day.
And did you already have a place to go?
Yes.
And so, was there any conversation about, you know, within you and the other adults in your house about trying to go and some kind of attack, retribution, or anything against anybody else?
No.
Did you ever become aware that at some point Sam left?
Yes, he came in the house. He was like, I'm finna go. And that was it. And he hopped in the car and left. And once he pulled out, they started shooting at his car.
Did your house get shot at while they were shooting?
When they couldn't get to him, that's when bullets started flying in our house.
And your house got shot, where did it get shot?
The bathroom downstairs, because the water was going everywhere. Upstairs, the living room. We was trying to get all the kids out the way.
Back up a second, let's talk about the water. Tell the jury what you mean about the water going.
A bullet hit the sink and water just went everywhere.
Let's talk about the children. What were you all doing to try to protect the children?
Javante laid on top of our daughter because he was already holding her. And, just pushing the kids on the floor, so they won't get hit.
And these other events, had you done similar things to try to protect the children?
Yes, it was a 3-story townhouse. So at that point, our room was on the second level. So we ended up going all the way up to prevent, the bullets, because you never know when it was coming.
You all ended up moving from the second floor to the third floor to try to protect yourself against these occasional shootings.
Yes.
Did you get a chance to look out the window and see who was shooting at you?
No, but we see everything on the camera. It was on the TV.
Okay. And did somebody call the police, or did the police show up?
I think the neighbors next door, she called the police because every time our house got hit, hers got hit.
And did you stick around and speak to the police?
No, we was trying to get the kids to safety.
Right. And did you ever make a statement to the police?
I have a couple of times.
Came to this case?
Yes.
And have you also talked to people from the district attorney's office about the case?
A lady, I forgot her name, she was still calling me about the New Year's Eve case.
So did you end up moving from 4215 Notting Hill Drive?
Yes, we've been moved.
And how
Just
long?
left most of our things.
Just left most of your things after this event?
Mm-hmm. Yes, sir.
All right, well, thank you for being here. Were you aware of whoever was shooting, whether or not they left the scene? Did you ever become aware, or could you tell what was occurring outside, movement of people or anything like that?
Not really.
So what was it like to be on the inside and when this happened?
It was scary, traumatizing.
You recall what you were doing at the time that these gunshots began?
I can be feeding the kids, playing with the kids, bathing them, anything.
I'm talking about on this specific evening on September.
The day was moving?
Yes.
No, trying to get clothes and stuff together.
To move?
Yes, sir.
Were you all actually loading things on the truck to move?
Mm-hmm. It was just kind of hard because, the kids and.
They run around and kind of got to keep an eye on them.
Yes.
So you're trying to get clothes together and these gunshots begin.
Yes.
And what's occurring? What do you see inside? What do you remember?
Just getting the kids out the way. That was about it.
All right. Do you remember which children you were trying to get out of the way?
All of them, could they all be right there together?
What were you doing when you say you're trying to get them out of the way?
I was in the room gathering things at that moment.
Okay. And what were you doing to try to get the kids out of the way?
I was, pushing them on the floor, laying on top of them.
Was there any yelling, screaming? Can you give us a sense of what it was like?
Yes, all the kids were crying. We was yelling. It was just a lot.
How long did you stay on the floor with the kids?
Until the shooting was over.
Shooting, when it was occurring, do you know who else was in the house with you other than the children that are in the room with you?
Javante, I think he was downstairs somewhere. And my mother-in-law.
They were also there?
Mm-hmm. Yes, sir.
And the 6 children basically in the room with you? I know you mentioned Javante and his daughter, but.
Yeah, my little girl, she was following Javante around.
So he ended up picking her up and he was walking around the house with her, trying to get stuff together. And the other kids upstairs with me, because one of the kids was a newborn. He wasn't even crawling yet.
So you stayed down with the children until you heard the gunshots in.
Yes.
Then what happened next?
By the time we went outside, it was police everywhere.
You stayed there inside until.
I was outside already. I came outside when they pulled up.
Okay, and the first officer got on scene.
Yes, they came at the same time. It was multiple.
Thank you very much for being here this afternoon. I don't have any other questions at this time.
Okay, thank you.
They may ask you some questions, but I don't.
Okay.
Mr. Monetis, do you have any questions for Ms. Hammond?
Yes, Your Honor, thank you. Now, you say that you were dating Mr. Javante Harris at the time?
Yes.
So he was staying there with you at the house, the 4215?
Yes.
Okay. And there were guns in the house, correct?
One.
There was one gun in the house?
Mm-hmm.
Okay. And that's that you knew of, correct?
Yes.
Okay. And did you use Instagram at the time?
Did I have Instagram? Yes.
Okay. And did you ever communicate with Javante Harris on Instagram?
On Instagram? No.
Okay. Do you know whether or not his Instagram at the time was Tay stepping on shit?
No.
You don't know whether it was or not?
I don't remember that page.
Okay. And what about Sam? What was Sam doing at the house?
He was there helping us move.
Okay. And what's his relationship to Javante?
They only been knowing each other for like a month.
Okay. And when you say knowing each other,
he had just got out of jail then.
Who?
Sam.
Okay. So Sam gets out of jail, now he's friends with Javante for about a month.
He met him through somebody else.
Okay. And they're spending a lot of time together during this month? They're friends?
Yeah.
Okay. And I guess I didn't hear correctly. So is Sam sleeping there at nights or he's just coming over to hang out?
He just come over, hang out, then leave.
Okay, he leaves. And as far as any statements that you gave in any of these cases, were those statements ever written by you?
By me? No.
So you never gave any police any written statements?
No written
about any of
statements.
this? Okay. And what about audio recorded?
No, I don't think so. I don't remember.
Okay. And what about video recorded?
Video, yes.
Okay. And which one of those statements was that?
The New Year's Eve, the New Year's case.
Those are my questions. Thank you.
No problem.
Mr. Rowe, do you have questions for Ms. Hammond?
Do you have a surveillance, did you all have a surveillance system where you were, when you were living at that address at that time?
Yes, sir.
Okay. And did you turn that over to anybody in particular?
Yes, they got the camera box.
When you say they, are you referring to the police department, the district attorney's
The
office?
detective, like this. I don't remember.
Okay. And when did you turn that over?
The day we was moving.
Okay. Hey, did you have an opportunity to view the surveillance prior to turning it over?
No.
Were you aware that Mr. Harris was on the surveillance with 2 guns on the day of the incident?
That wasn't Javante.
Okay. Who was that?
Sam.
Sam? Okay. And so Sam grabbed 2 guns,
I'm assuming. I wasn't out there, so I don't know.
but you was aware of it?
Yes.
Okay. All right. So when he had 2 guns, was that before the shooting?
Yes, when he seen the guys walk past with their guns in their hand.
Okay.
That's when he grabbed his.
Okay. All right. And you indicated that there was a shooting on September 2021, September 13th. But you did not call 911, did you?
No.
Okay.
We just left and got a hotel and.
All right. And the New Year's Eve shooting
Same day. She in front.
that you referred to, you did not see who actually did the shooting, did you?
It's on our camera.
Okay, all right. And so, do you know the person that did the shooting on the New Year's?
I don't know them specifically, but I seen it on the camera.
Okay. Is that person in the courtroom?
No.
Okay. And regarding to the September 13th, 2021 shooting, you can't identify that person in the courtroom either that did that shooting, can you?
Say that one more time, I'm sorry.
Regarding the September 13th, 2021 shooting, you cannot identify anyone in the courtroom as the person that did that shooting too, correct?
Correct. But I know the names, I just can't identify their face at the moment because it happened so long ago.
You know names, but you can't identify faces, correct?
Correct.
All right. And did you see the victim involved in this case the day of the shooting?
It was one of them.
No, I'm saying the person that was shot, that's the victim.
Oh, I never seen them before at all.
Were you aware that he also lived in the neighborhood?
At that time, I didn't know.
Oh, didn't know, okay.
I didn't know nobody got shot until after.
Okay. So you never saw the person that was shot on that date in question, correct?
Correct.
Okay. So you don't know how he was shot or anything like that, right?
No, because we was in the house trying to move.
Okay.
We wasn't outside.
So you really didn't witness anything that took place around the area that the gentleman was deceased or shot?
I mean, the only thing I witnessed was the guys walking back and forth with their guns, watching our house.
Okay. But Sam also had 2 guns, right?
He grabbed his 2 guns after he seen them walk past the house with the guns.
Were you outside when the gunshots ring went off?
Who?
Were you outside when the gunshot went off?
No, but our camera shows everything.
Okay. But the camera does not show anyone in particular shooting the victim or the person that was shot, correct?
I mean, at some point, it does show when they were shooting.
But it doesn't show who was shooting, correct?
Correct.
And how many gunshots, or how many, if you can answer this question, how many gunshots were found, or how many shells cases were found where you live at your house?
Judge,
I'm not sure.
I don't know that this witness would be able to answer that question.
That's what she can say. I have no idea. She's already testified she was not outside when it happened, so we don't want to ask her a whole lot more questions about what happened outside, since she's made very clear she was not outside when it happened. So, do you remember what the question was?
No.
Okay, you can ask your question again.
Thank you. I said, my question was, do you know how many shots was fired at your house? That was my question.
No, I don't. But it was a couple.
But you testified there was shots fired at your house, correct?
Yes. After they shot at Sam's car and they couldn't get to him, they started shooting at our house.
But you have no idea how many shots?
No.
You didn't call 911?
I didn't have to. They called 911. They was already outside by the time we went outside.
And you said it was your son that was involved in the initial dispute?
Yes.
And you said somebody knocked this tooth out? Is that correct?
Because the auntie told us that she don't see why they tripping because his tooth was already loose.
Okay.
It was a kids fight.
He was what?
It was a kids fight.
Oh, kids fight, okay. Is Sam related to you, the one that had the two guns?
No,
Okay. How do you know Sam?
because he knew Javante. Javante met him through somebody.
So he was a friend of Devontae?
Yes, I don't know Sam. We only knew him a month.
Okay. So Sam had two guns, right?
Yes, you've asked her that a whole bunch of times. Two guns. Next question.
Judge, I'm just trying to do a thorough sifting cross-examination.
You've been trebly thorough. Next
I
question.
wasn't outside at the time. Sam had the guns also.
Okay, all right. And you said there was another gun in the house that Javante had, right?
I never said Javante had a gun.
Okay, with the gun in the house, who did that gun belong to?
Me.
Did you have to use that gun?
No.
Did you ever give a statement to the police department on the day of the incident?
It was a couple of people that I gave statements to.
All right. Did you mention?
Stay there until everything was over.
Okay. Did you mention to them about a vehicle that you saw?
No.
Did the officer ever come over to your apartment collecting the evidence or to your house?
Yes.
Okay. And do you know what they collected?
No, I don't recall.
Okay. Were you present when they came over to collect it?
Huh?
Were you present when they came over to collect the evidence?
Yes. I had to stay there till the whole thing was over.
Okay. They collected from the inside of the house or the outside of the house?
Both.
And how many times were you interviewed by the police department?
Probably like once or twice.
That's all I have, Judge.
Mr. Menendez?
No more questions, Your Honor. Thank you.
Any redirect?
No, Your Honor.
All right. Any questions from the jurors? We may have a few. Deputy Gordon, if you'll collect those, please. Thank you. Counsel, if you step outside, please. We'll be right back to you. Ms. Hammond, just need to cover a couple things. Was the date that you were moving with the U-Haul truck and Sam was there to help you move, was that the day that the gentleman across the street was shot and killed? Are we talking about the same day or different days?
This is Sunday.
Okay, your moving day ended up being the day of the shooting. I mean, we talk about a lot of shootings, but the shooting where someone died.
Yes.
Okay, and on that day, were there multiple rounds of shooting or just one? Here's what I mean by that. There may have been multiple shots. Was it one fusillade of lots and lots and lots of shots and nothing else? Or were there some shots and then some time and then more shots and some time? How did it play out on the day the guy was shot? You're moving it.
Multiple shots, like shots and shots and shots.
But it was all one big shots at one time, not, and then 3 minutes later, there were more shots. Okay, got it. Thank you for clearing that up. Mr. Griner, do you have any questions for Ms. Hammond based on these two topics?
No, Your Honor, no questions.
All right, Mr. Menettis?
No questions, Your Honor.
Mr. Rowe?
No, good.
All right, thank you, ma'am, for your time. You're free to go.
May she stay in the courtroom?
If you're not recalling her, she certainly may.
Thank you.
Thank you, Ms. Hammond. Next witness.
I will call Javante Harris.
Hey, Mr. Harris, come on up and Deputy Gordon's going to give you a couple instructions.
You swear affirm that testimony you will give the truth, the whole truth, nothing but the truth, so help you God.
We just need you near the microphone, but the chair doesn't have wheels, so there you go. Thank you.
Can you state and spell your name for the record?
Javante Harris, JAVONTEHARRIS.
Good afternoon, sir. Thank you for being here.
Yes, sir.
Can you tell the jury a little bit about yourself? You have a family, you have a job, and a little bit about yourself, please.
Yeah, my name is Javante, 28. My name is Javante.
The microphone moves down if that helps. There you go.
I currently have 7 kids at the moment, 6 boys and 1 girl. I'm not working at the moment, but trying to find a job as we speak. But yeah.
Back at one time, did you live back on Notting Hill Drive?
Yes, sir.
On what address did you live at on Notting Hill Drive?
4215.
Who did you live with when you were at that address?
I stayed there with my girlfriend and my children.
And your girlfriend is who?
Tabitha Hammond.
She's the one who just testified?
Yes, sir.
And how many children did you have, or did you all have back at that time?
6.
And did anyone else stay with you all?
No, my mother was there for a minute.
Back at that time, where were you working?
Papa John's.
Did you become aware of an incident involving some children fighting?
Yes, sir.
Can you tell the jury what you understand occurred?
Well, at first it was just a kids fight. My oldest son, when we first moved out there, the kids that was out there used to pick on him. But I guess one day he didn't want to get picked on no more, so he got to fighting with one of the little boys. And the little boy's teeth was loose, so when they got to fight, he knocked his tooth out.
Your son knocked the other child's tooth out?
Yes.
Okay. And then did the kids go home after that?
Apparently, yes, until later that night when I came home. That's when I heard of the incident. But by that time, nobody was outside, to my knowledge.
When you came home that night, do you recall roughly what time you might have gotten home, if you remember?
It had to be after 10.
You were working in Papa John's at that time?
Yeah, it was after 10 when I got home that night.
When you got home, what do you recall occurred?
Well, when I first got there, I changed clothes, chilled for a minute. Then one of my friends called me. I left when it picked him up, came back home. We stood in the driveway for roughly 20, 30 minutes. Then his girlfriend pulled up with his car. And as she left, and as we standing there, two older guys approached us about the fight that happened earlier that day. But by me not being there, I didn't have no knowledge of what all actually happened. So when the guys showed up, they had guns, but their guns was already out. I didn't have no gun on me at the time. My friend had his gun under his arm. So throughout the conversation, the guy was just asking me, do I have grown adults in my house beating up on children? I told him no. I'm the only adult here. Well, the only male adult that stay here. My son is only 7 years old at the time, my oldest. I don't have any teenagers. So he had a little boy with him, and the little boy was telling him, like, no, there's no older kids stay there. That's the daddy. So in between all of that, the guys end up taking my friend's gun off from under his arm. My friend fell back into the door and closed it. The guy tried to go behind him. I stood in front of the door and told the guy, the only way you can get in this door is that unless you kill me, because my kid's in here. I'm not letting nobody through this door unless you're going to kill me now. So the other guy that was with him, I guess he seen it, and he was just like, come on, they left. As they was leaving, they shot back at the car that was in the front driveway. But I haven't seen them guys since then.
Do you remember about what time of year that was, or how many months or days or weeks or whatever that would have been before September?
It had to be, you saying how many months?
Yeah, I mean, just what length of time?
I'm not quite sure the exact time, but it had to be in the year 2020, 2021, something like that.
Okay, let's relate it to New Year's Eve of 2021.
Okay.
Did it occur before that time?
Yes.
It did occur before that time?
Yes.
Okay. Do you remember whether or did your house get shot up at any other occasion after that initial event with the two men at your house?
Yes. That was the New Year's of 2021.
Can you tell the jury, were you home when that occurred?
Yes.
Can you tell the jury what you recall occurred?
Well, my mother was cooking that day for New Year's. It was me, my girlfriend, my kids, and my mother. We was in the kitchen and in the living room. My mother was cooking. We had music playing. I'd say around 11:30, something like that. I had too much to drink, so I was going to lay down. But the way my camera was set up, if I leave from the room, I unhook it from the room and hook it in the living room to the big TV. That way, while I'm in the living room, I can see the camera. So I unhooked the camera, took it to my room, and plugged it up and sat down on the bed. In the midst of me doing that, I was telling my son likes to play with my socks. So I was telling him, I was like, Daddy, take my shoe off. So as he's taking my shoe off, I see a white truck go down, but it's like I've been drinking, so I'm not just, paying attention to the truck. But as the truck go down, you see the truck comes back up. But when it comes back up, I guess whoever was driving almost hit the mailbox. So you will see on the camera, they almost hit the mailbox, and that's when the shooting starts.
And you say that's when the shooting started.
Yes.
Tell the jury what you mean by that.
Well, from that day forward, I say every other day, if not a week or so, my house will get shot up. But it's like they'll watch me leave. As soon as I leave, I get a call, they shut the house up.
Does shot the house up mean that someone
Several
fired
shots.
one shot or 100 shots?
Multiple shots.
Multiple shots.
I ain't gonna say 100 shots, but
Sure, but not just one.
Yeah, multiple shots.
So that occurred on New Year's Eve,
Mm-hmm.
and the murder occurred in September of 2021, about 9 months later. How many times during that period of time did your house get shot at? If you know.
If I'm not mistaken, maybe 3 or 4.
And each time, was it multiple shots?
Yes, sir.
Each time did you all report, try to do something to stop it?
Most of the time my girl would call, but most of the time I wouldn't even be home when these things occur.
Did you interact with anyone in the neighborhood to try to put an end to it? I mean, find
Yeah.
out who did it or anything?
Yeah, I actually stopped one of the guy's little brother one day when I had my daughter in my hand. And I was just telling him, like, I don't know what's going on with y'all, but when you beefing with somebody, the beef is between you and them. If we beefing, me and your beef ain't got nothing to do with your family or my family. Y'all just keep shooting at my house and y'all watch me leave every day. The young guy was like, bro, that's not me. Them not my everyday friends or whatever the case may be.
Did you ever come to know someone around the neighborhood named Hot?
Yes.
And who was Hot?
Hot was the guy that stayed in front of me, but to the right.
You see Hot in the courtroom?
Yes, sir.
What is Hot wearing? You can stand up.
A white collar shirt with a long sleeve under it.
Okay, so there are 2 people here with.
One has a tie, one has no tie. You talking about the guy with no tie?
Tie.
Okay.
Is Hot, the guy with no tie.
No tie.
Yeah.
And did you ever know someone named Woe?
Yes.
Who was Woe?
The guy sitting right there next to the lawyer in the front with the tie.
Woe over here?
Yes, sir.
Let me show you. 6 Exhibit 1A, and you can turn around and stand up or whatever you might need to. Does this look familiar? I know it's an aerial photograph you may have never seen, but does it look familiar?
Yes.
Can you point out where your house was here on 1A? All right, and that you pointed to 4215, is that correct?
Yes, 4215.
And where did Hot Parks live?
In one of these houses.
Okay, and so you're pointing to this road that's down here, 4228, 423 on that road?
Yes.
Did you ever know whether or not Woe stayed in the neighborhood?
At first, no, I didn't until afterwards.
Until after the event?
Yeah.
Okay. Did you see Woe around the neighborhood?
No, not necessarily. Only time I ever seen him is coming and going.
Did you ever know Hot Parks's other brother, Fats?
No, actually, he's the only one that I ever seen at first. I never even seen Hot at first. Fat was the only one that I was seeing first.
So you knew about Fat?
I didn't know about him. I seen him before, yes.
Okay, you had seen him before, you knew.
Yes.
You knew who he was.
Yes.
Okay, and did he live, at this same house down here that you indicated over here in this building?
Yes.
And for the record, that's 42, 30, that building somewhere. So you were aware that this guy named Fats lived there, and then sometime later, you became aware that Pocket was living there.
Yes.
So at some point, did you and your family decide to move?
Yes.
Can you tell the jury about that process? You know, when you decided to move, what you were doing to move?
They actually sent us a letter in the mail stating that we had to go to court first. But after we went to court, they were saying about, you know, all the problems that was going on. So they was like, they're not saying that it's us and they're not saying that it isn't, but you know, it'd be best if, you know, we move. So that's what we were doing in the midst of moving.
Okay. And did you rent a U-Haul?
Yes, sir.
And did you park it alongside the house there?
Yes, sir.
And did you invite other people over to help you move?
Yes.
Let's talk about Sam. Was a guy named Sam one of the ones that you invited over?
Yes, he was parked in front.
You remember what kind of car Sam drove or what color it was?
Like a white Kia, if I'm not mistaken. I think it was a Kia.
How did you know Sam?
I knew him from the neighborhood where I used to hang at.
Did you know him well?
Not that well. I knew him for like a month or so, maybe 2.
Did he come over to help you move?
Yeah.
Was there any conversation between you and Sam or between Sam and anyone else about what was occurring outside?
No.
Was there any conversation between you and Sam about kids being outside, young, hot, you know, whoa, we need these other guys outside?
Yeah. He was just like, because I was in and out of the house moving stuff at that time. So when we did have a conversation about those guys, it was because they walked past first. One of the guys walked past first, but when they came back, it was all 3 of them. But one guy had 2 guns in his hands. So Sam was like, bro, I'm finna get ready to pull. I don't want to start nothing and I don't want nothing to go on. You got your kids. I'm like, all right, just call me. I goes in the house. By the time I make it to my second set of steps, my daughter is coming down the steps. So as she's coming down the steps, I start hearing the gunshots. One bullet comes through the window. I turn around and just lay down on my daughter until the gun stops shooting.
Did you know who was shooting at the house at that time?
No, not at first, no.
Did you, after the gunshots stopped, what did you do next?
I ran outside screaming.
What were you screaming?
Y'all niggas tripping. Y'all shooting up my house and I got kids in here.
Did the gunshots come like in one burst all along, or was it like one burst and another burst?
Yeah, like just back to back. 1, 1, 1, 1.
Explain that to us, please.
I mean, I was in the house, so it's hard to tell how many guns I heard. I just heard the shots.
Did you ever get a gun that was inside the house and go outside?
To my that day, yes.
And what did you do, if anything, when you went outside?
I ain't do anything. I wasn't able to do anything.
And what do you mean by not being able to do it?
Because it was people there and my children were there. It was just, at that time, I was just so mad because my daughter was just almost hit. So by the time I got out the door, it was police everywhere.
Did you stay inside the house pretty much until the police got there?
Yeah. Then they asked me to come out.
And did you talk to the police?
Yes,
Did they initially detain you?
yes, sir.
And did you go to the police station and speak with them?
Yes, sir.
Did you shoot a gun at all that day?
Not now time.
What was that?
Not now time at all. No, sir, I did not.
Have you ever shot a gun in this neighborhood?
No, sir.
Have you ever tried to retaliate with violence against others who were shooting at your house?
No, sir.
You had a video system in your house, you mentioned already.
Yeah.
And did the police obtain that video system from you?
Yes, sir.
And did you, after the gunshots occurred, you laid down on your daughter to protect her? Let me just follow up something on that. Were you on the stairs when that occurred?
Yes, sir.
You were laying down on top of her, you all on the stairs.
Yes, sir.
And
The second set of steps.
second set of steps.
Yes, sir.
Is that leading up to from the second floor to the third floor?
Yes, sir.
Okay. And so when you were on top of your daughter trying to protect her, shield her, which daughter was that?
I only have one daughter.
Okay, and how old was she?
At the time, I believe she was 1.
Gunshot stopped. And did you do anything? What did you do after the gunshot stopped?
I took her to her mother, and then I went downstairs.
Then you went downstairs.
Yes, sir.
Did you ever do anything with the camera recording system? You have to answer.
No, sir. Like, what do you mean? It's nothing that you really could do to it.
Okay. But did you go over to it and look at it or try to play or do anything to the camera system?
No, sir. No, sir.
Or even after the police got?
No, sir.
Did the police obtain
Well,
the actual box?
they took the actual box while I was downtown. I wasn't there when they took the box.
Right. I'm going to show you. Show you video that's been marked and presented evidence.
It should be right in front of you as well, Mr. Harris, if that screen works. You're welcome to look at the big one, but it's easier on your neck. If you.
Okay, it's working now. First, I didn't see anything.
It takes a second. Okay, let's just pause it right here. There's always a little bit of a lag here. So can you orient the jury as to what we're looking at?
Okay, there's Sam standing right there.
You may need to stand up, and you can stand up.
So he can stay right there. I'm gonna show him how to mark the screen so he can stay near the microphone. So if you tap the screen once, over in the corner, you see that little circle with a pencil? Now your finger will, I think the color's red right now. So if you circle Sam first, we'll try that out. For that.
That's Sam.
Yeah, that's Sam.
Okay. All right. And so, do you know either of the other guys who was shown right here? We'll advance it in a moment to see if there's some separation between the two.
I'm not sure. I can't see their faces at the moment, but if I'm not mistaken, it looks like Hot and some other guy.
All right. So is this your driveway?
Yes, sir.
I see a mailbox there. Is that 4215, which is your driveway?
Yes, sir.
All right. And just so we're all oriented and talking about the same thing, if we look at 6 Exhibit 1A again, can you just kind of point, it may seem obvious, but can you point to where we're looking at?
You're looking at this right here. This is what you see on the camera.
Okay. We advance that forward. Can you stop it right there? It's always the way. Did you see as the guys kind of separated, did you able to identify anyone there?
Yes, Hot was the one on the left side.
Wearing what clothing?
He had on like some white and red Jordans.
So there was a guy in all black. That's hot or not hot?
That's not hot.
Not hot.
I have never even seen that guy in my life.
All right.
But the other guy wearing kind of the red jacket?
Yeah, with the book bag on, that's hot.
That's hot. Just so we're clear, hot is this guy right here.
Yeah. Yes, sir.
You know the other person that's walking right here, kind of the heavy set person that.
No, sir. I do not know who that is.
Okay. All right, let's let Nancy do that. All right, let's stop it right here, please. You know this guy who's just walked into the frame from the left?
Yes.
Who is that?
That's Whoa.
Whoa.
Yes, sir.
All right, and just so we're clear, is that this guy right here in the tie?
Yes, sir. Guy with the tie.
All right. You seen Whoa around the neighborhood?
Yes, sir.
Yeah, they have to speak.
Yes, sir.
All right, you had seen Hot around the neighborhood as well?
Yes, sir.
Okay. All right, and so shortly after this occurred, do you know whether or not this is when Sam left, if you know?
Yeah, this is around the time when he left.
Okay. I'm gonna play, let it play forward, and if you can, I'd like for you to look at Whoa. He's wearing the white and he's got a backpack.
Yes, sir.
Just kind of look at his hands and see if you notice it. Just let this play forward. Were you able to see anything?
No, on the camera, no.
Okay, all right. So, were you aware of this scene out here where these individuals were walking past Sam?
No, not at first, no. I was out there when he walked by, yeah. When all three of them walked by together, I'm not sure if y'all had that clip. But I was standing under my porch when they walked by.
Okay. Were you standing in the porch, what we just saw? Were you standing in your porch at that time?
No. I was, if I'm not mistaken, I was walking out the door while they was going past his car. That's the first time they walked by.
Okay. There was another time that they went by?
Yeah, they walked past twice.
I'm going to show you another short video clip and see if you.
Can you, for the record, tell us what this is?
This is it 23. Sorry, I said it to my colleague. Okay, yeah, what angle is this?
This is my front door.
Is there a basketball hoop here somewhere in the
Yeah.
picture?
Yes, a basketball goes to the left, right there in front of the stop sign.
Is it like right here?
You can mark it on your screen. That should be.
It's not showing up anymore.
Well, so tap the screen again and then a little circle.
This is the basketball goal.
Okay. And whose basketball goal is that?
I'm not sure. I believe it's the lady that stayed to the left right there, but I'm not sure.
Okay. And so we're going to play this forward. You see who those guys were that just ran past your front door?
Yes, sir.
Who were those guys?
Whoa, Hot and the other guy I never seen before.
Whoa, Hot, and then this other person you've never
Yeah.
seen. Gunshot. Did you see gunshots?
Yes, sir.
Gunshots?
Yes, sir.
Were those gunshots going into your house at that time?
Yes, sir.
Do you know whether or not that was those three, Whoa, Hot, and G, the other person that kind of skidded off in that red vehicle?
I'm not sure.
So from that point, were those the only gunshots that you heard? Like, it's kind of hard to gauge because you weren't looking outside.
Right.
Do you recall, from that point forward, you were able to hear those gunshots? Do you recall whether or not you heard the car skidding away?
And that I don't remember hearing. Honestly, I don't.
From the inside of your house on the stairwell between the second and third floor, how loud were these gunshots?
Like they was in my front yard. Like you was standing under the door.
And so at that point, after were you convinced at some point that these guys had left?
Yeah.
And then, I think you said you waited until the police got there, until you went outside, or you went outside and you yelled, basically.
Yes. Yes, sir.
Did you venture outside beyond your yard before the police got there?
No.
Did you see anybody out there? These three, Hot, Whoa, and the other guy, or anybody like that?
No, sir.
Sir, thank you for being here. I don't have any other questions at this time. You may have some questions.
Mr. Rowe, do you have questions for Mr. Harris?
Yes, I need this. Good afternoon.
Good afternoon.
You said prior to September 13, 2021, that your house was shot up.
Yes.
You said at least 3 times, correct?
Yes, sir.
Wasn't true, were there other houses in that neighborhood shot up as well before September 13?
We're talking about my house. I don't know about anybody else's house.
Okay. And you testified about 2 men when was it your oldest son that had the dispute?
Yes.
Okay. And then you testified that there were 2 men that came to your house with guns.
Yes.
And could you identify who those 2 men were?
No.
Okay.
I haven't seen those. I ain't never even seen them then. And I ain't seen them after that.
Okay. So Hot was not one of those 2 men, correct?
No, sir.
And you indicate that your house was shot up 3 times after those 2 men came to your house?
Correct.
Okay. And you never identified who were the individuals that shot your house up those 3 times, correct?
What do you mean?
You don't know who, you didn't see physically who actually shot your house up
No.
those 3 prior times?
No, sir.
You testified that Sam walked out the house with 2 guns, and then shortly you heard gunfire.
No, I never said he walked out the house at all.
Okay. You said he had 2 guns.
I didn't say he had 2 guns.
Okay. So Sam didn't have any guns?
Yeah, on the camera, yes, he did. I'm saying you said that I said that. I said, no, I did not say that.
Oh, okay,
I was not asked, did he have two guns or not?
okay, all right, so when he walked out the house, after he walked out the house, shortly you hear the gunfire, correct?
Correct.
All right. And you said there were three people that walked by your house, right?
Correct.
Okay, did you physically see them walk by your house?
Yes.
Okay, all right. And you said that, that three of them had guns?
No, I didn't say they had guns.
Okay.
You can clearly see they had guns.
Okay. But you didn't physically see the guns?
Yes.
Okay. Just like you didn't physically see Sam with guns?
No, I physically saw the guns.
With the three boys, three
Yes.
guys? Okay. And you just didn't physically see Sam's guns?
No, see, this is where you getting me wrong. I never said I didn't see anybody with a gun.
Okay.
When you came to the stand, you said, did I say it that he had two guns? I never was asked, did Sam have two guns just now? So when you asked, then did I say that? No, I did not say that. But did he have two guns? Yes, he did.
Okay, all right. So, let me try to be more clear. Did you see Todd with a gun when you walked by your house?
No, not him, no.
And when the shots took place on September 13th, you testified you was inside your house, right?
Yes, sir.
So that means obviously you did not see anything that
I
happened.
didn't see anything that happened outside. No, sir.
So you don't know who started shooting, is that correct?
Correct.
Or you don't even know how many people were shooting, correct?
Correct.
And did you even see the gentleman that was unfortunately shot that day?
No, sir. I didn't even know nobody was shot.
Okay, all right. Did you know the gentleman that was shot?
No, sir. Never seen him.
And did you give a statement to the police department?
Yeah.
Okay, did you give a statement that same day?
Yes, sir.
Okay, and did they come over to your place to collect evidence?
I'm not sure. I was at there. They detained me at the scene. When they got my cameras and stuff and did they search, I was downtown.
And you owned the pistol, you owned the gun at the time?
No, I didn't own a gun at the time. I had one. Yes.
You had one inside the house?
Yes, sir.
Was it inside the house on that day in question?
Yes.
And in fact, you came out of the house with your gun?
Yes.
And you indicated that you were able to obviously discharge it because the police department was already.
Correct.
All right, that's all the questions I have. Thank you.
Mr. Monetis, any questions for Mr. Harris?
Yeah, just one question. When we saw the three boys walking, it's true that there's only one way in and out of that neighborhood?
Correct.
Okay, thank you.
Any redirect, Mr. Griner?
No, Your Honor.
Questions from the jurors? Looks like there are a few. Thank you. All right, counsel, come with me. Jurors will be right back. Mr. Harris, you, in answering one of the questions, you said that you and Ms. Hammond had to move. Did someone tell you, like, did the homeowners association say you had to move, or did you get evicted, or tell me what the?
We had got a regular letter in the mail that said we had to go to a court hearing about the incidents that was going on at the house. Basically, with all the shooting that was going on out there in the property.
Okay.
That's what we had they had to have a meeting or something like that.
Okay, and someone said as a result of that, you have to move, or you and Ms. Hammond decided it's just not worth the going to court?
It was, we went and they was just saying like, we can move if we want to, or, you know what I'm saying? But if anything kept going on, that we would have to move eventually.
Okay.
So at that time, we just decided just to move.
Got it. But it was a homeowners association or some kind of official organization that said you may have to move, and not these guys who were threatening you?
No, not the guys that was threatening me.
Okay,
no.
Got it. When your son got into the scuffle with the other little boy and the tooth came out. Did you learn about that at the first time when the two guys with guns showed up or before then?
No, I had learned about it before then from my son, but when I went outside to talk to the actual parents of the little boy, they were saying that he didn't stay over there. That was the cousins. So, you know, there's nothing I could really do if the parents are not there.
Got it. Okay, so but you learned about the fight or the altercation from your son?
From my son, yes.
Okay. I sort of asked this, I should ask it more clearly. Is that neighborhood one that had a homeowners association?
Yes.
Okay. Did Sam know that your house had been shot up before when he came over to help you move?
Yes.
All right. Mr. Griner, any questions for Mr. Harris based on what he and I just discussed?
No, Your Honor.
Mr. Rowe?
No, Judge.
Mr. Menendez?
No, Your Honor, thank you.
All right, Mr. Harris, I appreciate your time. You're free to go. Okay, we adjourn needs to use the restroom? So you should go.
I'm good.
Yeah. So you all can, someone who needs to use the restroom can. Let me tell you what we're gonna do. We're getting close to 5. The state's next witness, we won't finish today, but my thought is let's get in 10 or 15 minutes of this witness so that when, I think it's a she is back tomorrow morning, you've gotten into the here's who she is, what she does for a living. So we're gonna do that, but if one of you needs a very quick restroom break, we can do it. Let's just keep it quick because we're eating into the last 10, 15 minutes that we've got, okay? With that, go for it. And why don't you we'll get the next witness coming on in so that person's ready to go when our jurors come back.
So you're gonna excuse the jury for now?
Nope.
Just a few.
Just they're doing what they're doing. So if you bring the next witness in. There. We're going to formally introduce you in just a second. We have 2 jurors who are using the restroom.
My name is Brandy Parker, Brandi, last name Parker, Parker.
Ms. Parker, if you want, you have to really heave it, but you can move the chair closer so you're closer to the mic. Thank you.
Good afternoon, ma'am.
Good afternoon.
Can you tell the jury where you currently work?
Right now, I'm currently employed with the City of Atlanta Police Department with the crime scene unit.
And how long have you been in that particular line of work?
8 years.
Can you tell the jury what you do when you're called out to a particular scene?
Yes. So basically, I'm dispatched to a crime scene by 911 dispatching police officer. And when I arrive on scene, I get a walkthrough or information from the police officer on scene. And basically, I'm informed on what happened or what they think may have happened, any evidence that may be pertaining to the situation. And I go and document the crime scene from beginning to end using a camera.
So you take photographs of items that you might see.
Yes.
And have you received any particular training in looking for what might be relevant in the case?
Yes, I have.
Can you tell the jury a little bit about your training?
So I have 2 years for certification for crime scene to be deemed a professional. So that requires 7 classes. And I also have on-the-job training for 8 months to a year before being released into the field on my own.
You also, other than take photographs of particular items of evidence, do you also collect those pieces of evidence?
Yes, I do collect evidence.
And is there a particular manner or standard operating procedure that you use when you collect, say, a cartridge case?
Yes, there is a procedure.
Can you explain what you might do with the jury?
Yes, so upon finding any evidence or any shell casing, I photograph it first where I found it. Then I place a marker number, basically from beginning to end. It could start with number 1 and end at all the way to 100 if possible. And I also go and re-photograph my crime scene or my evidence once I place that marker number down and with that evidence, and I collect it by placing each shell casing in its own individual small envelope.
Do you do this work in conjunction with others or other detectives or investigators?
Yes, I work along all types of investigators.
Can you give the jury a sense of what kinds of cases you might be called out to perform your work? What kind of crimes?
We respond to all types of crime scenes. So it could be homicide investigators, a robbery investigator, SVU investigator, any type of domestic violence, anything that's a person-on-person crime, I would respond to.
Murder scenes?
Yes, murder scenes.
How many murder scenes have you gone out to maybe in the course of a year?
The course of a year.
4 months, or whatever scenes is.
A month, it could be anywhere between 5 and 15 a month, depending on the situation.
Did you get called out on this particular case back in September 13th, 2021?
Yes, I did.
And did you respond out to Notting Hill Drive in Fulton County?
Yes, I did.
Do you ever go outside the county to collect evidence?
We do, but it's rare, and it's also in conjunction with the lead investigator who is requesting us to come to a location outside of Fulton County.
Was this particular location inside Fulton County?
Yes, it was.
Can you tell the jury what occurred, how you got called, and what you saw when you got out?
I was raised on our radio by 911 dispatch and an officer. The officer will tell me what they have on the scene. I arrived on the scene, and like I said, I do a walkthrough to see what evidence may be there at the time of my arrival. And I've located several shell casings and a victim in front of a house or a townhome. And at that time, I just photographed the scene as directed and based upon what I found.
Okay, so let's take a look at State's Exhibit 1A. I'm showing this to a lot of folks today. Just ask it. Does this look familiar to you at all? I know you may have never seen it. Does this look familiar at all?
I can't say that it looks familiar because I've never seen the bird's eye view of the street.
Okay. Do you know whether or not you collected evidence from more than one location along the street on this particular evening? And we can just start with photos if that might be more helpful.
I think the photos would be more helpful.
We'll do that.
Okay.
I'm going to hand you what has been marked The hand what's been marked as State's Exhibits 24 through 56.
Okay.
And ask if you could take a look at these.
Okay.
Do those look familiar?
Yes, they do.
What are State's Exhibits 24 through 56?
So these photos are just photos of the outside of the location and the crime scene within the driveway of the location, in front of the location.
Okay, and did you take the photographs or were you there when the photographs were taken?
Yes, I took these photos.
You took these photos?
Yes, I did.
And are these true and accurate depictions of what you observed back on September 13th, 2021?
Yes, it is.
Your Honor, at this time I move to admit State's Exhibits 24 through 56.
Mr. Manetis, any objection to 24 through 56?
No objection, Your Honor.
Mr. Rowe?
No objection.
Admitted.
Okay. Let me get into it.
So, Mr. Manetis, I know we've been talking about some things outside the presence of the jury. Right now, all we're doing is admitting photos and talking about what's in the photos. Are you all right proceeding with that before we work through the thing we weren't able to finish this morning? So we're not getting into actually what was collected, but just the photographs.
Yeah, of course, Your Honor.
Okay, great. Then let's keep going for a few more minutes.
Start with State's Exhibit 24. We'll pull it up here on the screen. Do everything electronic.
Okay.
And can you tell the jury what we're looking at, State's Exhibit 24?
This is overall of the location of the crime scene.
You see a mailbox number there on one of the mailboxes?
So for this particular picture, you can see one mailbox with the address 4226. But at the time, I do not believe that was the correct address at the time. I also took a picture of a street number.
Okay. So you think the 4226 may not be the actual?
Yes, I believe it was the mailbox next to it.
Okay. All right. Did you have any question as to whether or not the residence itself was 4226? Maybe I'm not getting too complicated.
Yeah, I mean, I was not sure. I just went based off of what I was advised. Okay. So I cannot say that mailbox goes to that location.
Okay, but this is the location that you went to?
Yes, it is.
And when you got there, what did you see, just basically?
Basically, I saw a vehicle in the driveway along with a victim and several shell casings along with reddish stains.
Okay, let's go to State's Exhibit 25, please. There's a lag with.
It's fine.
And ma'am, you're welcome to use the screen in front of you. If you hit the stay muted button, that'll go away. When pictures come back up, you'll be able to see them, and you can even mark on them if that is helpful.
Okay, thank you.
Can you tell us about State's Exhibit 25, please?
So this is a better overall picture of the location along with the vehicle and the victim and reddish stains along with shell casings in the driveway.
Right. We've got the crime scene tape, looks like.
Yes, yes.
All right, is this a chain link fence over here to the left? Can you see a chain link fence?
Yes, it is.
Okay. Typically, when you're marking evidence in a situation like this, you start with the body as being a piece of evidence for one of everyone.
It's not all the time, but in this case, yes, that's where I started with the body.
That's 26, please.
Yeah, it's 12.
Different angle.
Yes, different angle.
And 27, please. And what's this?
This is an overall of a vehicle on the street.
28.
This is overall of the victim, some shell casings and reddish stain.
29.
Just a different angle, basically overall of the victim in the driveway.
When you're looking at a body, do you take pictures from different angles and distances?
Yes, I do.
Go to 30.
This is also overall of the victim in the driveway.
31.
This is a close-up of the victim's face.
32.
Close-up of the victim's right hand.
33.
Close-up of the victim's left hand.
34.
At this time, I placed down my marker numbers, starting with number 1, and I just took an overall picture to show that I added something to the scene.
Generally speaking, when you take photographs at the crime scene, you take them overall and then move in closer to?
Yes, I do.
All right. And so what we're looking at, you could just explain, you've got these little yellow tints, and then when they get closer up, just explain to the jury if you would, is there any kind of rhyme or reason behind these numbers?
So for these marker numbers, it's basically to show a series of events. I started with marker number 1 for the victim and proceeded with 2 and so on to mark the shell casings that were on the scene. And that just indicates that I will be removing these shell casings from the scene and taking them with me.
Go to 35, please. Closer up.
Yes, just a different angle.
36.
This is also just a different angle. I'm basically moving in on my pictures.
37.
A different angle for the shell casings.
38.
This is a mid-range of 2 shell casings.
So what we've got here, we say 2 shell casings. Can you just point out what we're talking about or circle it like the judge wants?
Yes, I can circle it. I'm not sure how to circle it.
So if you tap the screen once, the little circle in the lower left-hand corner with a pencil in it.
Okay.
Now you've got superpowers.
Okay, thank you. I circle number 2 and number 3.
Okay. And so shell casing, we're talking about these little metal things.
Yes.
What's the reason for collecting shell casings and cartridge casings?
We collect them to process them for fingerprints. And once we process them for fingerprints, we then submit them to our crime lab for ballistics testing.
Are there any fingerprints of value in this particular case that you're aware of?
No, not that I'm aware of.
Let's go to 39.
Oh, and you can make the things you drew go away. There's a circle with a sort of backwards arrow in it. If you tap that over on the, yep, that should make the, there you go.
Okay.
Thank you.
Thank you.
Okay, so on 39, is this the cartridge casing here, this metal?
Yes, this is a close-up of the shell casing with marker number 2.
Let's go to 40, please. And close up on 3?
Yes.
41. What are we looking at on 41?
This is a mid-range of markers and shell casings number 4 and 5.
42.
Close-up of shell casing with marker number 4.
43.
Close-up of shell casing with number 5.
4.
This is also a mid-range with markers 6, 7, and 8.
25.
This is close up of a round, a live round with marker number 6.
So we've been seeing these shell casings, and then now we've got something different.
Yes, this is different.
Can you explain the difference?
So this is a live round, which indicates for us that it has not been fired. Compared to the shell casings indicate that it's been fired already.
You collected number 6, obviously, is a piece of that.
Yes, I did.
46, is it 46 pins? What does that show?
Close up of number 7 with the shell casing.
47.
Close up of a shell casing with number 8.
48.
This is a mid-range of markers number 9, 10, and 11.
49.
This is a close-up of shell casing with number 9.
50.
Close-up of shell casing with number 10.
51.
Close-up of shell casing with number 11.
52.
This is a mid-range with majority of the marker numbers, also with 12 and 13.
53.
Mid-range of shell casing with number 12.
And 54.
Close-up of the shell casing with number 12. Yes, you did.
Yeah, we went through 56.
This is a mid-range with shell casing with number 13.
And 56.
This is a close-up of the shell casing with number 13.
Thank you. And is it important to document all this? It's kind of a painstaking work, a lot of details. But is it
Yes.
important to do this kind of thing in murder?
Yes, it's very important.
Your Honor, that's probably.
Is a very natural break point. So, Ms. Parker, I'm sorry we're having to break you across 2 days, but what I can promise you is you're first up tomorrow. You won't be behind anyone. But
Okay.
hopefully we could have you back here at 9 tomorrow morning.
Okay.
Thank you.
Thank
I appreciate it. You can leave those photos right there.
All right.
All right, ladies and gentlemen, we're going to stop for today. We're obviously not done with the trial. So as you leave here, you're going to leave your pads in the jury room. Please don't talk about the case tonight with the people who want to know how your day went. Tell them about the good food you had for lunch, how nice the jury room is, but not about what's going on here. Also, no outside research. You've done a great job of asking your questions if you've got them. Don't go online to figure out, wait, what does a crime scene technician do? Ms. Parker just told you what they do. We'll see everyone, what time tomorrow? 9. You did a great job being here on time. I need all 13 of you to be on time. Do we have the number, the phone number to call? We'll put it up there. Write that number down. That's the main number to my office. So if you are stuck tomorrow, call so we don't panic, and we'll help free you up if you're stuck. Oh, that's something different. Okay, maybe it was something for the jurors. Not a hall pass. So we'll see all of you in the morning. Any logistical questions before you go? And juror 13, you're good with, you and I had talked about whether you needed assistance in terms of the kid pickup and everything. Currently that's under control? Okay, let me know if it's not. Thank you, everyone.
All right, jurors.
Mr. Rowe, can you do me a favor? Can you come over here? Thanks. Can you grab those? I think you're gonna want that, or I'm gonna give a copy to your client. Give one to Mr. Parks, please. All right, everyone else can be seated. We are at the end of the day, even though it's 2 hours earlier than yesterday. But I want to see if briefly we can cover any of the remaining motions that are rattling around out there. I handed to Mr. Rowe, who handed to Mr. Parks, an order that ought to get him a haircut sometime in the next day or so. We'll talk with Deputy Gordon off the record about how we can make that happen. It's in the system. That doesn't help. It's getting it into the hands of folks at the jail, but Deputy Gordon can help with that. Mr. Greiner, tomorrow we'll have Ms. Parker testifying more. So I guess the physical evidence, is it here in the courtroom? So Mr. It's not.
I'm sorry, it's not in the courtroom, we have it in the DA's office downstairs.
Okay, so is Ms. Parker not the witness through whom you'd be admitting all the shell casings, for example? She is. They'll just be here in the morning.
Correct.
Okay. So if you could bring all the physical evidence in the morning, but bring it before 9, and you can work with Mr. Menendez as to what time that's going to be. And if Mr. Rowe wants to be there, of course, he's entitled to as well. Mr. Menendez just wanted to see the physical evidence before you're tendering it. I will not require you to open up envelopes that are sealed right now that have shell casings in them. Mr. Menendez is entitled to see what it says on the outside of the envelope to see if he's got chain of custody concerns. It's a tough road to hoe, but he can explore that if he wants. But certainly he needs a chance to see that. And it sounds like that just hasn't been arranged before. What I don't want to do is have the jury sitting here and Mr. Menendez say, well, I need to see that, which he's entitled to do while we're waiting with crime scene technician Parker right there. Okay?
Yes, Ron.
You've provided the defense with the redacted interview of Mr. Parks. Have you provided the defense with the redacted transcript of Mr. Phillips's immunity hearing testimony?
No, I have it right here. I'm willing for my colleague to take this with him tonight.
Okay, as he finishes up his brief that we're all anxiously awaiting.
What I've done here is I have I've even marked out page and line of the transcript, which might be pretty helpful.
Okay. Great. Anything else from the state?
Your Honor, one of our witnesses, I mentioned yesterday, has been contacted with an attempt to influence. And that witness is requesting that tomorrow that the courtroom be cleared for safety reasons, for her concern, or for his concern. And I'm going to ask the court to allow that with this particular witness. What we could do is have her, if the court wants to hear anything more, she could be available in the morning to speak to that with the court. But I'm making that request. I don't see any reason. There might be somebody in this room right now who is one of the ones behind it all. And so I take this kind of thing very seriously. My whole office takes this very seriously.
We all should. So here's what we need to do. I guess that's what we need to take up first. That doesn't mean that crime scene technician Parker won't be the first witness, but well, we could also be during a break. I don't know when this witness appears in your flow tomorrow, but we'd need to take something up outside the presence of the jury. And I'm comfortable clearing the courtroom, not necessarily for the testimony, I'll need to hear more, but for an initial exchange with this witness under oath. And you may have questions for this person. The lawyers may have questions for the defense, may have questions for the person. The focus of that won't be what's your testimony going to be. It's tell us your concern. That'll make the record that needs to be made before I could say, all right, when this person testifies, we're closing the courtroom. I'll note that the courtroom is, of course, never closed because this is being live streamed. And so for those who would say, well, I'm entitled to see and hear what's going on, indeed you are, and indeed you may. And that's how folks could see what's going on. So that's my suggestion, that we have a quick hearing with that witness outside the presence of the jury. and everyone else other than the attorneys and the defendants.
Would you prefer to take that up first thing in the morning, or would you prefer mid-morning? I know that the court, we're in the middle of a witness right now. We've got, big flow going.
It'd be better if we did it during our morning break, meaning I just can't give you that specific time, 10:30-ish, 11. We could also do it during the lunch break. I'm taking a plea during lunch, but after that plea, towards the end of your lunch break, we could have this witness. If having that witness not testify until after lunch works for you.
Okay, all right, I'll let the court know.
Okay. Got it. It's just one witness for whom you need to do this so far?
Looks that way, yes.
Okay, got it. Mr. Monetis, I have lost track of all your concerns about late discovery and this and that. I don't want to miss any of them. So I'm going to ask you to prioritize and tell me if there's one we're going to talk about right now, what should that be?
Well, Your Honor, yeah, we didn't get to finish my concerns for the motion to exclude based on the Baker case, I believe, that we discussed.
Yep.
Because there was a second piece of discovery handed over even later. That's obviously in possession of by a state agent. It's a crime scene lab type thing. The state briefly mentioned it in the morning. Basically what it is that all this time I've been operating on a report that just says, talks about groups of shell casings being put in an envelope together, but it never says, well, where's this group from and where's that group from? It doesn't say like what number, like these markers we just saw as convenient just came up, it doesn't say which group comes from where. And so all this time I've just not known. And that's why I brought up the motion to physically inspect, because all this time I've been searching for that answer. And I figured it might be on the envelopes or somehow in there, which it turns out it is, along with another report that says exactly, okay, this is 1A, this is where they were found, this is 1B, this group was found here. And now this is all, I only found out about it 2 days before trial, an especially set trial since April, that's 3 years old. And I would not want to have a continuance, but it's also not, I also can't be effective in only 2 days of trying to hire an expert. It's literally impossible. And so it was in possession of a crime lab. It does change the defense. I relied again on the state's ready announcement to tell my network that, okay, we don't need an expert because that's not part of the case. The state announced ready, even though one of their agents had it. And I think that's I hate this word bad faith, but that's the standard in Baker that I don't think is overruled, but it might be narrowed in different scenarios. I think for this scenario, it's on point. And that's just the unfairness here that's inherent, Your Honor. I relied on their September 5th announcement. And now 2 days before trial, September 16th, I'm given for the first time access to the physical evidence through picture form when I'd been asking it well outside the 10 days of trial. I'd been texting Mr. Abadi and or emailing. I understand he didn't do it on purpose. He has a lot of trials back to back to back. I'm sure the court knows. And I just never got a response to multiple emails over the course of time to look at these envelopes. All I got is pictures of them 2 days before trial with the groupings on them that now I believe, warrants an expert. I'm doing my best to just catch myself up on the ballistic science. So I can do my best with the expert the state brings, but it's just so much to it, Your Honor. The whole methodology, everything about it. All
right, I need you to stop because you're covering a whole lot of ground. First, it sounds like there were two things in your motion to exclude late discovery. One is a video that I've already said I don't find was ever in the state's possession until it was just recently, and it was immediately provided to you and Mr. Rowe. And there'll be testimony about that, but I find that is not something that I'll exclude because the state learned about it late, but not because they forgot to ask the lead detective, hey, could I have your whole case file? And that might be more along the lines of Baker. This was a private citizen who had something and who was no less available to you or Mr. Rowe or Carrie Henderson or anyone else. It's one of her neighbors. But I'm retilling old ground there. Now I'm understanding the second one. I thought there was some FBI report that you're talking about, because that's what's in your motion. There's this reference to an FBI report and DNA, and I'm really confused.
Yeah, maybe that is, a copy.
7 days prior to trial, the state furnished the defendant a copy of the DNA test results.
Oh, right.
These were in the possession of the FBI. FBI is presumably accessible to the prosecutor, and thus this tardy disclosure violated discovery. Those are your bold words in your motion that you filed.
Yeah, they were warranted in another case, and that's an oversight of mine.
You can see why I'm confused, because I haven't heard anything about the FBI.
Yes, of course, Judge. And it's a lot for me to do with that once I'm getting this stuff 2 days ahead.
Okay, so let me finish. So then the second thing that you're saying is late is photographs of what is on all of the evidence envelopes showing that 1A and 1B were from here and there. Okay, talk to me about the complicated science. You have done many trials as well, and shell casings generally eject to the right and to the rear. You've heard that testimony umpteen times. So we've got here evidence already that while shell casings may eject to the right and to the rear, firemen were running through the scene, police officers were running through the scene. We saw a guy with no shirt walking through the scene, a guy with a shirt walking through the scene. What's the complicated science for which an expert that you don't have is going to swoop in and make a big difference in the case?
Right, Your Honor. It's not that. It's actually something that was new to me, and my opinion is that it's not science, but the state is going to have this expert. And that's exactly what I would want to show is I don't expect the court to comment on it, but I think a lot of these stuff like bite mark, hair analysis, these government only non-peer reviewed things that have been debunked, I think this is one of them. What they're going to try to say is that you can look at two shell casings and say whether or not they were fired by the same gun based on these grooves that it makes. Not the, I understand the ballistics of going through the barrel of a particular gun. This is different. They're saying that the hammer of certain guns have a identifiable fingerprint to that.
Sure, I've heard that. And there you go. Is that a report that you got a photograph of 2 days ago?
Yes, and I got the photographs of the actual what there's. Well, he said he looks at it microscopically. There's no picture of that, but there's photos of each of the shell casings and said, oh, this is 1A. And there's a circle around what they say is the fingerprint of the hammer. And I will say, Judge, I've just gone online as a layperson, and NIST and a lot of other organizations do doubt that as a science.
Okay, but this isn't that we're not working through that right now. I'm confused then. What you got 2 days ago was the expert report, or it was what I'm going to call like the decoder key that helps you figure out what is 1A and where was 1A found?
That and some of the raw data, the pictures of the actual shell casings that are in the physical discovery that I was not allowed yet to this day to review.
Document for me the efforts you made to look at the state's file. Document's the wrong word. I don't want you to hand me anything, but I like you to speak slowly into the record. How many times you went to the DA's office, 3rd floor? Hi, I'm Mr. Menendez. I'm here to look at the case file in State versus Phillips.
I never did that, Your Honor.
Okay, so you didn't do that. How many times did you pick up the phone and call Mr. Abate saying, when can I come over and look at the file?
Never.
Okay, you sent emails. When can I come look at the file?
Yes, Judge.
I guess it would be like this. When can I come look at the file?
Right, Your Honor. Mr. Abate is responding to other emails of mine.
Yeah.
He's not responding to those. And I've always communicated with all the ADAs by email.
There's nothing wrong with email. I'm just wanting you to let me know the steps you took so I can see how vigorously you pursued your right. You have a right to look at these things. And it sounds like it was an email?
No, multiple, at least 3.
Okay.
I'd have to search them at Gmail, and I have a lot of emails, obviously, but I can prepare that for tomorrow morning. And I hope the state's not implying that sending an email is more or less vigorous than having to come downtown and park and go knock.
The state's not implying anything. They haven't said anything at all. I'm just asking about the steps you took. And all you should need to do is ask. And you did. I just want to make a record of what you did. You did not come downtown. You did not call. You emailed. I'm not saying emailing is insufficient. I just want to make a record.
I might have misread the court's tone. I'm sorry.
So what we need for tomorrow morning is your emails that you sent. And Mr. Griner, you can work with Mr. Abate about what responses, if any, were sent. As in, sure, you can come by on Tuesday. And if Mr. Menendez didn't come by on Tuesday, that's a him issue and not a state issue. But what I'm hearing Mr. Menendez say is that his request to look at the physical evidence went unanswered. And he is demonstrating prejudice now as to not having been able to look at what it said on the envelopes or this or that.
May I clarify something?
Sure.
Ron? I think what my colleague is talking about, there is a ballistics report authored by Jay Jarvis some months ago or a year ago. And, I think some of us are aware that Mr. Jarvis has had a number of issues that had him out of pocket and unavailable for a period of time. I spoke with him, I think last week, and we were discussing the case, and I asked him at that time, send me everything that you might have. And he emailed me some photographs. So as I understand the process, casing, he takes a picture of it, he takes a couple of pictures of it, and then of each one of these 31 items. And then he does his comparisons, and he's got handwritten notes and things.
So we're talking past each other right now. You've already started to explain that before, and I'm not questioning Mr. Jarvis's work or his expertise. I'm well aware of his extended unavailability. Mr. Menendez is claiming that on multiple occasions, he said, can I see the physical evidence? And he was never given access to the physical evidence. And if he wasn't, and there's something meaningful on it, like what was written on the evidence envelopes, that's a problem. And so what I need tomorrow morning is for you to have gathered from Mr. Abate or for Mr. Abate to be here to say, yeah, my mistake, I didn't respond to him. Or as we heard when Mr. Rowe made certain allegations about the state and offers and this and that, Mr. Abate was able to come in and say, see, take a look at this email. And I was able to sort it out the way I did. But right now I have a claim that there were multiple requests made to look at the state's file, and not your notes, but the physical evidence that went unanswered. And that's not okay, if that's what happened. So I'm not asking about what Mr. Jarvis did with his file or this or that. It's did he, Mr. Menendez, get a chance to look at things? Because if he didn't, then here he is making a good point about it, that he shouldn't be able to make because that opportunity should have been given to him.
Yes, Your Honor.
Okay. All right. That's all we're going to do today. I got to go get on a teleconference. Other than Mr. Rowe, I need to make sure you've got nothing pressing because I'm not ignoring you and Mr. Parks.
No, we just want to make sure you get accepted.
Yeah, so I don't control that. I've done what I can. We're going to